Good morning to one and all present here. Any country's ability to translate knowledge into innovation and then commercialize it will determine its future. The present trend of globalization is the foundation of the era of the knowledge based economy and society, in which knowledge is the only meaningful factor of production and other factors are secondary and can be obtained easily provided there is knowledge. Intellectual property rights, or IPR as it is called, is ideas, inventions, and creative expressions of individuals based on which exclusive rights to the inventors or creators of that property is bestowed. It is my pleasure to extend a cheerful welcome to you all. On behalf of the President of Children's Education Society and Chairman of Oxford Educational Institutions, Management, Principal, Staff, and students of the Oxford College of Engineering, I, Ms. Bhavishya, student 4th SEM from Department of Biotechnology, the Oxford College of Engineering, deem it a great pleasure and privilege in welcoming you all to the workshop on Know Your Intellectual Property Series 2 on the occasion of National IT Festival Month celebration organized from 24th to 28th July 2023 in collaboration with CSIR, Institute of Minerals and Materials Technology, IIMT Bhubaneswar, Karnataka State Council for Science and Technology, KSCST, Government of Karnataka, Bengaluru, and Vishveshwaraya Trade Promotion Center, VTPC, Industries for Trade and Commerce, Government of Karnataka. There are no words which can convey our awe and respect for late Sri Narasa Rajagaru, the founder. He formed Children's Education Society in 1974, under which the Oxford Group of Institutions established. We would like to start this event in his remembrance. We remember him forever and pray for his blessing in all our endeavors. It gives me immense pleasure in welcoming a respected President of Children's Education Society and Chairman of Oxford Educational Institutions, Sri Dr. S.N.B.L. Narasimha Raju Garu. I welcome him in his absence. On behalf of the President of Children's Education Society and Chairman of Oxford Educational Institutions, Management, Principal, Staff, and students of the Oxford College of Engineering, I extend a very warm and hearty welcome to our Chief Guest, Dr. U.T. Vijay, Executive Secretary, Karnataka State Council for Science and Technology, Bangalore, Guest of Honor, Dr. T. Pavan Kumar, Senior Scientist, CSIR, Institute of Minerals and Materials Technology, IIMT Bhubaneswar, and Srimati Pabhavati Rao, Facilitator, Intellectual Property Initiatives and Geographical Indications, Cell, Vishveshwaraya Trade Promotion Center, Government of Karnataka Center for Export Promotion, Department of Industries and Commerce, Bengaluru. I also welcome Dr. Kapil Arya and Ms. Priyanka. I would like to extend a very warm and hearty welcome to our Principal Dr. N. Kannan, a very warm welcome to Dr. Vijay Kumari, Dean Academics. I would like to extend a very cheerful welcome to our Director Dr. Ravi Kumar KM. I would also like to welcome our HOD Dr. B.K. Manjunath Sir, Department of Biotechnology. A very warm and hearty welcome to all the principals and head of the departments of various institutions. Last but not least, I would like to extend a very hearty welcome to all the participants. Once again, I wish to extend my hearty welcome to everyone who is present at this function and everyone for enabling us to organize this function.
Thank you, Bhavishya. I would request our HOD, Dr. B.K. Manjunath sir, to give us an overview of the 5-day workshop.
Thank you. A very good morning to one and all. A warm welcome to the August gathering. It gives me immense pleasure in inviting all of you for 1 week IPR session, Know Your Intellectual Property Rights, Series 2. Primary motto of this workshop is to give exposure to the audience in the domain of patentability and non-patentability, procedure for IPR filing, art of drafting the clients, and researching around the patents. We kept these four prime theme for this 5 days workshop, keeping in mind that our staff members and all the participants should know before starting their innovation what is patentable and what is not patentable. In case if they are working with non-patentable commodities, how to convert that into a patentable commodity. Keeping this in mind, we have invited a lot of resource persons across the government organization. So during these 5 days tenure, they will be exposing you to the different patentability and non-patentability commodities. And the next theme is procedure for IPR filing, because we want to self-sustain our audience for filing their innovations. So keeping that in mind, we have invited the people who will guide you. What is the procedure involved in you're putting your innovation into a patent or IPR, other kind of IPR. And the next and the most important theme that we are aimed to cover is the art of drafting the claim. So in the way of making our audience self-sustained, it is primarily important to understand how to write the claims for our innovation. So keeping that in mind, we have invited the resource persons who will uh, tell you how to, or what is the key points that has to be included while drafting your claim. And the last one is researching around the patent, because it gives a very important thing when you start researching around the patents, especially the expired patents or the abandoned patents and other kind of things. So keeping this in mind, we have requested KSCST Cell. They were very generous in supporting us in all our endeavors. Whenever we think of arranging any kind of IPR activities, they'll come forward and they'll provide the resource person and proper guidelines, and also the VTPC who stands with us for arranging any such kind of opportunity. Now we are extending our collaboration with IIMT Bhubaneswar, especially Pawan sir. I attended one of his session and I got very good information. So I thought if I invite and collaborate with this organization, our other audience also will get benefited. So with that thing in mind, I approached him and he was very generous to extend his moral and all kind of technical supports. So I thank all the collaborators for extending their supports in organizing this. And we have a dynamic principal, Dr. N. Kannan, who always stood behind us. Whenever we think of organizing such event, he wholeheartedly in support. And I thank you, our principal also, for giving us an opportunity to organize this. So I hope all the audience who are attending this workshop will gain good, fruitful knowledge in the IPR for forthcoming 5 days. Thank you, one and all, for attending this event, and thank you for giving me the opportunity.
Thank you, sir, for giving us a complete overview of the workshop. I would request our principal, Dr. N. Kannan, sir, to give the presidential address. Over to you, sir.
Thank you, Ma. That is all the resource persons, that is from various organizations, that is including Mr. UT Vijay from KSST and Dr. Pawan from CSIR and other resource persons, and our head of the department, Dr. Manjunath. Morning to all of you. So really it is the need of the hour, because now the government of India is taking up a lot of initiatives to put out even the thought process and the idea for the student to convert that into some idea to design to product. So when they want to do those things, so they have to patent it. So unless otherwise they have the awareness, so it is very difficult for them to how to go about, how to move forward for the students. So only based on this, all the innovations have to be patented immediately. So if they want to do right, so whatever it is, so the students and faculty members have to think of those angles. So in order to, that is, make their ideas and products or design everything into patent. So in that aspect only, that is part of having the IPR awareness program for 1 week. Dr. Manjunath told, Dr. Manjunath told already that, so what is the outcome of this program, what it is going to cover. That is right from how to search the patent, whether it is there or not, and how to file it, and how to make the document, and everything, what are all the different types of things are there. So for that, many resource persons from many organizations are going to give the lectures for next 1 week. So I think for the participants, so you will be having the great time next 1 week. So you'll get lot of inputs. So based on the input, you can go ahead with your innovations. As well as I would like to, that is, uh, wholeheartedly thank all the resource persons for this program, because without you, it is not going to be a successful one. As well as I would like to uh, appreciate and congratulate Dr. Manjunath for taking this much effort and bring out this workshop in a proper way, as well as the participants. I would like to thank them for attending this. So I do not take much time because all the resource persons are there in order to speak about the IPR related things. So with this, once again, I wish this program is going to be a very successful one. And thank you for the opportunity given to me. Thank you.
Thank you, sir, for enlightening us by your talk and for your constant support. Now, I would like to introduce our chief guest, Dr. UT Vijay, before he shares his insights. Dr. UT Vijay is presently serving as Executive Director of Science, Bangalore. He has served in various capacities at KSCST since 1986. He obtained his BE in Civil Engineering from Bangalore University, Master's degree in Civil Engineering from Kuempu University, and Doctorate degree in Civil Engineering from Bangalore University. His areas of interest are water-related technologies such as rainwater harvesting, traditional water harvesting systems, and watershed development, and many more. He has been associated with various projects and programs in KSCST, such as rainwater harvesting, assessment of traditional water harvesting systems in Karnataka, monitoring and evaluation of watershed development activities using geospatial technologies, Suvarna Bhumi Yojane. He has to his credit a number of national and international publications. He has presented several papers and delivered talks and chairing in various international and national seminars and training programs. He is a member of several expert committees of various academic, R&D organizations and government departments of GOK and GOI. I would request our chief guest, Dr. UT Vijay sir, to enlighten us with your talk. Over to you, sir.
Yeah, thank you, Bhavishya. Good morning to all of you. Am I audible?
Yes, sir, you're audible, sir.
Yeah. Okay. So, respected dignitaries participate in this online program and know your IPR. 5 days, almost 5 to 6 days program organized by Oxford College of Engineering in association with many institutions like KCST, IMMT, and VTPC and other collaborating agencies. I thank and congratulate the management, principal, HOD, Dr. Manjunath, faculty members, and research scholars and student community of Oxford College of Engineering in taking pain in organizing this week-long program on very important topic on IPR, know your IPR, in collaboration with many organizations, including KCST and VTPC and IMT and so on. Respected principal, Dr. Manjunath, Dr. Pavan from IMMT, various faculty members, HODs, Dean, and student community of Oxford College of Engineering. As we all know that IPR is very important item in our invention life, as it protects our innovative ideas, invention ideas for the benefit of society. Coming to our organization, KCST, Karnataka State Council for Science and Technology, which was established in 1975 with the intention of taking whatever R&D taking place, research and development and innovations taking place in R&D organizations like IISc and other R&D institutions to the land, taking R&D from lab to land. With this intention, it was established by then Director of IISc, Professor Satish Dhawan and Professor Amulya Kumar in Reddy, A.K. Reddy from IISc. It was one of the first council on science and technology to be set up in the country in addressing the local specific problems of the state using various science, technology, and innovative ideas in addressing the problems of the state, apart from supporting technically the various departments of Karnataka state for the benefit of the society, both in terms of urban as well as rural areas of the state. Since inception of our organization for the past 48 years, KSST has been carrying out lot of SNT activities, that too in the area of water, energy, education, environment, agriculture, health, geo-ICT, IPR, and including various outreach programs, science population program. Coming to water, KSST has been supporting various government organizations to go for rainwater harvesting. It has been supporting all government and private organizations who have come forward to have rainwater harvesting by giving them technical support in the form of detailed project report involving assessment, designing, estimation, and providing drawings with the of various components of rainwater harvesting. End-to-end solution KCT has been providing for the installation of rainwater harvesting in any government or even private organizations, including domestic houses in Bangalore and other parts of the state. Then also under water sector, KCST has taken up scientific study of traditional water harvesting systems, which were constructed by our ancestors, our elders, our kings, such as Kalyani, Kunte, Gokatte, Katte, Kere, and so on. These traditional water architectures were constructed using traditional knowledge, using locally available materials, which were meant for various good uses, starting from domestic use to irrigation, including religious purpose. So such 14,000 to 50,000 structures have been inspected, assessed scientifically, and prepared scientific measures for rejuvenation in the form of technical reports and scientific reports, which have been submitted to various line departments, including district administration, Jilla Panchayats of respective districts of the state. Then under education sector, KSST has been running a very important flagship program called Student Project Program. Many engineering colleges of the state has been getting benefit from this novel program of council, which was initiated by KCST in the year 1978, first of its kind in the country. So far, under student project program, KCST has been supported more than 16,000 student project program, out of which around 1,000 project programs have been commercialized, have been marketed for the benefit of the society. This year also, we have received around 6,000 proposals under SPP student project program from around 200 engineering colleges from the state, as well as more than 50 universities and academic institutions in the science background. Around 1,496 projects have been sponsored by KCST, out of which 443 projects have been selected for annual seminar cum exhibition, which is going to be held on 11th and 12th of August in Alva's Institution of Engineering and Technology, Mudibidire. So I also congratulate the students of Oxford College of Engineering or any institutions who have participated in this online program for your innovative ideas in the form of student project program. On behalf of KCST, I would like to congratulate the students as well as the faculty members behind these projects. Then coming to energy sector, we have also have end-to-end solution for various energy programs starting from solar, wind, biomass, biogas, biofuel, and so on. Even solar rooftop lighting, we also offer to provide end-to-end solution for to go for rooftop solar rooftop lighting also. Then under Geo ICT, we have called one program called Natural Resources Data Management System (NRDMS), in which we are creating village-wise database for the benefit of the line departments of the district and research scholars and even researchers and academicians to take up R&D programs in the rural sector as well as the urban sector, wherein we provide analyzed information using geographic information system, GPS and remote sensing in the form of spatial and non-spatial data base as part of our NRDMS program, which in which we have established around 31 district NRDMS centers all over the state. Then under GeoICT, we have one more program called 3D laser scanning of various archaeological sites and various heritage monuments to create 3D models and 3D mesh models as well as 3D point cloud data to be used for future reconstruction and restoration of the monuments in order to preserve our heritage, history, and culture of the state. Then coming to very importantly, IPR, intellectual property rights, we have established with the support of Government of India, DST, CPM, and TIFAC, PAC for the past more than 15 years. Through this PAC, almost 65 IP cells in collaboration with KCST, 65 IP cells have been established in our state for the benefit of researchers, academicians, research scholars, startups, including student community, in order to protect their innovative ideas. Friends, as you know, April 26th has been celebrated as World Intellectual Property Rights Day, IPR Day, World IPR Day on April 26th. This year, UNO has dedicated 2023 towards women community, women and IPR. Lot of women community have participated in this program. I congratulate all women community to utilize the facilities available in the government and non-government sector in the form of various infrastructure facilities. Please think, innovate, invent something for the benefit of our society, for the benefit of our common people, including our farmers. So through these 65 IPR cells, KCST has supported technically, morally, for filing of more than 700 patent filings in our state. And also we offer technical support as well as moral support and admission support to all engineering colleges, academic institutions, universities to go for more and more active IP cells, not only established IPR cells. Please make it active, try to do some programs, activities, try to invent something for the benefit of the society. Then coming to the position of our India, Global Innovation Index, still India is in 40th position. Fortunately, for the past 5 years, we have climbed from 82nd position to at least 40th position. But with the support from all of us, support from all academic and R&D institutions across our state or our country, we should take our great country to the top 10 position. So let us all work together. Let us all think for the benefit of our society, invent something and do filing of patents, trademarks, licenses, designs, whatever comes to our mind for the benefit of our society, for the benefit of our organizations also. With this background, I once again thank and congratulate the management, principal and faculty of Oxford College of Engineering in organizing such a wonderful week-long program on IPR. I wish all the best to the program. I wish all the best to our research scholars and resource persons for wonderful interaction with the participants who will be there for this week-long program. Thank you one and all. Thank you very much.
Thank you, sir, for your expertise talk and for sharing your views on IPR and other programs held at KSCST. Thank you, sir.
Thank you.
Now,
Thank you.
Now, I would like to call upon Ms. Bhavishya to introduce our guest of honor, Dr. T. Pavan Kumar.
Dr. T. Pavan Kumar, currently working as Senior Scientist in Department of R&D Planning and Business Development at CSIR, Institute of Minerals and Materials Technology, Bhubaneswar, India. He obtained his BSc Chemistry in 2002 with College First and MSc Organic Chemistry in 2004 from Osmania University, Hyderabad, and secured University First with 4 gold medals. He pursued his PhD work in chemistry at CSIR IICT as CSIR JRF SRF and received PhD degree from Osmania University, Hyderabad in 2011. He holds PhD PL Patents Law from NAL SAR Hyderabad and several certifications from WIPO. His research interests include organic chemistry, asymmetric synthesis, process chemistry, green chemistry, etc. He has vast experience in intellectual property and has about 18 patents to his credit. Present research work is focused on small molecule chemistry with biology interface, and his core functioning is in the area of intellectual property and technology management and business development. I request you, sir, to give us a keynote address.
So,
Over to you, sir.
yes. So, thank you very much. Thank you for your detailed introduction. So, I'm very happy to be part of this wonderful event. First of all, I appreciate the efforts taken by Oxford College of Engineering and the team led by principal and more specifically Dr. Manjunath and also Dr. Salma in organizing the entire program. I have seen the entire design of the sessions. I think this is a unique kind of program that has been designed for the benefit of all the participants. All would definitely get a new learning experience, and also you'll find great experience in terms of intellectual property rights. And with this, I think without taking much of the time, I'll just start and convey my greetings to all the participants as well as the organizing team, and also my respects to Dr. Vijay, Executive Secretary, Karnataka State Council.
It is an honor to have an opportunity to express my appreciation to all the dignitaries present here. I am grateful to the esteemed delegates of the workshop for their presence and the effort in making this event a success. I extend my sincere thanks to our honored chief guest, Dr. U.T. Vijay, and guest of honor, Dr. T. Pavan Kumar sir, for taking time from their busy schedule to grace the occasion and enlighten all of us with the innovative ideas on Know Your Intellectual Property. Your words of inspiration and encouragement on this special day are greatly appreciated.
Thank you.
I also thank Dr. Nagarjuna from KSCST for his constant effort in organizing this event. A special thanks goes to Dr. N. Kannan, Principal of the Oxford College of Engineering, for his unwavering support in making this workshop a success. My gratitude also goes to Dr. Manjunath BK, Head of Biotechnology Department, for his effort in organizing this event. I must also acknowledge the organizing team and the volunteers for their hard work in the lead up to this workshop. I extend my deep sense of appreciation to all the faculties, students, and workshop participants for their active involvement. Thank you once again for everyone for making this event a great success. Thank you.
Thank you, ma'am. Now, officially, we'll be closing the inaugural session and we'll be starting with the first session for today, which will be taken over by Dr. Kapil Arya on patentability criteria. Now, I would like to call upon Ms. Bhavisha to introduce our speaker for session 1, Dr. Kapil Arya.
Dr. Kapil Arya, Senior Scientist in Innovation Protection Unit, Council of Scientific and Industrial Research, New Delhi, PhD and postdoctoral fellow in chemistry, and PG diploma in intellectual property right management. He has more than 15 years experience in field of chemistry, intellectual property right management. He has drafted, prepared, a legal document of labs, 100 foreign patent application review, and he has prepared final documents of office examination reports of patent applications in the field of chemical sciences and submitted to various foreign patent office. He has reviewed 300 Indian Patent Office examination reports and new patent applications in the field of chemical sciences, biochemistry, and material chemistry. Prepared response, drafted the patent application and hearing notice response, and submitted to Indian Patent Office, Delhi. He has filed 50 copyrights, 40 number of trademarks, 20 designs, 01 GI filing. On behalf of principal staff and student of Department of Biotechnology, I extend you a very warm welcome, sir. You can take over the session now.
Yeah,
I request
good
you to
morning,
take
all.
over the session now, sir.
Yeah, good morning to all of you. Thank you for your introduction, and I hope so. My slide is visible to all of you. Yeah, it is a visible, ma'am. My slide is visible. Slide is visible.
Yes, sir.
Okay, thank you. Yeah, yeah. As we know, the intellectual property is the creation of mind, and it is term of the scientific inventions, literary drama, artistics, all are come under to the category of the intellectual property, because the literary, scientific inventions, artistics, all these things come under to a creation of our minds. And the intellectual property rights is a certain exclusive rights to given the inventor or the creator of that property, so that they can enable them to reap commercial benefit for their creativity efforts, or for reputation purpose also. And there is a several type of the intellectual property, like the patent, copyright, trademark. We give the brief on that one. So patent is applicable for the novel inventions having the inventive steps and the industrial applicability also. Trademark is for business name, slogan, labels, packaging, numerals, words, etc. And copyright for the literary activity, artistic activity, website, software, books, and sound production or a film, etc. Geographical indications is also one type of the intellectual property for specific product with a specific reputation in specific regions. So the intellectual property, like the patent, trademark, industrial designs, copyright, GI, also have several maximum protections and governed by the particular acts and rule. Like the patent is a maximum protection having the 20 years, and we have to renew every year for enforcement of the patent. And it is governed by the Patent Act 1970, which is amended in 2005. Same the trademark having the lifelong protections, and we have to renew after 10 years, 10 to 10 plus plus plus. And the trademark is governed by the Trademark Act 1999, and which is amendment in 2010. Same the design is having the maximum protection is 15 years, and after 10 year we have to renew for the next 5 year only. And it is governed by the Design Act 2000 and Design Amendment Rule 2014. Same, the copyright have lifelong protection and in or 60-year protection in case of the deceased person, and the renewal is not required in case of the trademark and is governed by the 1957 Copyright Act, which is amended in 2012. Same, the GI have also lifelong protection, and after 10 years we have to renew the same, and it is governed by the GI Act 1999. Same, it is now we come under to the category of the patent. So what is the patent? Patent is the exclusive rights granted for the any invention to inventor for their scientific inventions, which can be product or a process, or which can be both product and the process, or in general way we can say it is a new way of doing something, or offer a new technical solution of the existing problem, or this is the patent is the technical information about the inventions, and the must be disclosed in public into our patent applications. So the patent is governed by the several laws and regulations. Firstly, in 1970, Patent Act come under existence, and which is amended in 1999, 2002, 2005, and Patent Rule come under existence in 2003, which is amended in 2005, 6, 16, 19, 20. 21, and from 1995 Patent Act amendment, the pharmaceuticals and agrochemical product come under in our act, and the exclusive marketing rights is included in our Patent Act. From the 2000 amendment, the patent term increased from 40 to 20 years, and the invention definition inclusion of the inventive step included in our Patent Act, and the reversal of the burden of proof on infringer is also included, and the mandatory compulsory license provision for food, drugs, and chemical removed from our Patent Act 1970, and the right of patentee importance also included. In 2025, pharmaceuticals is included. Before 2005, only process patent granted in India, but after 2005, the product patent also granted is a subject matter for granting. So both the product and process patent can be obtained right now after 2005. So in the patent law, in case of the safeguard, through the patent law, we can protection our product or a process or both product by process, and it is having the term 20 years, and examination on request is possible. Sometimes what happens that when we file our patent application, the inventor assumes that it is automatically examined by the patent office, but it is not happen. We have to file the request for examination to the patent office for in a particular form with a particular requisiting fees. Otherwise, our patent application is a automatic process. We have to give the request to the patent office. The pre-grant and the post-grant position is also possible in the patent law. When we file our patent application, and after 18 months of the expiry of the filing the patent application, it is undergoing the public domains. As soon as it is undergoing the public domain or published by the patent office, it is a subject matter of the pre-grant oppositions. Anyone can file the pre-grant opposition under section 25. Same the post-grant oppositions also we can do after granting the patent application, and after granting the patent application within the timeline limit of the 1 year, anybody can file the post-grant opposition under section 25, rule 55 to 62. Same in our patent law, the provision for the protection of biodiversity and the traditional knowledge also included, and the publication of application is after 18 months with the facility of early publication is also there. If the inventor wish to publish their patent application early, so we have to give the request to the patent office in form of Form 9 with the requisiting fees for early publications. And the compulsory license to ensure the availability of the drugs and at reasonable prices is also included in our patent law. And the provision for deal with the public health emergency is also included in our patent law. And same the revocation of the patent in public interest or also on the security consideration is also considered under section 99. So all these are come under to our patent law. So now the question is the patentability. What is the patentability? What is the criteria of filing the patent application or a patentability? So first one term come under in existence, inventions. What is the inventions? And according to the section 21J, the invention means new products or a process involving a inventive steps or having the or a capable of the industrial applicable capability. Inventive step means they give the invention give the better solution or a technical problem with the existing one. If the any solution come under existing in natures, how we give the betterment to that technical solution. So after, when we include the some betterment process or we design some new products, so it is a subject matter of the patentability or a inventions. So the invention and discovery both are two different things. Because in discovery, as we know, the detailed description of the thing that existing is natures, and in discovery, the further extension of human understanding only. Same with the example, the penicillium notatum. This is a discovery because we extend our human understanding for the discovery of this one. But the synthesis of penicillin in laboratory each inventions. So what type of the reactant we have used, what type of the reaction condition, what type of the reagent we have to use for the synthesis of penicillin in our laboratory, this is the invention. Because the in the synthesis of the penicillin in our laboratory, we there is a several way to solving the existing problem by technical means. How we synthesize the penicillin in our laboratory, there is a lot of problems. What type of the reactant we have to use, what type of the reaction condition we have to use, what type of the reagent we have to use. So all these are the problem by the solve with by the technical means. So this is the invention. So the invention is the further extension of the human potential, means human creativity, because in all these things the human minds will be there. So when we solve the problem and then when we solve the existing problem by technical means, our human minds give the or we can say the intellectuality is also included in that one. So in invention, it is a further extension of the human potential. So in patentable subject matter, there is a three major criteria for any inventions. The first criteria is novel. Your product or a process or both product and process should be novel. Second one is the inventive steps. In your inventions, inventive steps should be there. Third one is the having the industrial applicable applications not fall under the section 3 and section 4. So now we consider the novelty. So novelty is that the invention must not be published in India or elsewhere. When you file your patent application, you should keep in our mind, or you search through particular database. That is a freely available database is also there in Indian Patent Office site, European Patent Office site, same as the USPTO sites, or in a Google also give the facility for the freely available database through which you can search that is your invention is already published in India or elsewhere or not. So if this is the major criteria when you work on the any inventions or on any laboratory practice, you should first do the prior art search. Through the prior art search, you can find out that your invention or your discovery is already published in India or elsewhere or not, in prior public knowledge or prior public use within India or not, or either your inventions is claimed before in any specification in India or not. These three criteria should be decide your novelty, that your invention is novel or not. In the state of art, we can say that everything made available to the public by means of oral descriptions or written descriptions or by use way, so or in other ways. So before filing the application, before filing the date of applications. So when you do the novelty search or a prior publication or prior claiming search under section 30, the examiner of the Indian Patent Office examine your patent application based on two things. First is the prior patent publication in India or prior claiming in India. As soon as you file your patent application, the patent examiner examine your patent application under section 13 to anticipation by previous publication or by prior claim. The prior publication means the examiner to whom an application for patent is referred under section 12 when we file the request for examination and make the investigation to purpose for whether your invention is novel or not. So either your publication before the date of filing of the applicant complete specification in any specification filed in pursuance of the application made in India or date or after first day of January 1912. So if your application is when you file your patent application and any subject matter is already published or by the any person before your filing date, you lose your novelty and it is not a subject matter of granting your patent application. Second one is the prior claiming. In the prior claiming, when the invention is claimed in complete specification. For example, if your complete specification is A filed in India has already been claimed in the complete specification B, but the complete specification B is not filed in is already of your application A, but it is not yet published, or we can say it is published after you are filing the A. But in that case, the relevant claim of B will anticipate the claim of A by prior claims, or we can say because the application B is yet not published by the patent office, but it is a earlier filed from your patent applications, so it is the subject matter of prior claiming in India. So anyone can file the pre-grant opposition. In pre-grant oppositions, the examiners identify that your patent applications is your patent application is filed after the someone else filed your file the complete specification on the same subject matter. So this is a case of the prior claiming. So on the basis of two things, the patent examiner examine your novelty of the inventions, either prior publications or a prior claiming in India. Second one, the examiner also make a investigation to purpose whether your invention is a prior patent or non-patent publication in anywhere, either US or in the world is there or not. If there is a prior patent or a non-patent publication anywhere in India, it gives the lose your novelty. We should keep in our minds that your patent application or your subject matter or your complete specifications anticipated by the publication in India or elsewhere in any documents other than those of mentioning before the date of filing of applicant complete specifications. So but there is just some exceptions also from the anticipations. You never lose your novelty. Exceptions will be there under section 29 to 34. In under section 29, exception from the anticipation by previous publication is if your Indian patent application before first day of January 1912 and the matter obtained from the true and first inventor and published without his consent, you can exempt it. Under section 30 is the exception from the anticipation by communication to the government for the investigation. If you communicate to the government for investigations of any subject matter, you never lose your novelty of the subject matter. Exception from the anticipation by public display. If you display your invention in public, you may lose your novelty. But if you display your invention in exhibition with government notification, in that case, you never lose your novelty. If the publication or use of invention is consequence to display, you never lose your novelty. Novelty should be there. Novelty still there. If the paper read by the true and first inventor before a learned society or a published in its transitions, then you have novelty, but you have a 1 year grace period. Within the 1 year grace period, you can file your patent application. If the inventor publish their articles in any journals or a learned society journals, there is a 1 year grace period. Within the timeline of the 1 year, he can eligible to file the patent application. After 1 year, it is not a subject matter of filing because they lose their novelty. Under Section 32, the exception from anticipation by public working also. If your patent applications is a subject matter of the public working, you give the exception. If exceptions under Section 33 from the anticipation by use or a publication after provisional specifications, means as moment as you file your provisional applications, you are eligible to publish your article in any journals. So exception from the anticipation by use or a publication after provisional specification. So as soon as you have an idea, and your idea can be converted into the product, in that phase first you file your provisional applications. In provisional specification there is a no claim, so within the timeline of the 12 month you have to file complete after provisional specification, but your rights will start from the filing of the provisional specification. So first, when the idea is stick in your minds, immediately you file the provisional specification with having the title in or abstract of inventions, or a summary of your invention, or a objective of your invention, or only having the one or two examples. And after that, within the timeline limit of the 12 months, you just complete your invention by means of the working examples, best examples, or a claim, etc. In Section 34, the exception from the anticipation if circumstances are only as described in Section 29, about 30, 31, 32, and 33 also. So in the novelty determinations, when we comparison a claimed invention with the prior art, what is the existing art and what is your invention? Whether there is a difference between the claimed inventions is novel or not. This is the evaluate the element of the claim inventions and assess the each and every step of the claimed inventions or novelty of each claim is required to be judged independently. For example, in the claim 1 showing the composition of claim A and claim B, composition of compound A and B, but the claim 2 says the composition of claim A further comprising C. In that case, a prior art document when disclosing the composition of A and B can anticipate claim 1 but not claim 2, because the claim 1 is already having in the prior art, but the claim 2, the composition of claim 1 further comprising C is the novel thing. So the a prior art compound documents disclosing the compound A and B can anticipate the claim 1 but not claim 2. So evaluate the elements of the claim invention independently. Novelty of the each claim is required to be judged independently. In the novelty determinations, for an examples, the claim invention relate to the composition of enhancing the corneal healing, said the composition comprising vitamin A and sterile buffer administered to the eye. Same the prior art disclosed the use of eye drop to reveal the contact lens, wherein the said eye drops comprising vitamin A and sterile buffer and other experiments. So in that case, our claim is lack the novelty because it is anticipated by the our said prior art, because the both our prior art and our claim inventions is talking about the eye drops, or it contain the vitamin A and the sterile buffer and the administrator like the other experiments. So we lose our novelty. So in that case, the claim subject matter lacks the novelty. Same the implicit disclosure, since we can see the prior art is read through the eye of the person skilled in art. So the lack of novelty must be implicated in the sense in carrying out the teaching of the prior art, the skilled person would eventually arrive at the result filing within the terms of the claim. So there is two things. One is the person skilled in art and ordinary person skilled in art. There is two things. Ordinary person skilled in art means the ordinary person or layman can be do the same achievement on based of your prior art. But the skilled person art means for example, if I am claiming the any chemical synthesis or a chemical process, so the skilled person means the only scientist who is working or having the skill is having the skill would be inventively arrived at the results. So we can say the ordinary skill, in that case the ordinary skill person is not applicable, but the skilled person which having the expertise in that area would inventively arrive at the result falling within the term of the claim. inherent anticipation means the prior art reference may anticipate without disclosing a feature of claimed inventions. For example, the elastic property of rubber are relied upon the documents that does not explicitly state the rubber is the elastic material. Or in our claim, the elastic material is anticipated because the rubber taught in the prior art inherently as a elastic material. So this is inherent anticipation. Determination otherwise is the product by process, like the product themselves fulfill the requirement for novelty and inventive step, and same the process should be themselves fulfilling the requirement for novelty or inventive steps. Same the product by process claim in general interpreted in a absolute sense or a independent the process. For example, the compound C obtained by the process X, same the in the prior art D1 T is the same compound C with the same characteristics. However, D1 the compound C was prepared by the process Y. So the compound C in the prior art is synthesized by process Y, but in our we claim the compound C obtained by the process X. So in that case, product is not novel because the product is same. The product compound C is the same, but the process is different. In the prior art, tell us the process Y. In our inventions, we claim the compound C obtained by the process X. So these are process is different. In that case, the compound C is already identified in the D1, so it's like the novelty, despite the fact it is prepared by the different matter. So the claim subject matter like the novelty. So in other sense, in the combining documents, the not permissible to the combining separate item of the prior art together. However, if we the primary documents or the closest prior art refer to the second or a second document, the teaching of the second document may be regarded as incorporated into the primary document. For in examples, the prior art document D1 tell us only the product, and same the prior art document D2 tell us the process. So when we combine the both document D1 and D2, so both document D1 and D2 tell us the product and the process of that compounds. And if we claim that process, so we the prior art D1 and D2 both combining, when we combine the or any skilled person in the art and combining both the prior art, he can eligible to synthesis all this one. So he lose their novelty in their invention. For an example, the claimed invention is metal, and the prior art disclose the copper defeat the novelty of metal as a generic concept, but not the novelty of any metal other than copper. So if the prior art disclose a genus, it does not always anticipate a claim to specific filing within the genus if not explicitly the mention. Same the example, the titanium alloy with zero point 0.6 to zero point 0.7 nickel and 0.2 to 0.4% molybdenum. And in the prior art, it says that titanium alloy containing nickel and molybdenum. So both are same things. So the claim subject matter lacks the novelty. Second thing is that the major patentability criteria is the inventiveness. Inventiveness means the technical advancement as compared to the existing knowledge, or it can be a economic significance, or both. It can be or it's make the invention not obvious to the person who is just skilled in art, not a ordinary skill in art or ordinary person skill art, but the person skill in art. There is two different things. And third category criteria is the industrial applicable. Your invention should be capable, is made or used in any kind of the industry. So when we work on the inventive steps, so there is a different law. In according to Indian patent law, the inventive step means the involve any technical advancement compared to the existing knowledge. Same the European patent law, the invention shall be considered as involving a inventive step if having a regard to the state of art, it is non-obvious to the person skilled in art, and if the state of the art also include the documents within the meaning of Article 54, these documents shall not be considered in deciding whether there has been an inventive step or not. The problem-solving approach is used to determine the obviousness of the invention. But in the US law, the patent for claimed invention may not be obtained if the difference between your claimed inventions and the prior art are such that the claimed invention would have been obvious before the effective filing date of the claimed inventions, or a person having the ordinary skill in art to which the claimed invention pertains. So in the person skilled in art, who is the person skilled in art? The person skilled in art is a fictional person without inventive skills, not an expert. It can be a skilled practitioner in that relevant field. It is aware of what is the common general knowledge in the particular technical field at relevant date and access to everything in the state of art. It can be involved in consent development in his field or is expected to the look for the suggestion in neighboring or a general technical field of each remote technical fields, or maybe some field by the team rather than the individual persons. So, in the inventory step, we consider that technical advancement, economic significance, or it should be not obvious. So, the method to the objectively analyze the inventory step is that identify the inventive concept, identify the person skilled in art, identify the relevant common general knowledge of the person skilled in art, and or we can say the identify the different difference existing between the matter cited by cited in the earlier prior arts, or weaving without any knowledge of allied inventions as claimed, or do those difference consequent the steps which would have been obvious to the other person who is just skilled in art. So if there is a certain to the improve effect in your descriptions or a evidence for the achieved improvement compared to the closest prior art, then technical problem underlying the invention is for product claim to provide a compounds or a composition with betterment to the existing one, for process claim to provide a better process to the existing one, or we can say the closest prior art. Your process claims having the better process compared to the closest prior art, or in the product claim your claim product is provided a compound and composition which having the different from the closest prior art. If there is no evidence of any improvement in the application as filed with respect to the closest prior art or earlier prior art, the problem underlying the invention could be for compound claim, the provide the alternate compound for the use of disclosed invention in the closest prior art, and for the process to provide a further process for the preparation of product X as disclosed in closest prior art. So in the example, we can see the compound represented by this is a formula. This is the pyridine, and this in the pyrazole. The pyrazole stands for the specific pyrazole. This is the skeleton, and B stand for the ethyl group. Ethyl group, which ethyl group is in the 3 position, 4th position, and 5th position. And the compound of the invention possesses the analgesic property. Same the prior art say the closest prior art describes same the pyrazoles where the B stand for the methyl. In our synthesis, in our claim, we claim the same pyrazole skeleton, but on the position of 3, 4, 5 in closest prior art there is a methyl group, but in our case there is a ethyl group. The prior art doesn't tell us the any therapeutic activity, but in our claim inventions we claim that the compound of the invention possesses the analgesic property. So our claim we just slightly modified and we just replaced the methyl group with the ethyl group. So replacing the methyl group with the ethyl group, including the better activity, therapeutic activity or analgesic property will come in our compounds. So it is a subject matter of patentability because the inventive step will also come. So the identify the inventive concept embodiment in the present. The inventive concept is the pyrazole. B stand for the ethyl, where the compound possesses the analgesic property. So the person of the ordinary skill having the ordinary creativity, which is a common in general knowledge. So it can be replaced the methyl to ethyl, but the skilled person in this case is a chemist and maybe composite team of the organic chemist or a pharmacologist. He understands that when we replace the ethyl group with the methyl group replaced by the ethyl group, this having the some type of the biological activity. For example, for other things, I'm saying that if I replace the methyl group, because I am a skilled person or I am a chemist or having the good knowledge of the organic chemistry, when I replace the CH3 with the fluorine compound, or when I replace the methyl group with the CF3, so or I just include this pyrazole moiety in the sulfur group, so automatically the activity come under arise. So the person who is a skilled in art, having the better knowledge of the chemistry, he can just replace the methyl to ethyl, or a methyl to methyl to any halogen group, or a fluorine group, or a thio group. So the property, biological property will also come out. So you lose your inventive steps. So in this case, the skilled person thorough knowledge of the state of art related to the organic chemistry of the pyrazole, or also through the knowledge of the state of arts of the, or a class of the compound having the analgesic activity, the knowledge must be the date of the priority of the patent application in question, and not later that of. So when we difference between the prior art and our invention, that is there the replacement of 3-methyl substituted at annular position, and the pharmaceutical activity of the resultant compound will be there. So the invention is therefore non-obvious. Same in this case, the claim invention is merely selecting a subgenus species of the broad genus. For example, this is the R. R is the a compound of the formula. Same is the pyrazole R for treatment of disease X. Same the R dash is the, there is a group R dash is a selected from the ethyl, methyl, propyl, butyl, this. But when the there in, but in the prior art, where R is only H, but in our claim invention, the R is the methyl, ethyl, propyl, butyl there. So this is also a subject matter of non-obviousness, and inventive step will be there. But the prior art provides to modify to select any well-known member of broadly defined R. Not a R is ethyl, methyl, propyl, but it should be a very pinpoint there. So to provide a motivation to one skill in art to arrive at a claim inventions, and the claim compound not describing or having or not showing possess any advantage property to possess by the prior art example. So efficacy should be increased. If their efficacy should be increased with the existing prior art, in that case only our step or our process having the inventive step. If efficacy is not increased, or any biological activity will not come under to in our compound or in a skeleton, in that case the invention is obvious and having lose the inventiveness. Same the third one is the industrial applicability. Your invention is capable of being made or used in an in industry. For example, the synthetic analogs of steroids without any effects. The steroids possess the certain medicinal property. However, the compound of the inventions as asserted are subject of the serious investigations, being the analog of the compound known for the medicinal property. So the claim compound are not patentable as they lack any credible or a specific utility. Medicinal property is a very broad thing. So you have to give the pinpoint. Either it is an anti-cancer, it is anti-tuberculosis, or antibacterial. So your compound should have particular things should be there, or a specific utility. So or a mere scientific interest does not make something eligible for your patentability, because the medicinal property is very broad manner. So you give a specific utility of your compounds in your inventions. So some invention is also a patent subject matter section 3 excluding the section 3 and section 4, and section 3 have the subsections like the section 3a. The frivolous inventions or invention contrary to the well-established natural law is not a subject matter of patentability. For example, the machine that give the more than 100% performance, it is not possible. So it is not a subject matter of patentability. Same the perpetual machine is also not a subject matter of patentability. Same the section 3b tell the commercial exploitation or a primary use of invention, which is the contrary to the public model or a morality. The gambling machine also not a subject matter of patentability. The device for housebreaking is also not a subject matter of patentability, because it is against the public model or a morality. And the same the section 3b, the cause serious the prejudice to the health, human, plant life, or to the environment, like the biological war weapons, or a biological warfare materials, or a terminator gene technology, or a embryonic stem cell technology. All these are not a subject matter of patentability under section 3b. Same in the genetically modified organism, like the exploitation of which could be a contrary public order, or a morality, or a prejudicial to the human, animals, or a plant life, or a health to the or environment, is not a subject matter of patentability. But the genetically modified microorganism which do not fall under section 3b are a subject matter of patentability. In under section 3c, the mere discovery of the scientific principle, or a formulation, or a abstract theory, or a discovery of non-living substance occurring in nature is not a subject matter of patentability, like the Newton law, superconductivity phenomena, or discovery of microorganism, or discovery of natural gas, or a minerals is not a subject matter of patentability under section 3c. Say like the naturally occurring microorganism, but the genetically modified microorganism are however patentable subject matter, because in genetically modified microorganism the human creativity is inserted. So in that case the natural occurring microorganism not a subject matter of patentability, but the genetically modified microorganism is a subject matter of patentability. Same the section 3d. Section 3d means the mere discovery of new form to known substance which does not result in the enhancement or a known efficacy of that one. For example, when we synthesize any salt, or a ester, or a ether, or a polymorph, or when we synthesize some metabolites, or a pure form, or a particle size. For example, in prior art there is a 10 nanometer particle size, but we have synthesized 3 nanometer particle size. So this is only mere discovery. But when we compare the prior art with the existing when we compare the claimed inventions with respect to the prior art, our when we decrease the particle size 10 nanometer to 3 nanometer, and when the decreasing 10 to 3, your efficacy of the particles is increased. In that case only your subject matter is for the patentability. Otherwise the reduction of the size not only a subject matter of patentability. You have to show the efficacy when you reduce the 10 to 3 nanometer particles, and your efficacy is increased of your particle size. So in that case it is a subject matter of patentability. Same the complex combinations or other derivative of known substance which having the no efficacy, so it is not subject matter of patentability. But there is a significant in property with regard of efficacy. In that case only this is the subject matter of patentability. In for examples, the new use of aspirin for heart elements, and the new use of neems is also a subject matter of patentability. So the mere discovery of any new property, or any new use for known substance, or a mere use of known process, machine, or a apparatus, unless the such process result in a new products, or a employ at least one reactant. For example, in laboratory or in a prior art synthesis, the inventor just use the reactant A and B convert into C. Okay, but in our claim inventions we synthesize the C with the help of reactant A and D, and synthesize C, because we replace the reactant B with D. In that case our invention is a subject matter of patentability, or it is not come under to the preview of section 3d, because we use the one new reactant in our claim inventions. So your invention should be a new products, or a employ at least one new reactants, like for example A plus B in C, or you can use A plus B plus D is converted into C. In that case there is in prior art there is a two reactant, but in your case there is a three reactants. And in insertions of the three reactants, you give the product in higher yield, For example, in prior art, they have reported only 20% yield. In your case, you reported 40% yield, so, or a 60% yield. In that case, the efficacy is increased in your process. Or when we reduce the temperature in prior art, they use the temperature 100 degrees centigrade, and in your claim invention, you use the room temperature synthesis of the product. In that case, you reduce the temperature, so there is a efficacy increase. So little thing can decided your efficacy terms. In section 3E, the substance obtained by the mere admixture resulting only in the aggregation of the property of the compounds or of a components thereof, the process for producing such substance like the combiflam. Combiflam is the combination of the paracetamol and a brufen, which is an antipyretic and analgesic, or a solution of sugar and color additive in the water to form the soft drink. This is not a subject matter of patentability, but a mixture resulting into synergetic property of the mixture of ingredients, however, may be patentable, like the soap, detergent, lubricant. So the synergetic formulation are patentable. When you mix the two compounds or a solution of two things, you give the final product, and that final product give the synergetic formulations or having the synergetic efficiency. In that case only, then this is the subject matter of patentability. So synergetic thing you should be incorporated in your complete specification. Data should be there, so that anybody, so the examiner can be judged that your compound or your admixture having the better synergetic efficacy compared to the prior art disclosures. Same the section 3F tell us the mere arrangement or a rearrangement or a duplication of known devices, each functioning independently in one another or a non-way, is not a subject matter of patentability. Like the bucket fitted with torch, or a umbrella with fan, or a cloak or radio, or a camera and mobile you club into one thing, is not a subject matter of patentability. Or a floor mill provided with sieving, it is not a subject matter, because both are independent work. Same the section 3s tell us the method of agriculture or a horticulture is not a subject matter of patentability, like the cultivation or producing new form of non-plant or a preparation of improved soils is not a subject. But the agricultural equipment is are a patentability subject matter, because the equipment is a tangible products, or through the equipment you just increase the efficacy, or we can say that increase the yield of that product, or increase the yield of agricultural means. In that case, the agricultural equipment are a subject matter of patentability. Same the section 3I, the removal of the cancer tumor, surgical process, dental plaque removal, or method of vaccination, blood transfusions, all are these things are not a subject matter of patentability. Even the treatment performed on tissue or a fluid permanently removed from body, or a surgical or a therapeutics or a diagnostic apparatus or instrument are the patentable only. In section 3J, the plant or animals, or a part of plant animals, or a seed or a variety, or a essential biological process are not a subject matter of patentability. But the clones or a new variety of plant, a process for production of plant or animal, if it is consist a entirely new phenomena such as a crossing or a selection or a essential biological process, in that case only they can be covered. In section 3K, the mathematical models, business model, algorithm, or a computer per se program is not a subject matter of patentability. The new calculating machine even is a subject matter of patentability, because because through the calculating machine, time is reduced, so the efficacy is increased, or increase in your tangible product. So it is new calculating machine is a subject matter of patentability. Combination of hardware and software is patentable, but the software only is not a subject matter of patentable, it is a subject matter of copyright protection. But when you combine both hardware and software, and in that case you give the any tangible product, in that case only it is a subject matter of patentability. Same the literary, dramatic, or a musical or a artistic work is not a subject matter of patentability. This is a subject matter of the copyright protections. Same the 3M, the scheme of learning language, method of solving crossword puzzles, or a method of learning language, or method of teaching learning is a subject matter, is not a subject matter of patentability. But the novel apparatus for playing game or a carrying out a scheme is a patentable subject matter. Same the any manner or a method of expressing information like the spoken word, visual display, symbols, diagram, or a information recorded on carrier is not a subject matter of patentability under section 3N. Same the topography of integrated circle or a mask work circuit layout is not a subject matter of patentability. This is the other way of the intellectual property, semiconductor layout design. Through the semiconductor layout design, you can file your patent application, you file your application for registration of semiconductor layout design, but is not a subject matter of patentability. Same the traditional knowledge is not a subject matter of patentability under section 3P, because the traditional knowledge already in the public domain, like the wound healing property of healthy, is not a subject matter of patentability. But the any value addition using the traditional knowledge or leading to the new process or a product which is novel with the inventive steps or industrial applicability is the subject matter of patentability. Like the extraction of azadirachtin from the neem can be patentable. Same the section 4. Section 4 tell us the inventions falling within the section 21, the Atomic Energy Act 1962 are not a subject matter of patentability. If your invention related to compound of uranium, beryllium, thorium, plutonium, or radium, lanthanide materials or actinide materials, graphite, or more notified by the central government from time to time, if your invention is there, so it is come under the section 4. And according to section 4, the invention is falling within the section 21, the Atomic Energy Act 1962 are not subject matter of patentability. So last one is the sufficiency of disclosures. So if your patent application, if your inventions having the novelty, having the inventive steps, or having the industrial applicability, so when you draft your patent application, you should keep in your mind that there should be a sufficiency of disclosure. If your patent application have insufficiency of disclosure, in that case your patent is not granted. Because the under section 10.4, the every says that the every complete specification having should be fully and particularly describe the inventions and disclose the best method. Or if there is a biological material is there, so which may not be described in such a way to satisfy clause A and B and not available in the public, so in that case the deposition should be there, and deposition not later than date of filing of applications, and reference in specification should be there. Or all the available characteristics of correctly identification, including the name, address of depository institutions, and the date, number of deposit should be there. And the access of the material only after the date of application and priority, and disclose the source and geographical origin of the biological material should be also included in your complete specification. So when you analyze the presence of sufficiency of disclosure, so in your complete specification you determine the scope of claimed inventions also, and you just decide that the disclosure in the specification are is in such a way that one of the skill in art could practice in the inventions over its the full scope without undue experimentations. So in this case, this is the examples. In this example, this is the molecular structures, and where is the R1 is selected from the phenyl, pyridyl, thioalkyl, or a methyl group. Same R1 to R4 are the methyl, toluene, phenyl, pyridyl. But in the descriptions, the specifications included the several type of the compounds in these examples. But in example, however, these R1 is restricted to the limitation of R1 is always phenyl. In this table you can see the R1 is phenyl, but you claim that R1 is selected from the phenyl, predyl, thiol, but it is not acceptable because this is the in all example the definition of R1 is restricted to the phenyl, but you claim that R1 is the phenyl, predyl, thiol, but such type of the claim is much broader than what has been described in your specification and there is a lack of enablement in your specification and is therefore lacking in support, so it is not a subject matter of patentability. In the end, this is the one example of the patentability or in the case study. This is a very well-known case of Novartis. Novartis filed a patent application of anti-cancer drugs and the beta crystalline for or imatinib mesylate, just the Galiabec for treatment of the leukemia. Yeah, but in the prior art, this also a Zimmermann patent also disclosing the imatinib and their salts, so rejected by the Chennai Patent Office on because the Novartis patent application is anticipated by the European patent applications because they have only the same thing and did not exhibit any major change in efficacy in their patent applications. And in that case, the Madras High Court refused the patent application of Novartis and they appealed in the higher court. Madras High Court same the transferred the case to IPAB and IPAB again examine the inventions, and in that case they tell us the invention satisfied the test of novelty and non-obviousness, but the patentability of the product was hit by 3D because in their case the Novartis beta for crystalline for imatinib mesylate is not having the synergetic efficacy with the Zimmermann patent office. So the issue is that what is the known substance, what is the meaning of efficacy, what is the biological qualification as increasing the therapeutic efficacy, or whether the beta crystalline form of Novartis patent application is more efficacious than the Zimmermann patent applications. So the Supreme Court tells us the whether both having the focus on same molecules, imatinib mesylate, which is already known by the Zimmermann patent office, but in Novartis the imtimesylate is all there in Zimmermann patent, and this is a novel substance. The beta crystalline form is clearly a new form, but it is not so a synergetic efficacy in Novartis case. No data is subject application, no data in the subject application or in the supporting affidavit to make any comparison between the efficacy of Zimmermann patent and their claim inventions. So that Supreme Court made it very clear that efficacy in section 3D only means the therapeutic efficacy and state that other property of drugs are not relevant. On the question of the bioavailability, no material has been offered to indicate that the beta crystalline form of imatinib mesylate will produce the enhanced or a superior efficacy. In that case, the court therefore rejected the appeal in April 2013 of the Novartis case. This is the best example of the patentability. So when you draft your patent application, you should keep in your mind first what is the inventions. Either your invention is the patentable of not, is your invention having the novelty or inventive steps, or you should search all these things, the novelty and inventive steps to the prior art. You just go for the rigorous prior art, and through the rigorous prior art you can find out the oral if your invention is having the oral disclosure or not, prior printing publication will be there or not, or a prior public use will be there or not. So through the prior art search you can identify. So before drafting, you conduct the search thoroughly and listing the problem in the prior art. What is the problem solved by the inventions? What is the novelty, obviousness, or has your publication and you should or not, and decide the area and nature of protection. Either you file your application in India or a European country or in a US country, because as you know, the use claim is not granted in India, but use claim granted in US. So you decide the area and nature of the protections also, where you want to file your applications. Or what type of the application you have to file. You file to complete application, you would like to file the provisional applications. So it is depend upon your inventions. So in your complete specification, there is a content of there, this is a title, background of the inventions, use of invention, prior art, comparison between the prior art and the present inventions, object, summary, or a statement of the inventions, detailed description, working example should be there for the best method of the inventions, or claim for legal monopoly should be there. Same, there is a when you complete your complete specification or a provision specification, you file your patent applications within electronically with one of the patent office based on the territorial jurisdiction, because in India there is four territories: north, south, east, and west, and there is a four patent office on four patent office. So the based on the inventor address or applicant address, or you just file your patent application with with a particular territorial jurisdiction of the place of office, and pay the requisiting fees also. And the all information is also available in ipindia.nic.in. So this is the flow chart of the stage filing to the grant of patent of application. You can file your patent application either provisional or a complete specification. When you file your application as a provisional or a complete, the fees for filing is 1,600 for other than natural person, and 8,000 for other than natural person, and it is limited to the up to 30 pages and 10 claims. If you exceed the pages, so or a claims, so in that case 1,600 for per claim and 800 rupees for per pages in case of the other than natural person. When you file your as moment as you file the provisional applications, the or if you file your provisional application, not file the complete specification, you have to file the complete after provisional applications within the timeline of the 12 months. When you file the provisional application, you get the priority dates. So immediately, as soon as you file the provisional application, you give the priority date, and you can just you can transfer your technology, you can transfer, you can sell your technology, or you can go for the publication in the referred journal also. So after filing your patent application with the timeline limit to the 12 month, complete after provision specification, your patent application is published by the Indian Patent Office within the timeline limit of the 18 months from the first filing dates. If you are not filing the complete after provision specification, your patent application, a provisional patent application, is deemed to be already is abundant. So the only complete applications or a complete after provisional application is a subject matter of the publication by the Indian Patent Office, which occurred after the 18 months from the first filing date. As moment as your patent application is published by the Indian Patent Office, anybody can file the pre-grant opposition under section 25 rule 55. And after expiry of the 48 months from the first filing date, within the 48 months from the filing date, you have to file the request for examination, and fees for filing the request for examination is 20,000 for other than natural person and 4,000 for the natural person. And if the inventor would like to expedite examination from the Indian Patent Office, for the fees for the expedite examination is 60,000 for the other than natural person and 10,000 for the natural person. As moment as you file the request for examination to Indian Patent Office in the form of Form 18 with the requisiting fees, the Patent Office examine your patent application and issue the first examination report within the 3 months. After that, the Patent Office issue the first examination report. Based on the objection raised in the first examination report, you have to file the response. You have to file the response to the Indian Patent Office on the basis of disclosing information within the timeline limit of the 6 months. This is a free of cost. After filing the response to the your first examination report, examiner again work on that one, and they may be granted on based of your disclosed information. And when your patent application is granted by the patent office, it is already subject matter of the anybody can file the post grant opposition under section 25 rule 55 to 62. If your patent application is not granted by the patent office, the controller given an opportunity to hear once again under section 14. In hearing again, the controller and the inventor sit together either offline physical mode or a online mode, and in attending the hearing, and based on the hearing response, the decision of the patent granting by the patent office, your application may be refused or granted after hearing. If your patent application is not granted by the Indian Patent Office or case refused, there is another chance for to appeal. And the fees for filing appeal for 4,000 rupees for other than natural person and 1,000 for the natural person. And the timeline for the appeal is the 3 months from the refusal of your case. Or based on the appeal, when you file to the patent office, your application may be revoked, amended, or a grant. If your application is still refused, you can go for the court or high court for the particular jurisdiction. So this is the stage for the filing of the grant of the patent application. So this is the foreign filing filing flowchart through the PCT country. As right now the PCT contracting country having the 157 countries list. So PCT is not a granting authority. This is the patent cooperation treaty of 157 countries. So when you file your application, application in Indian jurisdictions, within the timeline of the 12 months, you have to file your application in PCT. The fees for filing this 1 lakh to 3 lakh rupees. After filing your application within the timeline limit of the 12 months from the first filing date, your applications published by the WIPO after 18 months of the first filing date. Within the after expiry of the 30 months from the first filing date, you have to enter into the particular national phase. Particular national phase means the particular jurisdiction who is a granting authority, like the European country, US country, China, Canada, Australia, etc. So the particular entering the national phase means the particular entering in the particular jurisdictions. So the PCT is not a granting authority. It's provide the platform. So through the platform you can enter into the particular various national phase in the single applications. So and the fees for filing the whole patent system is 2 to 3 lakh rupees. So this is the post-granted activities in India. After filing your patent application, you have to renew your patent application in every year. As soon as you have received the patent grant intimations, you have to pay the renewal fees within the timeline limit of the 3 months from the grant. Same, you have to file the Form 27 in each month of the September of the current financial year for the commercial working. The fees for filing, the renewal fees for filing is first five term is the 4,000 rupees. After 5 year is the 12,000 rupees. After 5 year 10 to 15 year term is 24,000 rupees, and term 16 to 20 years is 40,000 rupees for per year. So the total fees for your patent application renewal is the 3,80,000 rupees. If you would like to renew your patent application till 20 years, or you can go the patent application with the 20 years. So the total fees for renewal is 3,80,000 rupees. So the total patent cost for the Indian patent application is almost 4,08,000 rupees. So this is the post grant activities in India, and this is all from my side. And now I would like to now I am happy to have a question from the audience.
On behalf of the principal, staff, and students of Department of Biotechnology, thank you, sir, for staying with us and sharing your insights on patent law and invention. Thank you, sir, for being our resource person for today.
Thank you, ma'am. Thank you.
If anyone has any questions, you may please ask, sir.
Sir, good morning. Dr. Manjunath here. Can you throw some light on one compound second use? single compound, multiple uses?
Yeah. In the single compound is multiple uses. For example, if I have synthesized compound X is used for the anti-cancer, same the other inventor the same compound used for the anti-tuberculosis activity. So the this is not a subject matter of filing in India, because the same compound cannot be the same compound and different use is not a subject matter of filing in India, but in US it can be possible, but in India it is not possible.
But actually, in case if a compound is used for one type of cancer and if it is not worked out for another type of cancer, and if the compound is useful for that cancer, we cannot patent, no, sir?
Yeah, the use claim is not granted in India, sir. use,
Ah.
use claim granted in US only.
Okay. Otherwise, how to go about it, sir?
In when you file your application, you just first file your application in India, and after you go for US, because you cannot directly file your application in US. You have there is a two things. First, you file your application provisionally in India. You do not file the application complete in India, and after filing your application 6 weeks, you can file the convention application in US. Or there is another thing is there. You just take a permission from the Indian Patent Office in form of 25 that I would like to application directly in other country, not in India. So the Patent Office give you permission for the same, so that you can directly file your application in other country without filing the application in India. But you take the permission in form 20 from Patent Office.
So the permission is mandate, right?
Yeah, permission is mandatory, and the fees for permission is for the other than natural person is of 4,000 rupees, and for natural person is 1,600. So it is somehow same for the filing the new patent application. So it is a better than you file the provisional application, and you file the complete application, and let us decide the controller of your controller or examiner of your patent office. Or if you drafted your claim in such a way that it showed some inventiveness, so it is maybe subject matter of granting in India also, but it is depend upon how you draft your claim.
Okay. So in case if we change our drafting pattern, I think we can go ahead with the.
Yeah, because in under the sun everything can be patentable.
Yes.
Everything can be patentable, but how you draft your claim, it is a mandatory thing, because the claim is the heart of your patent application. So all these depend upon the drafting of your patent application.
Any questions from the audience? Bhaveshri, you check the messages. If anybody posted any questions on there, you can read it out.
Okay, sir.
Please unmute yourself. Participants, if you all have any queries, please unmute yourself and you all can discuss with sir.
So there are no queries.
Yeah.
On the behalf of Harvard College of Engineering, KSCSC and VTPC, we wholeheartedly thank you, sir, for your for sharing your valuable knowledge and for sparing your time with us. Hope the session has brought immense knowledge to all the participants. Especially for me, it was an important session, sir. Thank you very much for sharing your knowledge.
Thank you, sir.
Now we will be ending with this first session for today. The second session will begin at 1:30 p.m. So I request all the participants to join the session by 1:15 using the same meeting link. Sir, you can kindly exit the meeting now, and thank you for your kind time. I also request all the participants to exit the meeting. Thank you.
Good afternoon to everyone present here. Our speaker for this session is Ms. Priyanka, Project Associate KSCST. I would like to call upon Ms. Kavya to introduce our speaker, Ms. Priyanka.
Ms. Priyanka has a Master of Science in Biotechnology from University of Mysore and PG Diploma in Intellectual Property Rights from National Law School of India, University, Bangalore. She started her career at Karnataka State Council for Science and Technology and involved in implementing science popularization and outreach activities supported by Department of Science and Technology, Government of Karnataka and Government of India such as National Science Day, National Mathematics Day, Teachers Training Program, Chetana, E-Learning Center, Vijana Darshana, Science Radio Serial with All India Radio, Children-Centric Program of Puneet Satellite and few others. She also involved in coordination of student project program from 33rd series to till date. Further, she has scripted science dramas, article for All India Radio, Bengaluru and Panaji. Presently, Priyanka involved in Patent Information Center and TISC of KSCST in preparation of patent applications, trademark application for filing, conducting prior searches on biotech and life science related subject matters, drafting of patent application, assisting in FERs and visitor consultations and others related to intellectual property rights. Now, I would request you to ma'am to take over the session. Over to you, ma'am.
Thank you, Salma Kausu, for a beautiful introduction about me, and I thank Oxford for having me here today. So before starting, I just want to give you some inputs like the major of subject matter has been covered, and I like to have an interaction because today morning I noticed that we didn't had any questions. So if anybody is comfortable here, you can switch on your camera so that I feel like I'm talking to some people, even though it's in a virtual mode. If you're not comfortable, it's okay. But I advise everybody to interact whenever it's needed or when you feel like you want to. So here today, actually the subject given for me was a patentable subject matter, but fortunately it was covered with a previous speaker in the morning we had. So just I want to check today. I just want anybody of you to name a few IPs that you come across in your daily life. So you can give me an answer in the chat box. So how better you give me the answer, that better will be the interaction with me. So when we say intellectual property, have you used any intellectual property in your life or in your day-to-day life? If so, you can name the things what you are used. Oh, no messages till now. So nobody in the crowd has come across any intellectual property? Am I audible?
Yes, ma'am.
Yeah, can anybody in the group can say this is an IP that we are using? You can switch on your cameras. So no reply from a single person. I'm just waiting for the message. Unless I receive a message, my slide will never move ahead. Have you guys noticed? Okay, let me ask now in the either way. Have you guys used any IP in your life? Can I get yes or no answer at least? Have you used anything? Okay. Finally, thank Trinayan. Brand of a particular drink is an IP. Okay. Agreed. Then, and thank you for kickstarting the interaction. So any other IPs? Yeah, 1 second. I just want to see the message. Yes. So any other IPs apart from Trinayan? Trinayan says that patents, I need exact product name. Like when he says a drink, a brand of a drink is an IP, yes, agreed. You have a Thumbs Up, Pepsi, Coca-Cola. All these brands are an IP, I agreed. So when it comes to a patent, what is an example for a patent? Can you name any example? Coca-Cola is for trademark and it's for trade secret. Formula of a product, the specific product. Any specific product that you think it is protected under patent? COVID vaccine. Agreed, but it on public interest, it doesn't have a monopoly right. Copyrights. Can you give an example for copyright? Which product is protected under copyright? Websites. Websites is not a YouTube videos. YouTube videos under copyright. Websites, we have a special domain protection, not under copyrights. So under trade secret, we protect domain. Like cosmetics, food, okay. Then, so as of now, we covered trademark, images, okay, copyright, and patent. Books, okay. So apart from patent, copyright, and trademark, what are the other IPs we have? As of now, you guys gave an example. Music records is for copyright. Franchise, like for examples, those are not copyrights exactly. Okay, so now we'll have our designs. Okay, design is specifically for registered design. Example, design is given for which product? Registered design, architectural design of a company. Okay, so that means you are quite aware about the IPs you use. So have you guys paying any royalty or anything for a intellectual thing of a person has a reward for anybody's intellectuality? Yes. In form of what? So many says yes. In the form of the what reward we are giving for somebody's intellectuality. I can see only yes. So though nobody here in the crowd says no, I'm not paying any royalty for any intellectuality. So everybody says yes, or the 4 people from the group says yes. So in which form we are paying? In the form that we are buying that things in the form of money or in the form of MRP. Okay. Then what is an IPR? So IPR is nothing but it is an intellectual property rights. In the same manner, when we protect our property, we have a registration saying that this is my own property. In the same way, for the creation of mind, government gives you a certificate saying that this is yours. Nobody can use that. So here previously we have intangible and tangible assets. Can anybody mention what are intangible assets? You can unmute and see what are tangible and intangible assets in the group, if anybody. So what are tangible assets? So you can use my slide and you can refer that. You can use tangible or intangible assets. So anybody in the team can answer. Okay, the tangible assets are the infrastructure what the company or a building owns. The intangible assets are the IPs. So there was the time that the company were decided based on their tangible assets. Maybe till around 90s, everybody was behind the tangible assets. But now it's an era where we have a intangible assets. Intangible assets are nothing but they are the IPs, the creation of a human mind. So, past in 2022, India ranks a 40th position in a global index. So, it was in 81st position in 2015. Now we have reached 40, but we should work hard so that we can be in the top 10 in the world because the Switzerland, Korea, they stands first top 10 ranking. And when coming to the state wise, so Karnataka stands in the 4th position in generating patents. This record is specifically for the patents. So the being a Karnataka is a IT hub and a Silicon City, and all top institutions are in Karnataka, but still we lag behind. That we held a position of 4, and it was actually 3rd compared to last year. We have came behind, so now we are in the 4th position. And these are the overview. So on an average, we have 66,000 of patent filed every year, where around 50% will be. Oh, slides are not moving. Okay. One second. I think now you can see the slides. Can you see my slides?
Yes, ma'am.
Yes. Okay. Okay. Yeah, I think I was here. So we have around 30,000 of granting, that means of 50,000, and China has the highest patents filed. So China has around 3 lakh patent filed every year. So to reach China, we have to be another multiple of 4. So when you came across different types of IPs, these are the 8 type of IPs we have. So when you have so before that, why we need an IP? Why we need IP? Oh, slideshow it's not compatible. Probably we have some issues, so the slides are not moving. I think you can see my slide in the same manner. So why we need to protect our IP or our intellectuality? Why we need to protect our IP? The more the crowd is silence, to avoid copying from others for financial benefit. Then, so as I said, it is an asset. So we have 8 different types of I just wanted the word idea to protect our new idea. So what is an idea now? I just wanted that word, so I just asked why we need IP. So to protect our idea. So what is idea? Okay. Any other answer for that? Why we need to give new innovations to our society. Okay. Why it is so important to protect? Yeah, to order to get the ownership on our idea. Do the crowd, anybody here have the idea? Do you guys have any idea? Oh, it's a very simple question, man. Yes or no? So that other can't product. Okay, so that other cannot produce. So anybody here have an idea? Any idea? No idea. You guys doesn't have any idea? Okay, we'll talk in this manner. Do you guys have any problem? Any problem? No problem also. No, ma'am. Okay. Do you guys have an idea? When you guys doesn't have any idea or any problem, then why we need innovations in our society? If you guys says, no ma'am, we don't have any idea or we don't have any problem, then my question is for Nathuram. When you don't have a problem, why you need a new innovations to our society? Because both the answer was given by the Nathuram J. He says to give new innovations to our society. And he says, no ma'am, we don't have any idea or any problem. For the betterment of man. For the betterment, ma'am. Okay. So mainly the IP or the idea is just to make our life in a better manner or just to have a futuristic technological life which fetches you the reward maybe in the form of we can make a website where people can post their problem and others can give a solution for the same. Yes, and it's an idea too, and you can protect your idea. So here, when you have an idea, like Dhanush says that he can have a website and the people can post their problems and he can give some solution also, or other people who have a solution can post their solution in that platform. So anybody interested can pick up their problem and they commercialize the thing. So if that is an idea of a Dhanush, how can he protect its idea? So he can protect its idea in 8 different forms of IP. So in the morning, we talked many things about patents. So apart from patent, we have other 7 IPs also. So the majority area or the queen of IP is like patent. Patent fetches you the higher value. But however, you can protect your idea with other form of IPs also. Because if in the morning, the resource person discussed about non-patentable subject matter, where many of our idea falls in that. You think if Dhanush idea is a making website, for sure it falls in the non-subjectable matter that is under section 3. So now Dhanush want to protect its idea in other form. So he can go with, maybe he can create its own trademark saying this is the mark of my website, or he can claim a copyright for the software he used for his website, or he can claim design for his website design, and geographical indication cannot be claimed by Dhanush. So that specifically we have this 8 types of IPRs. Here, patent is given for 20 years for an individual for a product or a process, and trademark is given for a goods or a services, and it is for 10 years and it can be renewed until unless you wish to stop. And copyright is given for the author till life of an author and plus 60 years. So even after the death, you can claim rights for 60 years. And designs, it is for 10 years and extendable for another 5 years. And here the geographical indication is the only right that is given for the communities. So other rights are given, a monopoly right given for the individuals. And trade secrets, so we can protect our secrecy, like a Coca-Cola protects its recipe under trade secret. And for electronics students or electronic researcher, we have a special form of IP to protect the circuit, that is semiconductor IC layout design. And the last one is the recently introduced one, that is a plant variety. So these are the 8 form of IPs we have. So your idea can be protected in one or the either ways. So here we can discuss it. So how in each form it is protected. Is it an IPR right is a negative right or a positive right? We spoke about it is a right. Is it a positive one or a negative one? If positive, you can type 1. If it's very difficult to type positive, you can type 1. Or if you feel it is a negative right, you can type it as 0. It's a positive right. Salma says it's a positive right. Positive, positive. 3 positive, positive, positive. Nobody says it's a negative one. It's a positive. Okay. So can you say for whom it is positive and for whom it is negative? for whom it is positive and for whom it is negative? You can unmute and say, or you can raise your hand for the explanation of this question if it is difficult to type. Who says, for whom? For the needy, is it positive? Positive for the inventor. Then for whom it is a negative? When you specify, it is a positive one for the needy, negative for those who wouldn't want to steal it, positive for the owner, then negative for positive for the owner. Okay, so it is a monopoly right given for the single individual against the whole population of a country. And you know that it is a territorial protection. So when we apply an IP, it is given for the territorial region and it is a monopoly right given for a single individual. So it is called as negative right because you will be the owner or the inventor will be getting the right against all the population of the crowd. So IPR is a negative right given to an individual because the majority has the negative impact compared to the only one person or maybe the person who he gets a license. So apart from the finger count people, other people will be having the negative rights on the particular invention. So IPR is a negative right given for the inventor or an author from the government. Here, patent, trademark, design, GI, trade secret, everything is territorial except copyright because copyright holds good for throughout the world. Copyright doesn't have a territorial limits. I hope you guys are clear with the types of IPR. So we can just take some of the few case studies which shows how important the IPR plays an important role. Oh, okay, because my slides are not shifting, I want to move here and here. So can you recognize the brands here? Can you guys recognize some of the trademark or some of the brand?
Yes, ma'am.
Yes, so the first one says that it is
Puma.
Puma. Then the second one, okay, second one is for, the second one is a trademark for what? Agarbatti. And Coca-Cola, there is a name, and IBM is a company. Mahindra is for vehicle, Red Bull is for drink, Kit Kat is for chocolate, and MGM is for
movie studio.
movie studios. So here, have you seen a Puma? Have I written the Puma name? No, I have just shown you the picture of an animal. So in India, the trademark is given for goods and services only. So here, in patent, it's different kind, but in trademark, it's not necessary that you go and register your brand. If in case you can start using the brand, and when it become a familiar one in the society, it will be noted as such by the registry as a well-known mark. So here it's not compulsory that you have to go and register your service. So when Dhanush says, I want to create a website, he can first register a trademark saying that this is my logo for website, or he can start his website with some logo, and after getting familiarized, his website will be noted as a well-known one. So what are the advantage we have when we go for a trademark? Can you see a different two types of logo here? Whirlpool, blue and white. I hope you can see my screen, correct? I get confused many times because you guys don't respond. Yeah, home appliance is one. Yeah. We'll consider like this. The blue one is 1 and the white one is 2. Do you think it is a foreign company or an Indian company? Can you see is the Whirlpool trademark is from India or from foreign, or a foreign one? Is that so, ma'am? We are least bother whether they are from India or foreign. Yeah. Okay. Everybody sees a foreign. So which one is foreign now? So here I say we have an Indian Whirlpool and a foreign Whirlpool. So which one is India? The 1 or the 2? Blue is 1 and white is 2. So Paranika says that 1 is an Indian one. No, American. Okay, one is an American one. Okay, one is American one and the other two is an Indian. Correct. Actually, it's a right answer. One is an American one and two is Indian. Because you guys gave a right answer. If one is a foreign one, what are the electronics goods that produced by a foreign Whirlpool? Okay, so the case was like this. Whirlpool was a foreign based company. Initially, they have all the electronics items we have, washing machine, AC, fridge, everything. So one company from India called Chingar from Delhi, basically, they started manufacturing the washing machine in the name of Whirlpool. And the Whirlpools came to India and filed the case because the Whirlpool was not registered in India as of then. So they came to India saying that they are misusing our name or the quality of the washing machine produced by the Chingar company under the name Whirlpool is not a quality one, and this is causing the low of reputation to us. So you need to close. The court says, as it was not registered in India, you cannot claim the trademark. But the Whirlpool had one chance. Do you know the embassies, right? We have embassies in throughout the world, but in India also we had a US embassy. We have a US embassy. In US embassy, we had only one washing machine working in India. So that was the proof that showed by the US Whirlpool company saying that our washing machine is working in India since from many years. I come to AC before after concluding the washing machine issue. So then when they have the evidence that they have a usage in India, the court granted injunction for India saying that you are not able to produce a Whirlpool washing machine under the brand name Whirlpool. But as AC and other home appliances are not used in India, the other home appliances under Whirlpool, what we get in the market are Indian based company. So that's how the trademark plays an important role in protecting our identity and marketing our products. So apart from this, another interesting case we have is, can you see this? Yes, okay. So what the thing that you identify the moment you see these logos? The car company, the left side you can see it's a Mercedes Benz, and the right side we have a VIP, which is a company produces undergarment. So here the Benz company sued VIP Benz because they say the customer may think that the Benz undergarment is produced from Mercedes Benz and they get confusion. So in this case also the court says that VIP should stop producing the undergarments under the name VIP Benz. So even though there was the huge production of the VIP before it was marketed, it was produced and kept in the Gordon. The whole garments which has the seal VIP Benz were seized, and it was said that you can't use the Benz symbol, which is very similar to the car. Then the copyright. So the copyright is given for the all the literary work like your drawings, paintings, music, sound recording, cinematographic, everything. So whichever the way of expression. So here the idea, the logo is protected in trademark, but idea is protected in the under copyright, patent, and here copyright protects only the form of expression. So the I can give the crowd to write a drawing, and the writing a drawing is an idea that can be protected under patent. But the way how you write, that's given for a copyright. So can you anybody say the recent copyright issue that raised in Karnataka? Do you come across any recent famous case that involved copyright issue? No? Kantara movie. Okay, what was the issue in the Kantara movie? Instead of typing, anybody can unmute and say what was the issue. Music, the song. Okay. So it was the issue with respect to the song. This was the song which had a issue, correct? Yes. So it was the Oh, okay, Kerala people already had the song. So according to you guys, when the copyright is given for the person who created first, here the Navarasam song from some music brand from Kerala was created maybe 7 years before, which they claim that it is so similar to Varaha Rupam song of Tantara. Now, according to you guys, who owns the copyright? One for Varaha Rupam, two for Navarasam. Who owns copyright now? Is it Kantara team or Kerala music team? So you can type 1 for Kantara and 2 for Kerala. Confusion means you can say 0. 0. Oh, Pranika has confusion. Okay. Kantara. Who many of you are you local Bangalore people? So that we say no, no, ma'am. Whatever the things we should own the copyright. But the thing is, copyright is given for the person first who created it. Who filed the case? Kerala filed the case. Why so? Okay, the issue was like Kerala people created Varaha Rupam music bit 7 years before. Here, the IP office takes the music notation in the form of notations and even in the recording. Sometimes a recording, when we play the same notation in the flute and in violin, it may vary, but the notation written will not vary. So the notation was so similar, and Kerala people filed a suit in Kerala saying that Varaha Rupam is copied and they want the compensation of 10,000 rupees per show. So how much show the Kantara is here? Maybe in Bangalore, you think if consider only in Bangalore. So we have around more than 50 theatre in Bangalore, one show 10,000. How many amount they could have asked for? So it was actually settled out of the court, and some amount was given from Kantara team to restore the Varaha Rupam song in the movie. And you imagine, we'll leave the amount what they have paid back, but it was settled outside the court. A 7 or minimum of 5 minutes song or 5 minutes of literary work which was created 7 years before has fetched them and reward after 7 years, that too in the terms of maybe in the crores. So you cannot say your IP is of no value, and it's very important to protect all your literary work, because you degree college or a student or a faculty, you come up with too many poems or many way of expression, like in your talents day you start exhibiting your paintings or many artistic work, which everything can be protected under copyright. So I just wanted to take you through how important the trademark is, and this is a design part. It is given just for the thing, the outside appearance of a product, and it will be detailedly tomorrow with my colleague Nagarjun. And the last one is GI. We have no, not the last one. Maybe we have another two left. So the next one is a geographical indication. Here the Karnataka stands first in geographical indication, and Karnataka has the highest number of geographical indications. So can you name some of the geographical indication that you think this may be the geographical indication of Karnataka? You guys have not came across any geographical indications? Okay, let me define what is geographical indication now. Oh, Mysore silk, Chanpatna toys, I got two. Yeah. The handicraft or an artwork or an artistic work or a product that is involved with the regional or a land. Like Chanpatna toys is very famous in Chanpatna. And Mysore silk and Mysore sandal soap is a GI, correct. And you can see some of them in the picture where I tried to merge many of them. Because the Oxford College in Bangalore, can you name any GI from Bangalore? Bangalore has a GI for the blue grapes, the pulpy grapes what we get, the local. So that is the GI tagged grapes for Bangalore, and this is the logo where the GI is represented. So GI has its own value in the international market. So it is important to protect our handicraft under GI. Mysore Pak is not a GI. And anyhow, I think I have a time till 2:30, correct? So my talk will be concluding on 2:30. So we'll run with the subject matter other. So here trade secret, as I said, trade secret doesn't have the renewal date. So trade secret is the majority IP used by the big companies. Like unless the agreement is broken, trade secret cannot be revealed. The Google usually has the highest trade secret. The technology used in the Google is protected mainly through trade secrets. So other IPs have their own renewing date, but the trade secret doesn't have because it is done in the form of deed or a agreement. And here, the recent one we have is a protection of plant variety. The section 3 says that a plant or an animal cannot be protected. For that, we have a specific IP called Plant Protection Variety and Farmers Right. And this is the recent one you could have came across in the paper. We had a recent variety registered called Sidhu's jackfruit from a person called Sidhu and his father to the left. So now he is having a crores of business with foreign, and that form of jackfruit is famously called as Sidhu's jackfruit, and nobody can copy his jackfruit now, or nobody can grow the plant he has. So these are the various IPs we have. So when coming to the patent, already we have defined that is the rights given for the process or a product, and it is for 20 years, and it is from date of filing. It is a territorial right, and I just want to skip all these slides because we already dealt it in the morning. And the three main mantras, what we say it is very important for patent is like your invention, your product or process should be novel and should have inventive step in it, and it should be capable of industrial application. Here the interesting case we have that this is mentioned in the morning. I'm trying to link because I heard we had Dharwad Peda and Davangere Benne Dosa in the group. Okay. So here Dharwad Peda is a GI, and the Davangere Benne Dosa and Mysore Pak is not a GI because it's so generic, because everywhere we can get Davangere Benne Dosa. Even in Bangalore, we get the Davangere Benne Dosa. So here the GI should have their own characteristic, that it should differ when we prepare it in outside that land. So like Tirupati Laddu is a GI. Maybe if we prepare a laddu in our home, it will be not similar as a Tirupati Laddu. But if we make a Davangere Benne Dosa in our home, maybe it could be the same as we get Davangere Benne Dosa. So those are the GI, and that is given to the community. And here when we come to Apple or Samsung case, so in the morning sir said, when the moment you wanted to do some research, it's very important to do a prior art search, and he also deliberated how to do the prior art search. So here I just brought a case which shows how important the prior art is. So here Apple and Samsung are, as you know, Apple and Samsung are the two good competitors in the field of electronics, that's specifically for the mobile phone. Too many case has been filed from Apple against Samsung saying that they have copied their technology. And only one case that Samsung could defend was this with respect to iPad. So the Samsung came up with the prior art search or prior art search report where the Apple phone missed, or Apple company missed off is in 1960, there was a movie called A Space Odyssey. So their astronaut used some gadgets that is very similar to the iPad. You can see that I have marked that as an iPad. So that looks very similar to the gadget that was shown in the movie. So the Samsung claimed that, saying the design of iPad is already shown in the movie and it is in public domain, so you cannot say it is protected. So that was the only case where Samsung could defend. So that how prior art search is important. Sometimes you can fail finding the prior art, but your opponent will surely find the prior art report to avoid you from getting the protection for the IP. So it is very important to have a IPs. So till now we said IP for everything. So here I just want to show you a video how IP protected inventions are very important. So I just try to stop this presentation and take you through video. So you can just say whether you can see a video or not. Give me a second. I just find it off. Okay. Can anybody see my video here? No?
No, ma'am.
One second. Just try to aim for me and I could. Yes. So now you can see.
Yes, ma'am.
Yes. Oh, can you hear also?
No, no, ma'am.
Oh, it doesn't matter. If you don't hear also, it's okay. If it is visible, it's fine. So here, what is the problem you noticed? Do you notice any problem here? Can anybody say what is the problem that you noticed or what the thing you observed in the video? What are the things that you observed in a video? And I have left with only another 10 minutes more and I have many more cases to discuss with you. So the fast you respond, the more case I can discuss. The later you respond, the case discussed will be less. Makes people work easily. We need to cut to release the trapped air. Oh, that's the observation. Yeah, good observation, man. Then makes people work easily. Do you think so? Making Udin Vada in the home is a challenging work? Quantity is less. Have you ever tried making a similar Udin Vadas like we get in the hotel or with the similar texture or similar shape? And it's very difficult to have it, correct? So here when we feel like cleanliness well maintained, okay. Okay, what do you think the major part of this video is? Whole video is depend on the major part or the whole bottle of that squeezing is main design of a bottle. If a bottle design is like brand, oh, brand ID, oh, that's a trademark, that's a IP and it is a protected. Innovative idea. What is the innovative idea we have in this video? If a design is good, can easy to squeeze, okay. Can it get a perfect vada shape? So what is the part of design, if we say design, what is the part of that design, or what is the part of the portion is responsible to get a proper shaped vada? Old idea in a new and updated manner. Good. Now next, the cap. We call it as the nozzle. So opening, nozzle, yeah, that nozzle, yeah, this is the person, he is the Mustafa, he is the founder of this ID Fresh. And here, this nozzle is patent protected technology, and with this technology he has earned more than 1 crore of profit. Have you ever seen any other brand having the same model apart from ID Vada batter? Any other Vada batter sold in the same format with that nozzle? I don't think so. You get the same similar product in the market. If so, you get, or if you could find any similar one, you could message or you could communicate the same to the Mustafa so that he can sue the person who is having the similar product, because this technology is patent protected. So a simple solution for a problem. The patent or any IP will arise when you start thinking a solution for your own problem. So here, have you noticed the cricket systems here? The left one is used when we play here or in the local cricket. So now in the IPL we have that zinc wicket system. Why you think so? Why the wicket system has shifted from wood to the new system? Why didn't they had the old one? Why BCCI? Correct? I don't, if I'm wrong, it's a BCCI or IPL team. Go with zinc wicket system for an easy decision, because in the wooden we couldn't have a perfect accurate decision. So here a zinc wicket system is a patent protected technology which is done based on the sensor. Have you ever thought that we know the sensor is used in the many other ways in our life, but have you ever thought that a sensor can be used in the wicket system as well? No, but a man from Australia thought this is the person who owned the technology. So he's an Ekriman Bronte who invented this technology, and he has a patent in Australia and India. So a simple solution for the problem we had in the cricket match was the decision making, and he came up with a solution in the form of sensor attached wicket, which fetches him too much of financial revenues. Like one match of, he rents a pair of wicket for around 5 lakhs per day. So imagine we have played around 74 IPL matches in India. All 74 IPL matches have this technology rented. So how many amount the BCCI has been paid to Bronte for one simple invention? So that's how patents or technology have an importance in our daily life. And I hope you can recognize the lady here. So she is a Biocon founder, Miss Mujumdar Shah, and she owns the Biocon company. And her company was started with the simple brewing enzymes in her garage. And she was the first person from India to file international patent application. And that story has been recorded in World Intellectual Property Organization also. So a simple invention which you think it may not be worth enough, that will fetch you too much reward. And here another lady from foreign, and she's not a well educated, or she's not from the CEO of any companies. She is a normal person leading a normal life. Once she and her friend started traveling or moving towards a coffee cafeteria, and here her friend had a small kid which used to have a milk in a feeding bottle. The feeding bottle was so leaky, and she just thought, what could be the solution that she come up to stop the leakage of that feeding bottle? So that was the only one invention she had, and she thought that if we change the inclination of the nipple, the leakage may stop. And she did that, and it was a successful one, and it is a solution for many mother who feeds her kid with the feeding bottle. And her technology was sold to Haberman company for the production for a 42 million. So one simple inventive step or one simple invention was sold to a foreign brand for a 42 billion. So this is the importance we have for a invention. Only thing, your invention should be a solution for a problem. So here you have already seen what are non-patentable in India, that section 3 and section 4 were detailedly discussed in morning session. Here I just have a glance of that. So which invention says that mine is 100% efficient, that is not patentable in India, which already works like your gravitational force, which is the core of the invention, that is not patentable. If I think I can exploit plant or animal, that is not patentable. If my invention is harmful for the environment, that is not patentable. And we cannot say or we cannot discover the existing natural law, or we cannot discover anything or any substance and say it is my invention. Like a person can discover the microorganism, he can be the microorganism can be named after him, but he cannot own the monopoly. So we cannot discover a new form of the known substances and mixing two things and saying this is my own, it is not acceptable. And arranging one thing in a different form, like having the standby fan, and I just fit that standby fan to the roof and says that this is a patentable subject matter. No. And here the method of agriculture is not patentable in India because India gets the maximum GDP from agriculture. So on a moral responsibility, we don't get patent for a method of agriculture, and nobody, no doctor can say this is my process of treatment because of public health interest. As you see, COVID vaccine in the beginning, COVID vaccine on a public interest, monopoly was not given for any companies. Only the permission to produce the vaccine was given, but monopoly right was not given because in the time of COVID vaccine was so essential for the public. So government can pick your invention when it is a need for the public health, or when there is a national emergency, government can take up your invention if they feel they are so relevant. And you cannot protect plant or animal under patent. However, for the new variety of plant, you can get a protection under plant variety. So no mathematical model or business method is protected. No computer program is patented. All computer programs are protected under copyrights. However, the recent computer related invention guideline says that if you come up with the hardware and a software where the software is an integral part of that hardware, without that software, this hardware will of be no use. In that scenario, your computer program along with your hardware is protected. And I said before, all your literary, all your expressive work or artistic work are protected under copyright. And nobody can say, even a master Vishwanath Anand cannot say, this is my method of playing chess. Nobody can follow it. So no method of playing chess is protected. And nobody can say, even your teacher cannot say, this is my way of presenting the topic, you shouldn't copy it. So you have all rights to copy your teacher. So no presentation format is protected. And topography, oh, we skipped that actually. The semiconductor layout design, we have a new one, and we have less awareness about that because it is only specifically for the electronic students. And last one is our traditional knowledge. The traditional knowledge what we have in India is not protected under patent. That means we don't get the monopoly right for our traditional knowledge. Here we have a case study that University of Mississippi from US filed a patent and saying that turmeric has an antiseptic property, and we want to get a patent against turmeric. And the CSIR director said that no, it is our traditional knowledge. The patent cannot be given because if we get the monopoly right to some other people or some other country, they may start saying that no person in India can grow turmeric, and no kitchen in India runs without turmeric. So to avoid the right consuming by the others, the CSIS was able to prove, like we have evidence from many years, maybe from 1829, showing like we use the turmeric in our traditional or in day-to-day life as a traditional knowledge. So with that evidence, CSIR was able to cancel the patent granted for the Mississippi University for usage of turmeric. And here it is exactly 2:30 and it's time up, and we are here in the last slide at around last slide. So when I start saying 1, 2, you can say, is it patented or not? For yes, you can say 1. For no, you can say 0. So here the first one, 100% efficient diesel engine, can it go for patent protection? If yes, you can say 1. If no, you can say 0. If you have a confusion, you can say 2. No? Oh, Pranika has confusion. Okay. Yes. Okay. So according to section 3A, the first one, I didn't deliberate it detailedly because in the morning session, the section 3 was discussed very detailedly. So 100% efficient, anything cannot be protected under patent. The first clause itself says that no, whichever says that it is 100% efficient, it cannot be protected. So no advertisement of ointment or any hand wash has that saying we have 100% germ-free ointments. So that's the clause we have. So the first one is cannot be protected under patent. And second one is a perpetual motion machine. Can it be patented or not? And the answers holds good. 1 is for yes and 2 is for no. 0 is for confusion. Maybe. Oh, we can consider it as 0. Nobody says yes. Okay, here the perpetual machine cannot be patented because it works on the natural law and a treatment of a patient. So the method of treatment, can it go for patent? No, and it cannot go for patent. So if somebody discovers new animal, can it go for patent? No, okay. If I mix turmeric with the milk and say it is a new medicine for a headache or for some vomiting, can I go for patent? No. Or jewelry can go for patenting? No. Okay, at least I have some good listeners today. So here, a Newton cradle, a toy that we get in the Amazon, can it be patented? 39 says, is it yes for Newton's cradle, 39? Yes. No? Okay, 39 says no for Newton's cradle. So here Newton's cradle works on the Newton's law, which is very well established natural law, so it cannot be protected. And a casino machine can be protected. The 8th one, casino machine can be protected. No. No. Only 2 of them says no, other. No. Yeah. Casino machine cannot be protected because it is against a morality of a society. And the 9th one, 99.9% germ-free ointment. And here germ-free ointment says that 99.9% germ protection, so it can go for patent. And here pen with the sprayer. Pen with the sprayer, can it go for patent production? I think it leads your confusion. Yes, okay. So here actually pen with the sprayer cannot go with for the patent protection because both are the two different utility. So we are just joining the things. That is the arrangement of the known things. Here sprayer, we can see it in the our perfume and deodorant and pen. So even without that sprayer, pen will work individually, and even without pen, sprayer will work individually. When we attach, the utility or the nature of work will doesn't change. So it is not protectable. And Archimedes screw, 11th, no, yes, correct. Archimedes principle bill cannot be protected because it is well established as Archimedes principle. And the 12th one, neem stick has toothbrush, no, because it is our traditional knowledge. And a movie poster, no, because it is protected under copyrights. And in India, we have all these clauses saying that this is protected, this is not protected. But in foreign countries, we don't have such criteria for all crazy invention will get the protection. And just to create some enthusiastic in your thoughts, and if you feel like your invention is not protected in India, no worry, you go file in the foreign country so that you can see that I have a foreign owned patent. However, having an Indian patent is such a heavy pride. So I wish that everybody in this crowd could come up with one each patent or any other IP so that India gradually moves from 40th ranking to the 10th position. So here, let me see what are the crazy patents we have in our foreign countries is cycle attached with umbrella. Here it would be rejected under saying that it is two different things and it is attached, but in foreign it has been granted. And here we have even the dog cover is a protected patent technology, and I have just tried to fetch you the real picture as well. And here the umbrella for the dog, even that's a good idea where a puppy can be protected for the rain. And here for the many lazy people, if we have so automatic shower device, so we have a good number of family people who says that it's very difficult to go for a bath, so we can ask them to sleep inside this bathtub. And here virtual reality, when our partners are so far away and we wish to dance together, maybe we can utilize this technology. And here, when it's difficult for the chashmish to remove and keep a chashme for every frequently, so there is an idea for getting pierced it, and it is patent protected. Even a shoe that was used by Michael Jackson in his dance is protected for in the patent in 1993. So it is a US patent, a patent protected technology for shoe. And that completes my presentation. And thank you that it was great interacting with you, and thank you for interacting with me whenever I asked to reply. So thank you so much, and I thank all the organizers here and the faculty, student who are here with us today. So thank you. So if you have any questions, you can post me. I hope you guys are quite clear with the things that what IP is really means. So thank you.
Participants, if you all have any queries, the forum is open for discussion.
Salma, if no questions, we can conclude.
Thank you, ma'am, for sharing your expertise and for an interactive session and for giving us a complete knowledge about IPRs and their types. Also, for giving us a complete understanding about patent protection. Thank you, ma'am.
Library is systematic, you have a job as a scientist, you are paid, where it was passion in the past. Now it is more of, no more passion, but more of a fashion. Is it? Huh? How many are passionate about doing science? What do you people want to do in future? You want to become scientists or prepare for civil services or state service exams or get a job or MBA? You want to make money? Oh, what do you want to do? Does not matter if you want to make money. One of you would be future Bill Gates or Aziz Premji or Tata's Big Brother. No, Tata's Big Brother way behind. There are many other people. Adani Ambani. So, okay, whatever you want to do, have passion for it. No jabardasti. There is no force. You enjoy what you do. That is most important. So, how do I move the slides? Yeah. Okay. This is all, our teachers used to take chalk and board, and now life has become more easy. I don't know how they used to write the entire derivation. O going here, carbon, CO2 going somewhere else, and OH somewhere. Everything was, now we really find it difficult without all these new technologies. Probably, yeah, I'm glad to learn that you guys are learning genome editing. This is something really new, and for me also it's new, not just for you. It's just a science of few years old. So, well, my friend introduced me some of the important parts from Delhi University, I was not knowing molecular biology. When I joined Delhi University for PhD, and then I had never seen packet, I had never seen how much time I have by the way? 1 hour. 1 hour. Okay, I don't want to stand in between your lunch and okay, even I would be hungry by that time. So I was really, I had not seen the Zappant molecules and all those things. Probably you are all familiar with those, right? Do your molecular biology experiments? Yes. After my master's in plant, how to handle pipettes and all, I said, I don't know. I came to Bangalore to write the CSAT exam just to get a net certificate so that I can get some teacher job somewhere that would make me eligible to find a job of a lecturer. But fortunately or unfortunately, I had got fellowship and I was in the top 10% of the country. And I said, okay, let me go to Delhi University. I was trying for some jobs here. There were different criteria. So I could not make it to those jobs and I moved to Delhi University. During my PhD, I got bad scholarship, had an opportunity to work in Germany on bad scholarship. Why I'm telling all these things is you guys can try for all these fellowships. It's not to highlight more of my accomplishments or small this thing, but for you to enlighten you people as to what are the different categories in science. So I went to Germany for 6 months. That was the first time I had sat in a flight and I did not know whether it's going to fly high or going to come down. So it was really terrible, and I managed to, morning 7 o'clock, I used to go to the lab to see if I am getting colonies in my plates or not. And I used to work up from 9 to 12 o'clock all alone in the polyhouse, in the greenhouse, doing the experiments. I was a multitasker. So in the winter, there used to be heavy snow. I did not have proper shoes. I used to walk in those thick snow, with all those gold shocks. But still, I was so enthusiastic about doing science. I never thought I would do PhD in my life. I thought I would become a civil servant or something. But destiny took me there, and I was really attracted by these series of discoveries. You mentioned how DNA counts, RNA, what happens, and all those. It was all very enthusiastic events. So I studied in Stuttgart University. That's where Robert Bosch headquarters is located. And when coming here, I saw the Bosch company, and my memory went back to Stuttgart University. That's where the Bosch headquarters is located. So then after my PhD, I went to US and I worked in an institute called as Danforth Plant Science Center for almost 5 years. That in a place called as St. Louis, and that's where Monsanto, Bayer, Pfizer, and Sigma headquarters. You get all the chemicals from Sigma. They are all located there. And the recent Nobel Prize, what was the Nobel Prize for the last 2 years back on somebody worked on virus? The latest Nobel Prize may not be last year. Last year was given to somebody who worked on hepatitis virus. Right? So the Nobel Committee thought viruses are really important after this COVID pandemic, and it was awarded. Nobel Prize for COVID is yet to come because still people have not done enough work. So that's the place where I worked. So after my postdoc, I joined a DBT institute, and again I went to Switzerland for 1 year. It's a beautiful country. Everything is systematic. You really don't need a bike or car there. Public transport is really, really good. And more than research, what I've done is to see the beauty of Switzerland. So, and then I joined, Delhi, IRI, Indian Agricultural Research Institute, which is a premier agricultural research institute. It's mother of all agricultural universities. So if somebody wants to do your masters in biotechnology, you'll have to write ICAR exams for Indian Council of Agricultural Research. So you can get fellowship, you can be independent and no more burden to your parents or whatever. So you can as well as do your PhD. Many scientists from IRI, they have become world's renowned scientists like Dr. M.S. Swaminathan, Gurudev Kush, and many other people. And recently, World Food Prize was given to a soil scientist. So they are all, Dr. Lal, they are all products of IRI, Indian Agricultural Research Institute. And recently, I just came 2 months back, I was in UC Davis in California. I went as a Fulbright scholar. Only one person from each field is selected for that particular fellowship. And I was the one from agricultural science. There are different fellowships for medical science or different category of physics, chemistry. One or two persons are selected for. It's a very prestigious fellowship. Even our S.N. Krishna, former chief minister, was a recipient of Fulbright fellowship. So he was called. The time Fulbright is name of a person who donated his money to support people with this fellowship. It's not FULBRIGST, it's not Fulbright, it's just FULBRIGST. Okay, enough of that. So there are a lot of opportunities for biotechnology, and science does not have much money. It's a passion. You want to publish, you want to make a name, and you want to be satisfied, then that's the path. It has a very long incubation period, but if you can enjoy the journey of doing science, that's really great. But if you are desperate, somebody is desperate of making a lot of money, probably I will not advise do MBA, become a some managing director or whatever, then you get handsome salary. Scientists are not paid that well. Even Nobel Prize is not enough, so it's less than salary of a managing director of a company. Okay, but the world knows who this fellow is, right? So, how much money you want? Everybody eats the same food, right? Nobody is going to eat gold. Anybody who eats gold, we all eat the same food. What we need is calories. So do what you really like and excel in that research area. Okay, without taking much time, I'll try to do justice for. You have heard of genome editing? How many of them you have heard of genome editing? You're all familiar about genome editing, genetic engineering? Yes. Huh? Okay. So, what is genome editing? Somebody can answer? If you have heard, what is it? If you have not heard, that's okay.
By altering the genes.
Huh?
They basically alter the genes.
You basically alter the genes. Okay, good. So, what is editing? You write something and somebody edits it. Huh? So, edit is to correct. Correct for the good or correct for the bad, it can be either way. So, here you know what is genome. What is genome?
It's a functional unit of DNA. Unit of DNA.
It's not functional unit of DNA. What is genome?
Collection of
Gene is functional unit. Okay, what is genome?
collection of all genes.
Collection of all the genes. But how do you define it more scientifically? It's amount of DNA present in an haploid cell, that is the genome. Okay. Ome means the entire bunch, entire gamete of genes or its supporting elements. Okay. So targeted genome editing is you are targeting that. I want to edit this particular gene sequence exactly here in the gene. That is what is targeted. You are targeting. Okay. And so how genome, you are all more lean towards medical biotechnology or plant biotechnology? Both are still confused or still in the process of making, right? So medical biotechnology has advanced far much. Without COVID vaccines, which are all outcomes of biotech research, I think maybe I would have not been here without the vaccines. Maybe you guys are all lying and quite strong and now I immunity. Maybe you would have been there, but people like me or people older than me might not have been here without the contribution of biotechnology. So, what is it? You have to swing like this, huh? This way. Okay. Who are these people? They got Nobel Prize for their contribution in the area of genomics. Okay, so she is Jenny retired governor, and she is Emmanuel Chapman. She is from Max Planck Institute, and she is from University of California, Berkeley. So both of them jointly won Nobel Prize for their work on genome editing, and more specifically on CRISPR-Cas. Okay, you have heard of CRISPR-Cas? Huh? CRISPR-Cas is not some Faluda ice cream that you get in. Sometimes when I hear these strange words, if I go to a pizza restaurant, Pizza Hut or Domino's and all these things, I would really find it very difficult to order pizza. What toppings you want, everything is so advanced even in pizza technology. So what I know is only this part. I would prefer to go to a simple restaurant, maybe Udupi or some Jawara Roti restaurant. But I would really get confused in the McDonald's or pizza restaurant as to order what. So CRISPR-Cas has become a common terminology now. Everybody says CRISPR-Cas, CRISPR-Cas. I mean, maybe people don't know what CRISPR-Cas is or what it really stands for. People talk about it. Like virus, the world, many people in the world do not know what is virus. After this pandemic, everybody knows what virus is. Okay? So, how this genome engineering has evolved, it's not something really new. It's way back first in 1979. The first gene replacement was done in yeast. What is yeast? It's a single cell. Again, one of the best model hosts study most of the genetic aspects. The first gene replacement was done in 1979. So that's also genome engineering. Probably an old version of genome editing, but it's still some similar to genome editing. Okay. So then, something called as zinc finger proteins. You have learned about zinc finger proteins in any of your course? You are not sure. Okay. I'm not surprised. I would have been surprised if you have done. I learned about zinc finger proteins during my PhD. So, but now subject is in US, in the 7th or 8th standard, they learn about genome editing. There is a chapter called as genome editing here. So, may not be they really don't get into so detailed into the molecules, but it has, it educates people what really genome editing is, how it can be employed, what are the good things, bad things, and all those things. So, this is how the genome editing subject has been evolving. There have been discoveries about gene finger nucleases and CRISPR-Cas. Don't get embarrassed, like I'm asking you some thin crust pizza with toppings of capsicum or pepperoni or those things. Don't get confused. It's very simple. I'll take one by one and tell you what is what. Okay. So this has been really evolving. There are like something called as STAD effectors, CRISPR, gene fingers. These are all different tools and techniques that are used for genome editing. Okay. So, and very briefly, these are the 4 major techniques that are used for genome editing. One is meganuclease, the most primitive one, and the second one is ZFN, that is zinc finger nuclease technology. C is TALEN, okay, and D is CRISPR-Cas. So you can see all different features. They're all different techniques. This is the most primitive. Then later on, zinc finger nuclease, slightly more advanced, was discovered. Then talents were discovered. And the latest one is CRISPR-Cas. And again, in CRISPR-Cas now there are so many modifications. Okay. So essentially, the fundamentals of genome editing, it relies upon 2 basic things. Whenever there is damage in our DNA, there is something called as repair. Okay? If the road gets damaged, the repair happens very late, or it may not happen at all. But our body system, if there is a damage of DNA, it gets repaired quite fast. The the cellular machinery responds very fast. It's not like our PDA or BBMP. They respond very fast and they respond in two ways. One is something called as homologous recombination and another one is called as non-homologous recombination. So the damaged portion, they again attach with each other very immediately in one of these two ways. So one would be homologous recombination if there is a support system supporting DNA and the recombination doesn't change the sequence. Okay, the sequence of the area where the repair has happened remains intact. Whereas non-homologous end joining, that's where few bases fall off and the repair happens. There is ligation of DNA strands and the repair has happened with some deletion of nucleotides. Okay, and that is called as non-homologous end joining. So that results in mutation. Okay, mutation in the gene, and that particular gene is no longer able to synthesize or translate the protein that is intended to do so. Okay, so this is what is really important for genomics. So all these, whatever four genome editing tools I explained before, meganuclease, zinc finger nuclease, talents, CRISPR, right? Because we are all so fast in absorbing things, I'm really, probably one day I should sit there and you guys should come there. So they are all called as holy grail of biotechnology. You heard of holy grail? What is holy grail? Not heard of holy grail.
It's a cross, sir.
What is holy? Sacred. Sacred. Okay. So this is something like very sacred to biotechnology. So coming to zinc finger, meganuclease is very old technology and not much success or commercialization has been achieved using that technology. Let us speak about zinc finger nucleases. This is what is zinc finger nuclease. So these are the zinc fingers. You know the fingers? How many are there in each fingers? How many nodes we have? Three. So similarly, here, it can be three. Okay. So these zinc fingers, they have the ability to recognize certain nucleotide sequences. So they can recognize the nucleotide sequence. You have heard of restriction enzymes. What do restriction enzymes do? They recognize the nucleotide sequences and they restrict the DNA. They cut the DNA at that particular site. So similarly, these zinc fingers, they have the ability to bind to the nucleotide or DNA and specifically to certain areas, not randomly. That's why it is targeted genome editing. So you can have any number of zinc fingers depending on the sequence you want to recognize. Say you want to recognize 12 bases. Okay, so 12 divided by, so each zinc finger can recognize 3 bases. So how many zinc fingers you need? 4. You want to recognize 24. How many you need? 8. So these are attached to molecular scissors called as FOK1. Okay, these have not come from Dimer Chrysler or Bosch or from Ashok Leyland or somewhere else. These are all derived from prokaryotic bacterial cells. All these things which I am speaking about, they are all derived from bacteria. Okay, restriction enzymes are derived from where? From bacteria. EcoR1. What does EcoR1 mean? Yeah. So similarly, FOK1 is also derived from particular bacteria. The same strategic principles hold good for this also. Only thing is, the zinc fingers to recognize particular nucleotide sequence, and there is a molecular scissor to cut at the place of recognition. So these are attached together. So this tells go here and bind, and whenever this binds, so this cuts the DNA. So what happens after the DNA is cleaved?
Matches.
What happens?
DNA repair will take place.
DNA repair will. So how will it happen?
By DNA polymerase.
Okay, by what means? Non-homologous end joining or homologous repair. Okay, depending on if there is a substrate to carry out homologous repair, then there is homologous repair. If there is no substrate, then it is non-homologous end joining. Okay, so basically, this is the DNA, double strand DNA, and you need to have a pair of, whenever you use the word scissor, you say scissors, we don't say scissor, because it's a pair of cutting edges. So similarly, here we always want to use a pair of chain finger nucleases. Okay, so the one recognizes here and the other one on the other side, the complementary strand of DNA, double stranded DNA, and there is a cut, and cut can be repaired by one of the two mechanisms, non-homologous end joining or homologous DNA repair, and this results in targeted mutagenesis and the particular gene is knocked off. Okay, it does not translate. Suppose we have a protein that is really dangerous for my health. So if I want to knock out, I want to ensure that the protein is no longer produced, and that particular gene which is involved in translation of that protein needs to be knocked off. So you can knock off that particular protein and I will be free from that particular disability. Okay. Same case is true for plants or any other organisms. Okay. So most of the health issues we have is because of our genetics, many of them. Okay. The kind of proteins we produce. We are all not the same. We all have different genomes. We produce different proteins. Maybe 90% there is similarity, but that 1 or 10% of proteins make a lot of difference in each of these individuals. Okay. So suppose somebody says that it's not just that I don't want to mutate the gene by causing some nucleotide deletion, but I want to remove the entire gene, the chunk of gene I want to remove. Then you use 2 into 2 pairs of zinc finger nucleases, that is 4. Okay, so one pair makes a cut here, and another pair makes a cut here. So one pair, you can write on this point, you can use the pen. So there are 2 cuts made. Whenever there are 2 cuts made, what happens? The sequence in between these 2 cuts falls off. And then this is called as gene deletion. So the previous slide was of gene mutation. We are just changing few nucleotides and not the frame. It is the gene frame is disturbed and it doesn't translate for protein. But here we are removing the entire gene. Okay, the gene is gone forever. So this is another way of editing. So and there is something called as gene finger linkages. What is nick? Cut only one particular strand, not in both the strands. Here the cut is in both the strands. So what is done in the case? You use a pair of gene finger nucleases, okay, but one particular FOK1 is made dysfunctional. It doesn't work. Only one particular FOK1 works. What happens? A cut is made only here, but on the other side cut is not made. So only one strand there is a cut made, and then repair happens only in that particular strand. Okay, and then whenever DNA replicates, so this particular sequence change is reflected in the subsequent generations of the DNA in due course of replication. Okay, so are you guys following? Do you have any doubts? Please interrupt me if there is something which is not palatable. Okay. We come to CRISPR-Cas. So you have heard of CRISPR. What is CRISPR? clustered regularly spaced from you were reading it from here or you know it by heart?
Reading it, sir.
Even I would do the same. So, what is gas? It's CRISPR associated. It is associated with CRISPR. So the C comes from here, AS comes from here. Okay? And so it's Cas. The word 9, there are so many different Cas. From 1 to 12, 13, 14, 15, with time, more and more Cases would be discovered and you would get a new number. Okay? So CRISPR-Cas is basically this particular thing is. So this is not something which those two Nobel laureates which I showed in the initial stage, they did not discover it. This is there from the time a cell has formed historically. Okay, so this particular defense. This is an adaptive immune system or a defense system of bacteria, which are the most primitive organisms.
Bacteria.
Bacteria. There was anything before bacteria? Archaea. So this particular adaptive immune system is present in bacteria and archaea, and we human beings have exploited this particular mechanism and we are using it as a tool of biotechnology to improve plants or to overcome some issues in human beings or for that matter any other organism. Okay, so there is a long list, you will not understand. I'll take the picture. So there are so many different Cas, and Cas9 is the most common Cas that is used. And again in Cas9 there are so many different Cas9s depending on what plant you want to work. Say you want to work on Arabidopsis or tobacco or wheat or rice. So the Cas9 needs to be modified accordingly. Okay. So there are so many versions of Cas. So I'll not, if there is a Cas required for to work on human beings, there are different Cas. Cas to be worked on mammals or mice or rabbit or rat. There are different Cases which are, whose sequences are tailored so that it works well in that particular system. Okay, this is what is CRISPR-Cas. So this is double-stranded DNA, and this gray thing is called as Cas9. Where else you have seen this gray thing? Behind somebody's head. When we have the pictures of gods and goddesses behind this, what will be?
It's a halo, sir.
Round.
Halo. It's a halo.
Yeah. So similarly, this gas is something like a halo shown like that. It's the background. So this is the protein. It's a very big protein, and due to helicase activity, the DNA is unbound. Okay, and there is something called as guide RNA. So which guides the Cas to bind at this particular place and to carry out that particular cut. Okay. So this guide RNA is 20 nucleotide in size, and it has other things which helps in activation of Cas to do the necessary cut, the nuclease activity, and this guide RNA to bind to particular nucleotide sequence, it needs another sequence which is called as PAM sequence. Okay, so this is just a 3 nucleotide sequence which is called as protospatial adjacent motif. So this is called as protospatial, and this is adjacent to this particular protospatial, so it's called as PAM, protospatial adjacent motif. Okay, and this guide RNA can bind only to its homologous sequence only in the presence of PAM sequence. Although if there is 100% homology, if the PAM sequence is absent, this would not bind, it would not recognize the gene. So for the recognition to happen, the guide RNA, what is guide RNA? Just an RNA, small RNA. Guide is, it guides. What it guides? It guides the Cas protein to bind here and make a cut at this particular location. So this guide RNA goes and binds here. This is generally 20 nucleotide in size, and there is something called as 12 nucleotide, which is called as seed region. You have seed. In a fruit, you have seed. Seed is something which is really crucial. So the 12 nucleotide pattern is called as seed region, because if there is a single nucleotide mismatch in seed region, then this will not bind at all. Okay. If there is a mismatch somewhere else outside the seed region in the 20 nucleotide guide RNA, it can still bind, although with lower efficiency, but still it can do the job. But if there is a mutation in the seed region, mismatch in the seed region, the guide RNA would not recognize and the Cas protein would never make a cut. So, what are the important components of CRISPR-Cas system? You need a Cas protein, which is really big, and you need a guide RNA. Guide RNA is like your Google map, okay? Or somebody has the iPhone iMap. So, guide RNA is something like that, which has some additional sequences to activate the Cas protein. And for that to happen, this is like some traffic signal. The palm sequence has to be present, and it goes and binds, and then makes a cut. The Cas9 protein is able to make a cut only because of its nuclease activity. What is nuclease? Anything that degrades nucleotide. What is protease? Anything that degrades proteins. Anything that degrades lipids? Very good. So, now, for the nuclease activity to happen, there are two domains in the Cas9 protein. One is called as HNH, and the other one is called as loose domain. So these two domains, one of the domain targets one strand of DNA, and the other domain targets the other complementary strand of the DNA, and they are able to make a cut, and after making the cut, the repair has to happen. So repair can happen by either way, homologous or non-homologous end joining. So since there is no supplementary DNA, as in most cases, non-homologous end joining will happen, and there is a mutation, and the mutation will result in non-translation, and the protein is not produced. It's so simple. So all these tools are like advanced. So you have what is advancement, something which you use daily, iPhone 10, iPhone 12, iPhone 13. What is the latest iPhone? 14. Okay, I not heard. So this is something like that. So this is a three-dimensional view. Anybody has seen Chota Chetan? Chota Chetan? You don't know. Anybody has seen 3D movies? Which movie you have seen?
Avatar.
Okay, when I was of your age, there was only Chota Chetan. But anyway, when I wore that glass, I don't know it was of right quality or not. I never saw it 3D. So this is the 3D view of the CRISPR-Cas system. You can see the DNA, and it is unbound because of helicase activity. And this is the Cas. Okay. So how many of them have understood, and how many of them have not understood whatever I told now? Let's be fair. If I was there, probably for not understood was my hand would have been raised. Anyone who did not understand until now whatever I said? I see some glowing faces. I see some not so glowing. And how many of them have not understood? So I presume everybody has understood. To understand it much better, I will present an animation of this particular thing. Okay. So this is again the same thing, and I have explained in zinc finger nucleases you use a pair of zinc fingers, and one of the fingers can be mutated so as to cause a nick only in one strand, break only in one particular strand. Here also there are two nucleases, right? HNS and Lucy. These are the two nuclease domains in Cas9. In zinc fingers, there are two independent proteins, two independent nucleases. But here, in one single protein, there are two nuclease domains, HNH and Lucy, where you can see scissors. Okay. So if you mutate one particular domain, then this is is active, there can only be one particular cut in one strand of DNA, but not in the complementary strand of DNA. Okay, so here you can create nicases. So what for these nicases are used and all, you will probably get to learn later. I am not, because there is not enough time to explain everything. So I will just tell you like how you can design the tools, how these tools are designed for your convenience. I want to call the nick, I want to make a cut, I want to make a gene deletion, then you use two different pairs of gene finger nucleases and make entire deletion. Okay. So it's all up to you. How do you want to use these tools? There are so many tools available. So in the market, if you want to become a bike mechanic, okay, so there are so many tools, right? So you cannot buy everything what is available in the market. Huh? So you will not become bike mechanic, then you will become pauper. Okay, you need to buy only what you really need to do that particular job. So in the market, in the biotechnology market, there are so many tools available, so many proteins available, so many accessories, chemicals available. You cannot buy everything. What is your experiment? What is your objective? Only those things you need to purchase. So here also, similar to gene finger nucleases, you can make just one particular link. Okay? And alright, you can see this is one particular stretch of DNA with reference one particular gene. This is the promoter. Okay, this is guide sgRNA sequence, and you need a promoter too. So many of the people would ask, how will you produce the protein? How will you make sure the protein will get into the cell? How will you make sure the sgRNA will get into the cell? Okay. Anybody have these doubts? Huh? Did anybody think how do you make sure that the Cas is going into the cell? How do you make sure this particular sgRNA is going into the cell? So, essentially you have plasmid. You know what is plasmid? Vector. Okay, vectors. So there are vectors, okay, and these vectors will have different open reading frames, okay, or different cassettes. Each vector will have a cassette. What is cassette? Cassette is, there is a promoter to activate the transcription, and there is a terminator to stop the transcription, and in between there is gene sequence, the protein that you want to produce. Similarly, there is a promoter and this sgRNA sequence and stop signal. Okay, so the nature of promoter and the stop signal and all varies from plant to plant, organism to organism, depending on the target organism. You select what you really want to use. Okay. For a diesel car, you cannot buy for petrol, you cannot run it on petrol. For a petrol car, you cannot run it on diesel. You have to buy petrol. So similarly, there will be vectors, and these are there, and these vectors you can mobilize into plants. How do you mobilize vectors into the plants? How do you mobilize vectors into the plants? You have heard of agrobacterium? Plant transformation. Have you studied plant transformation or transformation of plasmids into human cells? Not yet. Okay. So it's like you have learned about making pizza without having to know how to make dosa. So first you have to learn how to make dosa, and then you put one step ahead how to make pizza. So these are transformed into plants by various means. You deliver these vectors by agrobacterium, which helps in mobilizing the DNA into the plant cell, or you mobilize them by gene gun. There are gene guns which strategically ruptures the cell membrane, and then the plasmid is mobilized into the cell. You are a student or a photographer? Student. Still comfortably. You should also learn. Enjoy it, okay? These photos, in US probably are taken thousands of pictures, but never had time to look back into that. One or two is enough, that's it. To show it to somewhere that we have done this. We invited somebody from Yelahanka who took 3 hours to come here. Okay. So,
Back, sir.
Okay. So I'll show you a small animation with cartoons. So this is the sgRNA, which is an RNA sequence. Just like 40 nucleated RNA sequence, 29 nucleated part of that is what? Guide RNA. Very good. And this is transcribed. Okay. You have Cas9 protein. Okay. So these are expressed maybe from a single plasmid or two different plasmids, and these are produced in a cell. Visualize that you are in the cell. Okay. What is there in the cell? There are so many things, right? There is DNA, which is transcribing RNA, and that results in proteins, which is translation. So you have plasmids which are forcefully put inside. So one or two of the plasmids, which are different cassets with promoter on the left, terminator on the right, and the intended gene sequence in between, transcribe or translate for a Cas9 protein and transcribe for a subgenomic RNA, sgRNA, which helps in recognition of the target sequence. Okay, and then what happens? They form a complex. Okay, and then they come and recognize the homologous sequence, complementary sequence. Okay, and for that to recognize, there has to be a PAM sequence. If this PAM sequence is not there, then it will not recognize. Okay, and it recognizes and then targets the gene of interest. You can see it makes a nick. Okay, why the nick has happened? Can somebody on this side tell? People are more active. I want to get some voice on here. Why this nick has happened? I hope you are not into Pizza Hut. Why this nick has happened? What is there in Cas9? What is Cas9?
It's a protein.
It's a protein. What kind of protein is it? It's a nucleus. So there are nucleus domains. That's why effect has happened. Okay. How many nucleus domains are there? Two. Okay. Then what happens? Okay. And then gap filling will be there. Since it is non-homologous, any nucleotide in the vicinity can come and fill up the gap. Okay. So there is all the chance a stop codon could be introduced, or there could be frame shift mutation. What is frame shift?
Shifting of positions.
Frame is shifted. That particular gene would not be able to produce the protein that you want. Okay. So there is sgRNA Cas9 complex formation. It binds to the target gene, Cas breaks the gene, and then mutation happens. So what you wanted? You wanted to edit. Did that happen? All right. So that is all in the sky. But how do you do it practically? I asked you, okay, gentlemen, here I have a plan. Please edit it. Edit this particular gene. What is your favorite gene?
Hemoglobin.
Huh?
Hemoglobin.
There is no hemoglobin in the plant. There is hemoglobin. Yours favorite gene. You want more blood? I'm asking yours favorite gene in the plant. What's the most important biological pathway in the plant? Photosynthesis. What are the different genes involved in photosynthesis?
Photosystem.
Okay. So essentially, how we go ahead? I ask, I need to edit this particular. Let us take hemoglobin only. I want him to no longer produce blood. Stop producing the blood. So you need to target the hemoglobin protein. So you design 20 nucleotide sequence somewhere from this particular hemoglobin gene. Okay, how do you design? There are different softwares. Okay, so you put your gene sequence in the software and it will use different algorithms and give you the output. These are the three candidate 20 nucleotide sequence which can be best target to knock off this gene using CRISPR-Cas or gene finger nucleases or something like that. So you take that 20 nucleotide sequence, get the sgRNA, you use a vector which expresses this guide RNA which is sgRNA, and then also the Cas protein. To put it in the plant, you can put it in the plant or human cell in your case. You can put it in human cell by different ways of transcription of plasmid DNA. The DNA can be transformed into human cell by different ways. Okay, there are so many different ways. So that can be done, and the cells, wherever whatever cells the plasmid goes, it encodes for the protein and sgRNA, and the editing happens. Okay, got it? Got it? All right, there are different software files. I will another how much time I have? 20 minutes. Okay. So you can play around. You can use the problem with these technologies is sometimes there are off-target effects. What is off-target? There is a mango there in the corner. I want to take off that mango. I'll hit a stone. There is all the probability that the stone would hit that mango or it may hit one of you. Okay? So if it hits one of you, then it's an off-target effect. Okay? If it hits the mango, then it is targeted genome editing. But nothing is 100% perfect in this world. There are always flaws, there are mismatches, off-targets. So, how to minimize the off-target? There are so many ways and means to minimize the off-target, but you cannot really avoid it. Okay? Technologies, you can polish the technology further to make it more specific. Okay? To have only targeted gene editing, but still the amount, the percentage of off-target is there, but maybe to very less extent. So to minimize such off-targets, people have played with different tools and techniques of genome editing, such as gene finger nucleases. They have mix match they have done for gene finger nuclease, like a OK1 is taken and put into the CRISPR-Cas system, so that you have better recognition. How it will help in better recognition? If you use two different, say, gene finger nucleases and sgRNA sequences, then you are sure that this is going to find there only, nowhere else. Because our sequence is so huge, there is always chance that that sequence will be present elsewhere else. Say your name is Naveen. There could be 2 or 3 persons who have the same name. Somebody is Shobha or something, and there could be another Shobha. If I say Shobha, both will raise their hands. So that can be off target. So how do I call Shobha and the last name? Many people here don't have a last name. Okay. So, all right. Let me not. A lot of applications of CRISPR-Cas technology. There are several model organisms like mice, rats, fruit flies. What are fruit flies? What is it called as scientifically? Drosophila. You have seen fruit flies? Where you have seen fruit flies? Sometimes if you forget to eat the banana, dies on the table rotting. What will you see? Small fruit flies, small. Those are Drosophila. They are the best model organisms. Most of the Nobel Prizes have gone for the work done using that model system. So there is a lot of agricultural applications, medicine. Okay, so there are a lot of applications, and now, as I said, there is more of off-target effect. People have tried to make it more specific and to make sure that there are no off-targets. So they have tried different proteins, something called CPF1. I'll not explain in detail. These are different versions, something like Cas9, and they are more specific in in their job. They have less off targets. Okay. So, and there is something called as Cas30. How many different nucleic acids we have? Two. DNA and RNA. Very good. So all that I explained now, Cas9 can target the DNA. Say I want to target the RNA. Then there are certain Cas proteins which target RNA also. So one of them is Cas13. Okay. So this Cas13 targets single-stranded RNA. There are certain RNA viruses, right? COVID coronavirus is what?
Double-stranded RNA.
Coronavirus is what? It's an RNA virus, but not double-stranded. There are some double-stranded RNA viruses. Coronavirus is not double-stranded. It's a single-stranded RNA virus. Okay. So there could be, you want to target RNA viruses, then this is something which can be used. Or somebody thinks that no, I don't want to disturb the gene. I just want to control the transcription. What is transcript? RNA. So you target your RNA. Okay, just see that your RNA is not stable, but you don't want to disturb the gene because you never know in future if that gene is required for some other job. So in that case, people are using Cas13 which targets RNA. Okay, and here you can see acts upon this particular RNA. The RNA is divided into small pieces. Got it? So this is like some jadoo. You wave your hand and I want mango, so I want apple. So somebody wants tomato. You have not been purchasing tomatoes for the last so many weeks. I thought the price would come down from 80 to say 60, but it's increasing. It's becoming 140. So why that has happened? One of the reasons is a lot of viral diseases this time. Havoc created by rains, heat stress, and as well as a lot of viral diseases in tomato. So if you have gone to the market, I don't know how many people go to Sabji Mandi and buy tomatoes these days, or everything is done by your parents.
We go, sir.
You go.
We go.
You try to pick up tomatoes which are really red in color. They don't have anything. You have seen these? Have you ever thought what are these? That's all because of virus. Okay? And don't get scared that if I eat the virus that will get into my body and some new COVID will happen. Fortunately, God has created a strict barrier between plant viruses and animal viruses. Plant viruses don't infect animals or humans and vice versa. Okay? So this particular virus which is called by some an RNA virus. If I want to control this virus, then by using genome editing technology, so which Cas protein should I use?
Cas13.
So you can use Cas13 and control this particular viral disease. So we are going to do this in near future, and there are a lot of complications of Cas13, not just controlling the virus, but the gene. Okay. So there are so many applications. I will not really get into detail, and sometimes I edit a gene, but after 5 years I feel, oh my god, I lost that gene, but it was really important. It's playing something very important role, which you really realize after 5 years. I want to reverse it. Can you reverse it once I did it? Yes. No. But now new technologies have done, there are reversible therapies. That particular edited thing, you can reverse it. Okay? So human beings are so notorious. You create a hole, then you find a solution to fill the hole, and again you say, no, I need that. And again you do something. So this is how. Alright, briefly I will tell about the work I have done. I spoke about this 2 or 3 years back when you invited me to. I forgot to thank Dr. Manjunath. I should have done this in the beginning of my talk. He has been really kind enough to invite me.
We are very glad to have you here for looking at your experience and work.
This is the work which I did during my postdoctoral studies. After MSc, I still think, why should I do PhD? PhD is done by those people who don't get a job immediately after MSc. Or people do MSc Masters who don't get a job after bachelor's degree. I never wanted to do PhD, but destiny took me there and I did. And I never thought after PhD what is there, postdoctoral research. So, when I was in school, I would always see when would we stop reading, when 12, still we got to read for the exam. Degree is over now, I am a graduate, I should stop reading. No. My job is to read only. Okay? So, if you consider reading as a hobby and passion, then you would never get those feelings. And this is the institute where I work, Donald Danforth Plant Science Center. It is one of the top institutes for plant science research in the entire world, not just US. And here, this particular institute has been working on a crop called as. Have you seen? How many of you have seen this? What's the other name for cassava? Sweet potato. Something similar to sweet potato. It is not sweet potato. This is tapioca. How many of you have not eaten sabudana? At least your parents during fasting. We don't fast. But our ancestors have been fasting. During fasting they eat sabudana. What is sabudana? Sabudana is derived from this particular plant. Probably nobody knew that. Even I did not know. Later on I learned. Okay, sabudana is derived from this particular plant. And earlier days, or even now, you get medicine. There are two different kinds of medicine that we take orally. One is solid, white, or they add some sort of color these days. And another one is capsule. Solid one has starch. Everything is not active ingredient. Only there is small percentage of that which is active ingredient. It is mixed with starch, and that is what you swallow. That starch is derived from this. And you know what politicians wear? Starch, nicely pressed. Kurta pajama, or Gandhi shirts, or you get them from where? Ramraj. Okay. So Ramraj uses cassava starch to starch the clothes. Okay. You cannot really press them well, they need to be starched so that there are no wrinkles on those politicians' dress. Although there are wrinkles on the face, but the dress are really clean. So this particular crop is a staple food crop for many of the Africans and also for many of the South Indians, like people who are in Tamil Nadu and Kerala and some parts of Andhra Pradesh. And now this is being cultivated commercially in India for starch production. This is the best starch for diabetic people because the major component of this has resistant starch. This is resistant for conversion into immediate glucose. Okay, so if there is like potato, when you eat, immediately it is converted into glucose in your blood. Glucose level increases and not good for diabetic people. But this is not like that. If somebody is diabetic, so this is the future crop of the world, future of crop for the climate. The world which is going through climate change because it can tolerate a lot of heat stress and so many other things. So we collaborated with several African countries with funding from Gates Buffett Foundation and other industries. And this is a major disease called as brown streak disease in Africa, which has literally destroyed the crop and resulting in famines in Africa. So this is caused by a virus which is similar to what I have shown in tomato sometime back. Okay, so this particular virus was controlled by a technology called as not gene editing but RNA interference. You heard of RNA interference? So before this Nobel Prize, I showed the second slide, Jennifer Doudna. Before that, who discovered RNAi? They were given Nobel Prize. Andrew Fire and Craig Mello. Okay, so they discovered RNAi technology. Using RNAi technology, also we can control several viral diseases. So if we use RNAi technology and developed genetically engineered few grams, and you can see this free from disease, and this one a lot of disease. And when you do a northern hybridization, you can detect the small RNAs. Okay, so you may not be able to assimilate what this northern hybrid. You have heard about northern hybridization? When I have a fracture in the hand, you use X-ray. It's an indirect way to detect the fracture, right? Using the X-ray. So this is an indirect way to detect the different kinds of nucleic acids. So this has been commercialized in Kenya. Which is the transgenic crop we have in India right now? BT cotton. Very good. There is nothing other than that. People have been trying to push BT brinjal, GM mustard, BT corn, but we are not accepting it. We accepted BT cotton because we don't need cotton. Okay, so okay, I'm safe. But we are brinjal. Bangladesh is going BT brinjal, and they are really harvesting very good crop there. But here our all brinjals have all borers inside. We purchase some brinjals and your mother will say how many ula are there in this. Right? So there are so many genes recognized which are controlling the disease. They help in the interaction of the host and pathogen, which result in occurrence of the disease. So those genes, some of them are susceptible genes. You can target them using genome editing technology, and you can control many of the diseases. Okay. So similarly, these viruses, they just don't get into the cell like that. Okay. There has to be an interaction between viral proteins and the plant proteins. So one such interaction is virus encodes for a protein called as BPG, and there is an eukaryotic host translation initiation factor which is numbered at 4E that interacts with the viral protein to recognize, and then the virus infects the plant cell. Okay, but if you destroy this particular 4E protein, then that interaction stops. Okay, there is no interaction. When there is no interaction, the virus fails to recognize and the virus fails to infect the plant. So these particular genes have been edited, and this is how editing has been done. There have been deletions here. Okay, the deletion does not happen, it's random. There can be 5 nucleotide deletions, 2 nucleotide deletions, or 20 nucleotide deletions depending on wherever it is there. It's all, although it is targeting the gene sequence, but it is not specific to that particular nucleotide. Within the gene, the deletions can happen little bit randomly. Okay, so by doing that, people have been able to control this particular brown streak. It is called as brown streak because you see brown colored streaks on stem. So that you don't see it here wherever the gene has been edited, because the virus fails to recognize that host protein and it is arrested from infection. So, and similar technology has been used in control of rice diseases and many other things. And now plant viruses are used as tools to express this Cas protein and sgRNA, so that some of the plants are difficult for tissue culture and transformation. You know about tissue culture? You know about tissue culture? So some of the plants are difficult for tissue culture and transformation. They are called as recalcitrant. Some school students, they will be difficult to correct now. They are too stubborn. You say don't eat too many oily things, but still, how many of them you see Tarak Mehta Ka Ulta Chashma? You don't see. Huh? Who eats too much in that particular cereal? Huh? हाथी तो मर गया अभी, उसका बेटा कौन है? गोलू। गोली is सरदार जी। गोगी। Yeah. So some stubborn kids, they don't listen. So the plants, some of them are not amenable for tissue culture and transformation. Then you use viral vectors, where you really don't have to do tissue culture and transformation, because virus gets into the cell and does the necessary job of editing. And then you can get rid of the virus. Looks like you guys are waiting for the lunch or bored of this. Anyway, so they are being used, and now zinc finger is used over CRISPR-Cas is over. What is left? foods. Mushroom, what is the problem in mushroom? Browning. So anti-browning mushrooms are produced by genome editing. Where else you see browning? Apples.
Vegetables.
So anti-browning apples have been produced by genome editing. And what is this? Tomato. So in Japan, they have produced first genome edited. This is the first genome edited and edible crop in the market. So this has a special amino acid called as GABA, which is gamma aminobutyric acid, which helps in reducing the blood pressure. Okay. So many people these days they have diabetes and high blood pressure. So you just don't have to take amlodipine or something other. You advise your parents to buy these tomatoes, although they are expensive now, but not bad, cheaper than the medicines you get in the pharmacy. So their blood pressure will go down. Okay. So genome editing has been used in for banana to control some viral disease, and let me not. There are a lot of policy issues. Technology is one thing and policy is another thing. Okay? If you produce a vehicle, it has to go through so many tests, collision test, gas, pollution test, so many tests to get into the market. Here also, it is more complicated than that. So many countries are not allowing genetically engineered crops. How many would want to have genetically engineered food or don't want to have? Don't want to have, you feel it is unsafe.
Yes, sir.
Right? How many wants to have vaccine, COVID vaccine? What is COVID vaccine? How is it produced? Through genetic engineering. Where is it? It is not applied to the skin. It goes into the bloodstream. And the genetically engineered food goes into the stomach, not into the blood. Which is safer? Something that goes into the blood or something that goes into the stomach? Stomach is safer. What do you want to have? Why you don't want to have genetically engineered? It's your choice, it's your money. But still, okay, it is safe. In US, all the corn you get cornflakes and everything all engineered. Probably you have eaten it without knowing. All the cornflakes till then you have eaten is all genetically engineered. So, and what is that? Popcorn and kurkure. Kurkure is from corn starch. That is also genetically engineered. She has already become style. Oh my god, I hate genetically engineered. How do I get rid of that? So, okay friends, the third genome editing technology I will quickly cover in 2-3 minutes is tail. It is not TAIL tail. What is TAIL tail? Monkey tail. Yeah. So this is TAL tail. What is the another meaning of TAL tail?
Transcription activation.
Okay. So this is, I am going to tell you the tail of a tail, not TIL, TALE of a tail. TALE. These tails are transcription activated like effectors. Okay. And when a nuclease is attached to that, it becomes TAL. Okay. So this is transcription activated like effector nucleases. That is TALEN. And these tails, similar to most of like zinc finger nucleases, CRISPR-Cas, they are derived from prokaryotic organism, bacteria or archaea. Similarly, this is also derived from a bacteria called as Xanthomonas. Okay. So this is a type 3 effector protein, and the good thing about these tails is they also recognize certain DNA sequences. Okay, specifically, and this is how you can see this is the DNA double helix, and it is recognized by tags. Okay, so what you need? A protein to recognize the sequence and a nuclease to cut the sequence. So talents also serve the same purpose. So they are also another tools of genome editing. Genome editing is not just CRISPR-Cas. There are so many tools and techniques, and this is one of them. And there are so many amino acid series used to recognize different nucleotide sequences. I'll not really get into that. And an FOK protein is attached to this, and you can cut. And then the repair happens similar to what I explained in zinc finger nucleases. This has been used to develop wheat that is resistant to powdery mildew. Okay, and there are so many success stories for talents. And there is a this is comparison of each technique, which is good, with talent or CRISPR or mechanical case. Not really. It's doing a lot of commercial applications of this, and now a few years back, China came with a new rhyming word for CRISPR, leaper. Many people want to name their kids with the rhyming words. Suri, Ali. What are the other things? Huh? Sonu Mono. Divya Kavya. So many things are there. Okay. Don't say Dravya. So there are China has come with Reaper. Then there will be a creeper. Don't go to diapers, okay? Stop here. So just wanted to tell you about the book that I have edited in 2018. Some people want to refer, can refer, and thanks for this opportunity. I hope I am able to convey the message, although it was sometimes hurry-burry. Anybody has questions, please feel free to ask if you have time. If your food is getting colder, then you can rush it. You already taken food. Were you having lunch when I was Okay, thanks for this opportunity, patiently listening. Okay.
A very good morning to one and all present here. I welcome you to day 4, session 7 of Know Your Intellectual Property Series 2. On behalf of the President of Children's Education Society and Chairman of Oxford Educational Institutions, management, principal, staff, and students of the Oxford College of Engineering, I extend a very warm and hearty welcome to our guest of honor, Dr. Lipika Patnaik, who will be taking us through the session on patent drafting. I would like to extend a very warm and hearty welcome to our principal, Dr. N. Kannan. I would also like to welcome our HOD, Dr. B.K. Manjunath sir. I would now request Ms. Kavya to introduce our guest of honor for today.
Dr. Lipika Patnaik, Principal Scientist, Innovation Protection Unit, Council of Scientific and Industrial Research, New Delhi. Dr. Lipika Patnaik has completed PhD in Life Sciences, Microbiology, and holds a LLB degree. She is presently working as a Principal Scientist in the Innovation Protection Unit of Council of Scientific and Industrial Research. Before joining CSIR, she has worked in Indian Patent Office for more than 12 years, both as an examiner and controller of patents and designs. She has also worked as an examiner of Indian Patent Office as ISA. During her stint at the Indian Patent Office, she has been actively involved on preparation of guidelines for examination of patent applications in the field of pharmaceuticals, guidelines for examination of biotechnology applications for patent, and guidelines for processing of patent applications relating to traditional knowledge and biological material. She has undergone JPO Operational Patent Examination Training organized by Japan Patent Office, the Overseas Human Resources and Industry Development and Asia Pacific Industrial Property Center, Tokyo, and WIPO training course on patent law and examination at International Intellectual Property Training Institute, Daejeon, Republic of Korea, organized by World Intellectual Property Organization in cooperation with International Intellectual Property Training Institute with assistance of Korea Intellectual Property Office. She has also attended judicial training for assistant controllers of patents and designs and the training program for examiners of patents and designs at RGN IIPM Nagpur. Her present profile at CSIR involves securing, protecting, and managing the intellectual property of CSIR. She is actively involved in handling issues related to Biological Diversity Act 2002 and Biological Diversity Rules 2004 of India, and dealing with National Biodiversity Authority of India, which administers the biodiversity laws. She is also involved in critical examination of IP clauses and forming opinion on IP issues in agreements, MOUs, proposals, and license agreements concerning contract R&D projects and consultancies. She is also involved in reviewing and management of IP portfolio of CSIR. Now, I request you, ma'am, to take over the session. Over to you, ma'am.
Thank you so much. Am I audible and visible?
Yes, ma'am.
Okay, I am trying to share my presentation. Please help me in this. Like, is the okay? Is my screen visible to you?
Yes, ma'am.
Is the presentation visible?
Yes, ma'am.
Put it on.
Is it in the slideshow mode?
Yes, ma'am.
Thank you. So, good morning, everyone. So, I have already been introduced. So, in the workshop on knowing your intellectual property, in this session, we'll be discussing about patent drafting. So we will discuss about what are the technical requirements of a patent for a patent to get granted, and how these requirements are to be fulfilled while drafting a specification. We will discuss about what are the different types of specification, like provisional and complete specification. Then we'll discuss about the components of the complete specification, like title, field of invention, background of invention, the summary of invention, detailed description, claims, abstract and drawing, and how to draft or prepare them. As we are talking about patents, you all be knowing that patents are the most important form of intellectual property rights, and intellectual property rights are exclusive right granted to the creator of such IP for his commercial exploitation, which is subjected to national laws and international agreements. And it is done with a view to reward the intellectual creativity of that person. So patents are one of the most important form of intellectual property right. It is an exclusive territorial right granted by the government to the inventor or his assignee for an invention. And what are the rights conferred? Rights are to exclude other from making, using, selling, offerings for sale, importing the invention for a limited period of time, that is 20 years. And it is given against or in lieu of the disclosure of the invention given in a patent specification. So patent specification is something you are giving to the public, and in return you are getting a right of a patent or a monopoly right over a patent. So patent specification is the most important thing over which all this thing exists in a patent. Okay, so in India, patents are administered by the Patent Act 1970 and Patent Rules 2003. It's an exclusive territorial monopoly right for 20 years, as I have mentioned, and it is granted by the government for invention which are new, inventive, and industrially applicable products and processes. So there should be a product or a process, and it should be new, inventive, and industrially applicable. And everything. So a patent specification is generally drafted keeping in view the requirements of the Patent Act and the rule regulation that is provided in the rules. So we cannot go beyond whatever is provided in the rules, and we have to follow the timelines, the fee requirements, etc. while filing a patent application. So now, before moving to the drafting part, let us very briefly discuss about the technical requirements of a patent. So, and let's first see what the Patent Act actually provides. So, for these requirements, Section 21J of the Patent Act says that invention means a new product or process involving inventive step and capable of industrial application. So, basically, it should be a product or a process. Nothing else could be patented, and it should be new, inventive, and industrially applicable. These three are essential requirements for a patent. Then, to qualify as an invention. Again, in section 2(1)(JA) defines inventive step. It says that it is a feature of the invention that involves technical advance, economic significance, or both, and it makes the invention not obvious to a person skilled in that. So here also there are two essential components: technical advancement, economic significance, or both, and it should not be obvious to a person skilled in that to qualify for inventive step. And section 2(1)(AC) defines capable of industrial application. It means the invention must be being capable of being made or used by the industry. It means it must have some utility. So once these three requirements are fulfilled, then the subject matter fulfills the requirement of invention. It becomes an invention, but it will not be considered patentable in India if it falls within the subject matter provided in section 3 and 4. Section 3 and 4 are basically the list of things which are not patentable in India. I'll come to these section in my subsequent slide, and I believe that in the previous session someone has already covered this, so I will be discussing it very briefly so that how it could be used while drafting the specification. Now, another technical requirement is sufficiency of disclosure, which is provided in section 10 of the Patent Act 1970. So sufficiency of disclosure means whatever is being claimed should be sufficiently disclosed in the specification. I'll come to this section while we will be discussing about drafting of the specification and claims as well. So now first focus on novelty. Novelty means newness against something. The specification or the claims should be new against something. So what is that something? That is the existing art. So let's see how the Patent Act guides to everyone to which document should be considered as a existing art or the prior art. So section 13(1) says that the examiner shall make investigation to ascertain whether the claimed invention has been anticipated by publication before the filing of the concerned application in a patent application filed in India after 1st January 1912. So it basically covers all prior patent publication in India. If the subject matter what you are claiming is there in a patent application filed in India, then there is a lack of novelty in your claim. Secondly, section 13(1)(B) says that the examiner shall also make investigation to ascertain whether the subject matter of the invention has been claimed, not published, has been claimed in a patent application, which may be published after the filing of your application, but that claims priority that is earlier to this particular concerned application. So it basically covers prior claiming in India. So in case your claims are covered under another patent application which is filed in India, which may be published after your application, but it is claiming, but it has been filed prior to you, and it is claiming something that is the same thing which is being claimed in the concerned patent application, then it will be considered as prior claiming in India and will be considered as a relevant prior art. Next, section 13(2) says that the examiner shall also make investigation to ascertain whether the claimed invention has been anticipated by publication in India or elsewhere in the world in any document that is not covered under section 13(1). So it basically covers all prior patent application published outside India or all non-patent literature published in India as well as outside India. So it basically covers everything that could be considered as a prior art document. But here there are some exceptions as well, but I'll not be focusing on those exceptions because we will be actually digressing upon from that topic then. So, but there are some exceptions provided in section 29 to 34. And so what is a prior publication? Anything that is available in public domain in a written form, if it is orally described anywhere, it is being used anywhere, it is there in the internet, everything comprises the prior art. So, or the state of art. So it is everything. If the subject matter which is being claimed is anywhere there in this, or it is claimed in a patent application which we call prior claiming, it will be considered novelty destroying, or it will be considered as a relevant prior art for questioning the inventive step of the claimed invention. Now it is very important to mention that when we are discussing novelty, only one document is taken at a time. The comparison is done with one document at a time. But for inventive step, combining more documents are allowable. Now let's move forward to let's see how novelty is determined. So it is comparatively simpler. The claimed invention is compared with the prior art. In case there is a difference, So the claimed invention is novel. So how to determine it? First of all, every element of the claimed invention is evaluated. It means what are the elements of the claimed invention. Then the second step is to assess or determine whether all the elements of the claimed invention, all the steps of the claimed invention are explicitly or inherently disclosed in any prior art document. If it is disclosed, the claim will lack novelty. But the novelty of each claim is judged independently. For example, if claim 1 is a composition of A plus B and claim 2 is a composition as claimed in claim 1 further comprising C. So it is basically A plus B plus C, and there is a prior art document that discloses a composition of A plus B, then it will be considered novelty destroying for claim 1, but it will not be considered novelty destroying for claim 2. Okay, now let's move forward to the next requirement, that is inventive step. As the definition provides, it is a feature of that invention that has technical advancement, economic significance, or both, and it is not obvious to a person skilled in art. So this obviousness is a complicated thing, so it makes the determination of inventive step a bit complicated. So certain steps are generally followed. First step is to, when the claimed invention is compared with a prior art document, the first step is to check what is the inventive feature or inventive concept of the claimed invention. Then the next step is to determine who is the person skilled in the art, who is reading this invention, who is reading the prior art. So when I'm saying a person skilled in the art, is not a natural, normal person like you or me. It's a person, it's an imaginary person. The person knows everything that is there in any book, any published literature, anything that is available in the internet. So he knows everything in that particular field. So he's the person skilled in the art. So while you have to compare your invention with existing art, you should step into the shoes of a person skilled in art and think in that way. While the examiner examines a patent application, he steps into the shoes of a person skilled in art and examines the patent application for inventive step in that manner. So now the next step is to determine the state of art. It means whatever common general knowledge, specific knowledge known to this person skill in the art is called the state of art. The next step is to determine whether there is a difference between the state of art and the inventive concept or not. In case there is a difference, then the fifth step, which is the most complicated step, is to determine, without the knowledge of the claimed invention which is being examined, whether this difference constitutes steps that is obvious to a person skilled in the art or that requires some inventive contribution. So here, while comparing a prior art, there should be some teaching in the prior art that the person will be motivated to try, or there will be a reasonable reasonable success in trying or applying those prior art to arrive at the claim invention. In case there is no such teaching in the prior art, then it will be considered it will not be considered obvious and the invention will be considered inventive. But I'll not be able to compare with examples because we are supposed to move into the drafting part. But now let's move forward to the next requirement, that is industrial applicability. So whatever is claimed must have some industrial applicability. So in case there is in a prior art, a steroid compound is known for a lot of medicinal properties, but a person goes on synthesizing a lot of steroid compounds, a lot of analogs of steroid compound, but these compounds are not showing any medicinal property. In that case, it will not be considered industrially applicable, because it will not be considered that it will be it could be made or used by any industry. So it will not be considered industrially applicable. So care should be taken while drafting the claims that whatever you claim should have some industrial applicability. Okay, now let's move forward. Now we have understand the requirement of novelty, inventive step, and industrial applicability in your claims. And in case these three things are there, the claimed invention will be considered as the claim subject matter will be considered as an invention, but it will not be considered patentable in India if it falls within the provision of section 3 and 4. Let's very briefly discuss what these section 3 and 4 provides and how to exclude such type of things in your claiming. So first, section 3 says anything that is frivolous or that is contrary to the well-established natural law is not patentable. So a machine that could give output without input, a machine that could work perpetually is not patentable. Section 3b says primary intended use or commercial exploitation of something that is contrary to the public order or morality, or that causes serious prejudice to human, animal, plant life, health, environment will not be considered patentable. So a device to commit theft or burglary is not patentable in human. Cloning is not patentable in India. Section 3c says scientific principle, abstract theory, discovery of living and non-living substances occurring in nature are not patentable. So Newton's law, discovery of plant, animal, microorganism, mineral, metal from earth crust are not patentable. Isolated sequences from microorganism or animals which are existing in nature are also not patentable. Now, moving forward to section 3d, it says that mere discovery of new form of a known substance that doesn't result into enhancement of known efficacy, mere discovery of new property or new use of a known substance, mere use of a known machine, process, apparatus, unless there is a new reactant or it leads to a new final product. So there are basically three components in it: new form, which is where there is no enhancement of efficacy; new use, and mere use, where there is no of a process where there is nothing new is employed or nothing new is being produced. So there is an explanation to this section. To actually explain this particular section, it says that salt, ester, ether, polymorphs, and all these will be considered the same substance unless they differ significantly with respect to efficacy. So when you are drafting such a claim, there should be such data in the specification that could show efficacy over the existing form. So in case a amorphous form of a compound is known, you're claiming the claim is over a polymorphic or a crystalline form. In case this efficacy is not demonstrated, it will not be considered patentable. In case a particular compound is known for analgesic property, now antidiabetic property is being discovered, so it will also be not considered patentable. Then okay, now let's move to section 3. It says mere aggregation or mixture of components are not patentable. So if it is just an admixture, it will not be considered patentable. If the claim is over a composition, there must be something synergistic in it, and the specification should provide the support for such synergism in terms of data. That A is, in case the composition is A plus B, A is giving some effect, B is giving some effect, A plus B should be giving some surprising effect, so that this composition will be patentable. Mere arrangement, rearrangement, or duplication of devices that could function independently of one another in a known way are not patentable. So if bucket fitted to a touch is not patentable, but in case you are combining two devices and they are combined in such a way that when they are combined, they act in a different way than their known way, in that case that it will be considered patentable. Agricultural and horticultural methods are not patentable. It's section 3I says medicinal, surgical, curative, prophylactic, diagnostic, therapeutic treatment of human being, similar treatment of animal to render them free of disease or to increase their economic value or of their products are not patentable. So removal, surgical procedure, removal, cancer, tumor, vaccination methods are not patentable. Detecting a particular marker which ultimately detects a particular disease is not patentable. Method of treating sick to increase the wool or production, or method of treating poultry to increase its body mass is not patentable because it is increasing their value or the value of their products. 3J says plant, animal as a whole or part are not patentable in India. Other than microorganism, an essential biological process for production of plant and animal are also not patentable. It says other than microorganism. It means microorganisms are patentable, but this section is always read with section 3C, which says naturally occurring substances are not living substances are not patentable. So naturally occurring microorganism is not patentable, but a genetically modified microorganism, it is patentable. Mathematical business method, computer programs are not patentable. Literary, dramatic work, artistic work are copyright protectable but not patentable. Mere scheme or performing mental act, playing game, presentation of information, topography of integrated circuitry. There is other type of IP protection for it, but it is not a patent. Patent protection cannot be provided over it. Invention which is in effect to traditional knowledge, or which is aggregation of traditionally known components or traditionally known properties of those components is also not patentable. So TK based inventions are not patentable in India. So these are Okay, these are the list of things which are not patentable under Section 3. And Section 4 says that invention relating to atomic energy, which falls within the provision of Section 21 of the Atomic Energy Act 1960, is not patentable. This section says that no patent shall be granted if it is in opinion of the central government, its use or the use relate to production, control, disposal of atomic energy, prospecting, mining, extraction, physical, chemical treatment, fabrication, etc. of prescribed substances or radioactive substances. They generally publish which are the which should be considered the prescribed substances and radioactive substances. They are published or notified by the Department of Atomic Energy. And if the invention relates to that, it will also be not considered patentable in India. So by now we understand what are not patentable in India. So now let's move forward to the next important requirement, that is sufficiency of disclosure. So it means Section 10(4) says that whatever is provided in the complete every complete specification shall be fully and particularly describing the invention, and the best method known to the applicant should also be described. In case it uses a biological material where it could not be fully particularly described or the best method could not be described, then it is not available to the public, then it has to be deposited in an international depository authority under the Budapest Treaty. And this deposition should be done before the filing of the patent application. All the available characteristics to identify that biological material in the name and address of the depository and date and accession number should be provided in the specification, and source and geographical origin should always be provided in the specification. So now coming to the patent specification. Keeping in view these technical requirements for a patent, the patent specification should be drafted accordingly. So you must all know that a patent specification is not a document, just a document. It's a techno-legal document. It describes the technical aspect of the invention, and it should be described in such a manner that all the legal requirements should be fulfilled. And both of them are very essential for grant of a patent. When I'm saying technical aspect, it means in case you are describing a product, so each and every feature of that product, how it is to be prepared and how it is to be used should be described. This is called the technical aspect of the invention. But whatever you are describing under the technical aspect should also fulfill the legal requirement. And what is the legal requirement? It should be novel, inventive, and industrially applicable. It should not fall within the provisions of Section 3 or 4. It means it should not be non-patentable in India, and whatever is being claimed should be very sufficiently disclosed in the specification. Now let's see what are the components of a provisional specification. First of all, why a provisional is filed? Provisional is filed to secure an early filing date. So it should describe the invention. Claims are not required in the provisional specification, but one should keep in view, keep some key points are here are, that should be a description of the invention as much as known to the applicant, and the description should be written. Providing only a diagram could not be sufficient for a provisional application. And because the benefit of this prior filing or benefits of this early filing could only be achieved if the subject matter which you are going to subsequently claim in the complete specification is actually covered in the provisional specification. If it is not covered, it will not fulfill that purpose. So the elements of the provisional specification are that there should be a title, the field of invention should be mentioned, whatever prior art relevant known to the applicant and what are the drawbacks of the prior art should be mentioned. A brief summary should be provided, brief description should be provided, what is the invention, and some working example that the invention is actually working. It should be provided. Drawings are not essential, but if required, it is required to be provided. Okay, now let's move forward to understand what are the components of the complete specification. First and foremost, complete specification could be filed directly with a patent application, or in case the patent application is filed with a provisional specification, the complete specification should be filed within 12 months from the filing of the provisional. And it should provide the detailed description of the invention with claims, and you should keep in mind that the patent office examines the complete specification. Provisional is not examined. So let's see what are the components of the complete specification, and subsequently we will see how to draft these components. First and foremost, there should be a title. It should be within 15 words. It should convey what is the invention is. Then the field of invention, which should provide to which the invention which field the invention belongs. Then the background of invention, it means the literature relevant prior art known to the applicant should be mentioned in the background of invention, and it should be followed by an objective of invention, which the objective should always be to solve the problem existing in the background of invention, which should be followed by a summary of invention. It is generally exact a full outline of the invention and how the problem of the prior art is being solved. Then the detailed description should be provided. It should be provided with working examples for each and every embodiment. And then the claims are provided. Claims are the most important part of the complete specification because it determines the scope of protection the patentee gets once a patent is granted. So claims should be very wisely, judiciously, and skillfully drafted. And drawings, if required, should be provided, and it should also be, and an abstract should also be provided, which gives a summary briefly a summary of the invention. Okay, so now let's move forward to the first part of the specification, that is the title of invention. So the section 10.1 says that every provisional and complete specification shall start with a title, shall begin with a title, and the title should not be more than 15 words. So it should be very brief, but it should be conveying whatever is there in the specification. So it should be technically relevant as well, and it should be consistent with whatever you are claiming. So making it consistent, let's take an example. In case the claim in a particular patent application, the claims are, there are three independent claims. First claim is a substituted pyridine compound of Formula 1. Second claim is a process of preparing that pyridine compound. Third is a pharmaceutical formulation for comprising that pyridine compound. So these are the three independent claims. So ideally the title should be a substituted pyridine compound, process for its preparation, and formulation thereof. So it should cover whatever is there being claimed in the patent application. In case the invention is about a process, some processes are already known, but the claim process is some improved process for preparing a compound or something which is an antibacterial agent. So an improved process for preparing a compound useful as an antibacterial agent could be considered as an ideal title. In case the invention is a device or an artificial limb to which an alarm is attached, and the alarm shows that when the maintenance is required. So here an artificial limb with a maintenance alarm could be an ideal title, but one should always avoid to use very generic, very broad title. Compounds and salts thereof, novel formulations are something to be avoided in the title, because it is not conveying what is there in the patent application. Okay, now moving forward to the field of invention. Field of invention is the first part of the specification. So it should first convey the general field of invention, and then which specific field it is referring to, and it should be very clear and brief, because this part of the specification helps the patent office in allotting the application to the concerned examiner and controller having expertise in this particular field. So the broad field of invention and specific field of invention should be provided in brief but in clear terms. Let's say the claimed invention is about a natural herbicide, a particular compound which is a natural herbicide. So the field of invention should start with present invention belongs to a field of natural herbicide, and subsequently the present invention particularly relates to this particular compound or 10 toxin compound which is to be used as a herbicide. In case the claimed invention is a system and device or system or method of monitoring a gas concentration in a cylinder which is attached to a an ambulance, and it is being monitored by cloud method. So the field of invention should say that the present invention broadly pertains to a method, a system and method for monitoring gas concentration, and it specifically or particularly relates to a system and method for measuring oxygen concentration in a cylinder that is attached to an ambulance by cloud method. So this should be written in such a way. So it should basically be written, the way should be the present invention relate or concerns to or pertains to this general field, and it also relates to this particular field of this particular field of the technology. Now let's move forward to background of invention. The PCT applicant guideline says background should provide the background art as much as known to the applicant, and which should help in understanding the invention, searching prior art for that particular invention, and also examining the claimed invention. And in case required citations, which what are being referred by the applicant, the citations of that should be mentioned in the background of invention. So basically, the background, while drafting a background of invention, it should be divided into 4 parts. First part should provide the general state of art, general background of the invention, focusing on a particular problem. And the second, and it should be followed by the second part should say that what are the prior art, existing prior art that is trying to solve that problem. And the in case it is a patent application or a patent, that patent application number or a patent number should be provided. In case it is a journal article, that journal article should be provided. So it could be written that reference is made to this patent application where this is described. Reference is made to this particular disclosure in this journal article where this is described. So this part is to be written in that way. The next part of the specific of the background of invention should be the problem that is existing in these prior art documents. It means what are the disadvantages of this prior art document. And in the fourth part, it is the last part of the background of invention, should establish the need of your invention. It means your invention should be in a position to fulfill the disadvantages of these existing prior art. So that should be summarized in the last paragraph of the background of invention. Okay, now let's move forward. The next is the objective of the invention. Now the applicant has already established what is the field of invention it is relating to. He's talking about what are the existing prior art and what are the and his objective of this invention is to solve those disadvantages that is existing in the prior art. So what is the aim of the invention has to be provided. The aim should be solving the problem of the prior art. Then it should be provided in broad terms. Broad objectives are to be provided. One should avoid providing narrow objectives. In case you provide narrow objectives, the application would be construed or seen in a very narrow picture, or it should be very restricted. So it will be interpreted in a narrow sense or a restricted sense. So it should always be kept broad. For example, in case the claim is about a compound for treatment of disease X, and there is a process for preparing that compound, and there is a formulation with that compound. But the objective of invention should only mention the main objective of the invention is to provide that compound for treatment of disease X. That compound need not be described here. The objective of the invention is to provide a process for preparing this compound. The steps of the process should not be described here. And the last part should provide a pharmaceutical formulation comprising this compound, and the formulation components of the formulation should not be described here. It is only the objectives of the invention, because all the description are to be provided in the subsequent part. Now coming to the summary of invention. Summary is actually provide a full scope of the invention. It's a full outline of the invention, you may say, and how the problem in the prior art is being full solved. So it should cover the subject matter of all the broadest claim. It should cover all the subject matter of all the independent claims, all the dependent claims, all the alternatives. It means all the embodiments and what is the disadvantages or how the problem in the prior art is being solved. So when I'm saying embodiment, in case there is a product, there are 4 components of it, and one component, let's say if the 4 components are A, B, C, and D, this B component could be B1, B2, B3. So different types of product could be produced with one product with A, B1, C, and D, another product with A, B2, C, and D. So all these embodiments, these alternatives are called embodiments of the invention. So all these embodiments should be described in the summary of invention. And at the closing of the summary of invention, the applicant could say that whatever is being summarized here could be better understood by the detailed description and the claims which is following. Then before the detailed description, there is a section which is called brief description of drawing. Here I want to mention that providing drawing is not mandatory. But in case it is required to understand the invention, or in case it is required by the controller, it has to be submitted. And drawing is a part of the specification. It is counted in the pages of the complete specification. And the drawing should be provided at the end of the specification in separate drawing sheets. And these sheets, and it should not be provided embedded in the specification itself. It should be provided separately. And the title of these drawings, listing of these drawings, which we call the brief description of drawings, are to be positioned just before the detailed description of the invention. So the drawings which you are providing should only refer to specific working or when it is required to compare the invention with a prior art. But for generally describing something, for general describing a general principle, drawing should not be used. One should not add drawing for general description of the existing prior art. Only those for where you can show that this compound is showing this much effect, this particular device is showing this much effect, that is only to be provided in the drawings. So how this brief description of drawing is to be written? First, the figure number is to be written, then what the figure represent is to be written, then if it is a photograph, line diagram, graph, it is a flow sheet, what is the type of drawing it is required to be written. In case it is a mechanical case and there is a visual perspective to it, it means if it is a side view, top view, cross-sectional view, so it is also required to be mentioned. And for example, figure 1 is a diagrammatic representation of device A. Figure 2 shows a cross-sectional view of device A provided in figure 1. So these are the examples. But drawing in the entire scope of the specification is generally not construed or narrow down to whatever is provided in the drawing, but a statement for to avoid such an interpretation should also be provided after the brief description of the drawings. Then now coming to the detailed description of the invention. So this is a very important part of the specification. The all other parts are not that much read or not read that much relevant, but detailed description is very relevant to provide support to the claims. So I want to go back to this particular section of the Patent Act 1970. It says that the complete specifications are fully and particularly describe the invention and also disclose the best method of performing the invention known to the applicant for which he is claiming protection. So it should be, it means whatever is being claimed should be fully and particularly described. And let's see how it has to be done. In case a apparatus is being claimed or a product is being claimed, each and every part of the apparatus, each and every component of that product should be described. How they are interrelated with each other, that has to be described. How they work when they are interrelated with each other, that is to be described. Next step, in case the claimed invention is a process, so all the process, entire process steps are required to be described. Then what is the starting material, what are the intermediate steps in case there is an intermediate being produced in the process, and how it is resulting into the final end product. Each and every step are required to be described. Each and every parameter or temperature or required temperature, pressure, what are the other requirements to carry out these process steps are also required to be described. In case the claimed invention is a product, its chemical formula, structural formula, process for preparing it, process for identifying it, characterizing it, and the process to use it should also be clearly described. And finally, all the alternative embodiments, as I have mentioned, embodiments means how alternatively this same invention could be carried out. So how these alternative elements could be carried out, that should also be, it means each and every embodiment of the invention should be described in the detailed description of the invention. Let's take an example here. In case the claimed invention is a composition of A, B, and C, is a composition of matter that comprise A, B, and C, then each and every part of the component is to be described. Let's say that the first part is A. So what is A? What are the different types of A? Its chemical formula, size, molecular shape. If it is a device, how it is to be? What is the dimension? What is exactly it is? How it is shaped? It is to be described. Then the preferred types of A are also required to be described, which is specific for your invention. Then what are the suitable methods of obtaining A, whether it is sourced from a market or a trader, whether it is being produced by the applicant himself in the claimed invention, that is to be described. What is the suitable amount of A for its given effect is to be described. Its functional definition, quantitative definition in relation to A, B, and C are also required to be described. And similarly, same thing has to be repeated for B and C as well. Then in the second part, how let's say A and B is combined first, then C is added to it, or A and C is combined and B is added to it. So how A and B are combined, their relationship, it means whether there is it is only a mixing, or there is a chemical reaction happening, or there is a emulsion formation happening. In case it is a device, how they are attached to each other, are they clamped, are they fixedly attached, are they removably attached? All these things have to be mentioned. Then what are the reaction condition? In case there is a reaction happening, what are the reaction condition? What are the methods used in combining A and B should be described. And once A and B are combined, what is the function, what is the definition of this attachment should be clearly mentioned. It means, are they separable? Are they not separable? In case there is a chemical reaction, whatever is being formed cannot go back to what the reactant. So, and in case it is there is a complex formation, or whether this attachment is through a ligand where A and B is attached through a particular ligand. So all these are to be described, and same has to be repeated for the with component C. In case A plus B is produced, when A plus B is mixed with C, all these steps, all these elements are to be described. Then in the later part of the detailed description, how it is to be provided, how it is to be presented is to be described. In case A and B and C are to be packed together, are they are to be provided in a tablet form or a capsular form, or what form it has to be, it is coming out as a product is to be described. And what is the use of this particular final thing is to be described, which is most important part, because it will help in justifying inventive step of your claim. So how A plus B plus C is giving a particular activity which is novel and inventive, that has to be described. So the basic purpose of such a detailed disclosure, and whatever I have mentioned, and for each and everything, working examples should always be provided. It means one should see the working example and know that whatever is being claimed is actually prepared by the applicant. And now the purpose of this is that such an elaborate description in the detailed description is required because it provides sufficiency of disclosure to whatever is being claimed. So how to determine it? First, whatever you are claiming or whatever is the scope of claim, that is to be determined. And second, to ascertain whether the whatever is being described commensurate to that scope, so that the person skilled in that could carry out the invention without any undue experimentation being required. In case there is an undue experimentation required, then the description is not sufficiently disclosing the claimed invention. Now let's take an example to understand it. Here, the claimed invention is this compound of Formula 1. So here there are four variables. Let's focus on this. R1 could be phenyl, pyridyl, thiazole, thialkyl, alkoxy. These are the variables claimed. And this is a detailed description where all the compounds of Formula 1 are prepared, where R is only phenyl. There is no other R could be there. So in this case, this particular, the claim is comparatively much broader than what is being disclosed. So there is a lack of sufficiency of disclosure in this case. So while drafting the claim and while drafting the specification, one should take care that whatever is being claimed should be sufficiently supported. In case you write a lot of things in your claim, but there is no support or no working example in the description, then that part of the claim is going to be struck out or removed from the claim when the application goes to examination. Okay, now coming to the claims. As I have mentioned, claims are the most important part of the complete specification. Section 10(4)(c) of the Patent Act 1970 says that complete specification shall end with claims, or one claim or more than one claim, and which provides protection to the invention. So claims, as I have already mentioned, is the most important part of the specification because it determines the scope of protection the patentee gets once the patent is granted. Let's say you have a property, you have a physical real property, you put boundary against it. So similarly, claim is a boundary against around your invention. So claims are the legally operative part of the entire specification. It means whatever you write in the specification, everything, but whatever is there in the claim is your legal right. So what you are not mentioned, what is not mentioned in the claim is considered disclaimed. So one should be very careful while writing the claims. And claims are a very relevant part of the specification because it is always referred in different stages of the patent's life. So when the examiner examines a patent application, he checks the claim and he compares the claims with the prior art document to see whether it is novel, inventive, and industrially applicable and patentable or not. When this particular application goes to litigation or there is an infringement of it, the court checks whether the infringing product elements are there described in the claimed invention or not. And when your invention is getting licensed, the licensee wants to check what is actually granted to you in your claims. So claims are the legally operative part of the specification, and there should be one or more than one claim in a specification. Claim should be one single sentence. There may be different elements in a claim, but it should be one sentence, end with a full stop, and it should define the matter for which the protection is sought. It should be clear, concise, and supported by the description. So these are the basic requirements of the claim. Now let's see what are the different types of claims. First and foremost, you must have seen by now what are the patent specification, how it is written. So there are basically two types of claims: independent claims and dependent claims. Independent claims are those claims which doesn't depend on anyone. They are standalone claims. So they should be the broadest claim of the specification. All the essential features of the claimed invention to satisfy the legal requirement of novelty inventive step should be there in the independent claim. Unnecessary features should not be added in the independent claim, and in case there are more than one independent claim, they should fulfill the requirement of unity of invention. It means they should relate to one invention or a group of invention linked by a single inventive concept. So and another type of claim is a dependent claim. These claims are those claims which depend on independent claim or another dependent claim. So when we say an dependent claim, it means it includes or it brings on every feature of the claim on which it is depending. So all the feature of the independent claims come into the dependent claim if the dependent claim is depending on another independent claim. So these claims are generally used to describe or claim the specific embodiments or the preferred embodiments of the invention. So in case a process is in case there is a process where let's take this example here. The claimed invention is a polyurethane microcapsule for sustained release of an active ingredient. There is a core that contains the active ingredient, and around the core there is a polymeric cell, and the polymer consists of diol aliphatic diisocyanate cross-linker and an additive. So this is an independent claim. And now this second one is a dependent claim. It says the microcapsule as claimed in claim 1, wherein the diol is selected from the group consisting of butane diol or propane diol, etc. So here this is the independent claims and this is the dependent claims. All the feature of the independent claim is considered incorporated in this dependent claim, and it is further restricting this diol to butane diol, propane diol, butane diol, hexane diol, etc. So it is a preferred feature of the claimed invention. This is the broad feature of the invention and this is the preferred feature of the claimed invention, or you can call it a preferred embodiment of the invention. Okay, now let's move forward. How an independent claim is to be drafted. Basically, generally, the independent claim contains three parts: preamble, transition phase, and body. So let's see how it is to be written. The preamble is the introductory part of the claim. So it provides the category of the invention. Whether it is apparatus, a product, a device, a method, or a process. So it decides the category of the invention. It is generally written in a single noun phrase, but sometimes modifiers, pre and post modifiers are added. So an apparatus. And in case the invention is a rice cooker, the claim is an apparatus for cooking rice. Now the applicant thinks, why cooking rice? It could cook grains as well. So an apparatus for cooking grains. And now he thinks that why cooking grains? It could cook anything. So an apparatus for cooking only. So now these are three preambles, but apparatus for cooking is the broadest, apparatus for cooking grain is the comparatively narrower, and apparatus for cooking rice is the narrowest claim in when we see these three claims. So pre-modifiers and post-modifiers are to be used very judiciously because it decides how broader the protection could be. Then the transition phase is the phrase that link the preamble with the body. So the transition phrase could be an open-ended phrase or a closed-ended phrase. Comprising, including, containing are generally considered open-ended phrase. It means whatever is written there in the body, there might be other elements present. So it is they are inclusive and not exclusive. And close-ended phrases are consisting of. You can say consisting of. It means whatever is there written in the body, there could not be any other possible component in the claim, in the final product. For example, the claimed invention here say the apparatus comprising a pencil having an elongated structure with two ends and a center, and an eraser is attached to one end of the pencil and a light is attached to the center of the pencil. So this is a claim over a pencil. So here it is written comprising. It means there could be other features as well. So it is a broad, and in case we replace this comprising with consisting, it means it is claiming a pencil that has only these features. Other features are not there. So it is advisable to draft the claims with open-ended transition phrase like comprising, not close-ended transition phrase like consisting. Now coming to the body of the invention. Body of the invention is the part which contains the elements of the invention. It means and how they are linked to each other. For example, if the claim invention is an apparatus for holding a holding item, it is a claim for a table. It is an apparatus for holding item. It contains at least one leg and a top that is configured to be supported by this particular at least one leg. So here the body of the elements of the invention are at least one leg and a top, and the connection between them and how they are to be connected, it is to be configured to supported by one leg. So this is the body of the invention. This is how generally the independent claims are drafted. Now coming to the grammars and punctuations. So when you are writing a claim, the preamble should be separated from the transition phrase by a comma. The phrase should be separated from the body by a colon, and elements of the body should be separated by semicolon, and last but one element should be separated from the last element by a semicolon followed by a phrase word and. So here, for example, an apparatus, comma, an apparatus is a preamble, comprising is the transition phase. Now it is separated from the body by a colon, and these are the elements of the body. It means a plurality of printing pages, binding configured to hold these pages, and a cover. So this is the penultimate or the last but one element, so it has to be followed by a semicolon and the word and the final element, and it should stop with a full stop. So this is one single sentence. There is no specific law in many jurisdiction about it. There is no specific law how to give the punctuations, but one should be doing it because the claims are interpreted in different stages of its process. So if you want your claim to be interpreted the way you want, the way it is intended, or the way it is drafted, the way you intend it to be interpreted, then these are essentials. For example, the claims are interpreted by the examiner while examination. The claim, in case there is a litigation, the claim is going to be interpreted by the courts, and in case there is a license happening, then the licensee will interpret the claim. So you will not be there to explain what you intend to claim. So if you want, the claim should be interpreted the way it is actually intended to, so it should be written in that way. Okay, now let's move forward to see what are the different types of claim that could be drafted in different circumstances. The first and foremost is the two-part claim, or which we call Jepson claim, or we call improvement claim. In case there is a close prior art, then such type of claiming should be done. In case you want to claim a lot of elements in one claim, then it is called alternate elements claiming or Marcos claiming. In case you cannot describe something in terms of its chemical composition or structural form, then some functional elements could also be added, and sometimes means plus function claims are also drafted. I'll come to these things in my subsequent slide. Let's take the first one here. The two-part claim, improvement claim, or which we call Jepson claim. So these type of claiming is done when there is a closer prior art. So in this claim also there are three components: preamble, transition phrase, and body. But the preamble here is a statement where the applicant himself admits that whatever I am writing in the preamble is known in the art. Then the novel feature is there in the body. Novel or improved feature is there in the body, and it is to be linked by a phrase or the transition phrase, which is called which could be characterized by, characterized in that, or where the improvement comprises which is followed by the body. For example, here the claimed invention is a pencil with an eraser attached to one end. Characterized in that a light is attached to the center, and here the pencil with an eraser, it means when you write such a claim, it means pencil with an eraser is already known in the art, and the novel feature is only the light being attached to the center of the pencil. So this type of claiming should not be done while drafting the specification. You should not be drafting the claims in such a way. A normal standard claim which I have just discussed, it should be written in that manner. But in case there is a very close prior art, you may amend your claim to this format. And one more thing, when we in case you all you can in case you apply this type of claiming to all types of invention, it is not applicable. It is not suitable for certain types of invention. In case you forcefully apply it, it will distort the existing prior art, and it will also make a misleading picture of your claimed invention. So this is not applicable in case of a composition or combination where the invention lies in combination. It is also not applicable for those processes where invention lies in different steps of the process. It is not also applicable where you are claiming something, a complex system where the invention lies in their interrelationship or the complexity, or you are trying to claim a lot of things or a lot of compounds in a single claim. So in that claim, in those circumstances, two-part claims are not advisable. Now let's move forward to understand how many multiple exclusive alternative element could be claimed in one claim. When such a claiming is done, it is called alternate element claiming or Marcus claiming. So basically, it is the general thing is it is generally written that selected from a group consisting of something. So in case you are wanting to describe A, so A is selected from the group consisting of X, Y, and Z. So A could either be X or be Y or be Z. But A could not be X plus Y or X plus Z or X plus Y plus Z. In case you want it, you should write that A is selected from X, Y, or X, Y, and or Z, or a combination thereof. In that case, X, Y, Z could also be included in the definition of A. So this type of claiming is generally done in case of chemical cases where alternative elements, in case of chemical process where alternative steps are to be claimed, or in case alternative parameters are to be used. When a lot of alternatives are required to be claimed in one claim, this type of claiming is done. Let's take an example here. This is a chemical compound. There are a lot of variables, and let's say the D is a variable. D is C. It means carbon attached to a R group. The R this R could be selected from XYZ. So it will cover all those compounds where D is C attached to X, attached to Y, and attached to Z. So in one claim, we are claiming everything. So this is called a Marcus claim. Okay, now let's move forward to a functional element claim. Sometimes claims are required to be defined in terms of components of the claim are required to be defined in terms of its function. Sometimes it is not possible to describe its chemical feature or its structural feature. And this is allowable only if this functional feature could be carried out by a person skilled in the art that should not require some experimentation. So when you say you are adding an oxidizing agent as a term is not a chemical term. We are not mentioning what is the oxidizing agent. It is actually a functional term because it is covering every possible thing that could be used for oxidizing something. Pharmaceutically acceptable excipient. It means we are not actually describing the excipient. We are actually describing whatever could be added which is pharmaceutically acceptable to a body. A solvent. We are not describing what the solvent is, but we are describing anything that could solubilize this. So these are functional terms. Sometimes this type of elements could be described in its functional terms. Means for plus function claims are those claims where the structural feature of the means or something, they are generally used for mechanical cases where a particular part is being used, but its structural feature is not, it should not be one structural feature. A different type of structural feature could be added there. For example, in case an apparatus for harvesting, so it comprises a means for holding crop and a cutter for cutting the crop that is holded by the means. So means here could be a metallic bracket or could be a belt or could be anything. If we write here that means is it means metal bracket for holding crop, then your claimed invention will be very narrow. So writing means for holding crop and subsequently providing what could be the alternative ways of providing these means could be a better way of drafting such a claim. Okay, now some principles to draft claim. First and foremost, you should determine for matter for which the protection is sought. So all the technical feature should be mentioned in the claims, and it should be supported by description. One should remember that no new matter could be added once a patent application is moved to the prosecution stage. So it should be drafted in such a manner, and the specification should also be drafted in such a comprehensive manner so that in case there are amendments done to the claim, your specification should be there to provide support to such amendments, and also it will provide a broader protection to your invention. Second is to identify what you are exactly wanting to claim. Is it a product or a process? And the preamble should start with a product or a process. When you say a compound, composition, apparatus, device, machine, they are all product claims. When it is written that a method of doing something, process for doing something, these are process claims. In case the claim invention says a process for something, then the product is described without describing the process, then it will not make the claim a product claim. It will remain a process claim only, and there will be objection on clarity about the process steps. So in case you are claiming a process for preparing something, it should start with a process as a preamble. In case you are claiming a compound, it should start as a compound. In case you are claiming a composition, it should start as a composition. So categorizing your invention and understanding what you actually want to claim and drafting your claim appropriately is also very important. Then next principle is that when to use two-part claim. As I have already mentioned, you should draft in normal claim in a normal standard manner, but in case there are some prior art cited by the patent office, in that case you can revise or amend your claim into a two-part or the Jepson claim, where you have to mention the preamble is the prior art, which is separated by characterized by etc., which is a transition phase, and then the novel feature is to be there in the body. But it should be drafted when there is a very close prior art existing. Then your claim should be broadest and strongest. So depending on the word you choose, the claim, the broadness and narrowness of the claim is decided. In case the claim invention is very broad, then there could be a lot of prior art document, and the claim invention might not be considered novel. In case in case it is drafted in a very restricted manner, in that case you may not be getting a lot of prior art document. You may get a grant, but your claim scope of your claim will be very narrow. Now coming to the another important principle is that you should be in the claims should be provided with sufficient dependent claims, claiming the specific embodiments, specific feature and preferred feature of the invention. Whatever is there in the independent claim is a broad claim, but whatever specific feature where actually the invention has been carried out, what are based on the best working example, specific embodiment in by way of dependent claims should also be provided while drafting claims. Marcus claim should be used where you want to claim a lot of alternative in one claim. As I have mentioned, Marcus claim could be used, and it is generally used in case of in chemical field. And of course, when you are drafting the claims, all your claims should relate to one invention or a group of invention that is linked by a single inventive concept. So in case we have three claims. Compound A, which is an antibiotic. Compound B, which is a bioactive compound which act as an antibiotic. Compound S, which is a steroid, but it could act as an antibiotic. Here A, B and steroid, all these are structurally different. So there will be a lack of unity. So it cannot be granted in one patent. But in case there is a particular compound which is being prepared, which is treating a particular disease, and this compound, the claim 1 is a compound of that formula 1, and claim 2 is a process for preparing that compound of formula 1, and claim 3 is a device that is configured or that is modified to carry out that process to prepare that formula 1. In that case, they are all linked by a single inventive concept, and that is the inventiveness of the compound of formula 1. So they will be considered linked by a single inventive concept, and they can be granted in one patent. So while drafting your claims, you should be very mindful about it. Now coming to the abstract, abstract should provide every specification, every complete specification should be accompanied by abstract. The abstract should commence with the title. The title should be provided just before the abstract. It should be a summary of the invention, the technical feature, technical advancement, and principal use are to be mentioned in the abstract. Speculative things should not be mentioned in the abstract. It should be within 150 words. And one should keep in mind that previously abstract were only digitized or were available in the searchable form. So abstracts were very important because they were being used for search or reaching at a particular document. Nowadays, every part of the specification is searchable. Now coming to the drawings, as I have mentioned, drawings are not mandatory, but if it is required to explain your invention, or if the controller desires or requires the drawing to be provided, it must be provided. So drawing should be accompanying the specification. It should not be embedded in the specification. Drawing are to be provided in a separate sheet. If separate sheets of drawings should be provided at the end of the specification, they should be clearly and neatly prepared in A4 size paper, 4 centimeters on top and right side hand, and 3 centimeters on bottom and left side hand should be left blank, and it should be sufficiently large and legible to understand, and they should be in a sequential manner. It means figure 1, figure 2, figure 3. It should be like that. And in the seat at the top head corner, the applicant name is required to be written. At the top right corner, total number of seats and the exact number of seat is required to be written, and bottom right corner, the signature and details of the applicant or agent is to be provided. So this is how the drawing is to be drafted. So I think I have already covered all the part of the complete specification, and basically the claims, how the claims are to be drafted so that it could be considered novel, inventive, and industrially applicable, and it should not fall within the provisions of section 3 and 4 in case you want a patent to be in India. In case your claimed invention is a particular compound or a composition or a device, providing its working or a method of using that compound or a method of treating something, instead of such claims, you should be providing specific embodiments or preferred embodiments of the claim process or product in your dependent claims. And I think I have covered all the components of the complete specification and how they are to be drafted to fulfill the technical requirements to get a patent granted. And these are some of the references which were used in preparing this particular presentation. And here I conclude my presentation, and I'll be very happy in case there are some questions.
Dear participants, if you have any questions, you all can discuss with ma'am now.
So you can raise your hands, and in case there is something not understood, you can ask some questions. So interaction in such a webinar is generally required. Otherwise, the connectivity is sometimes lost, I think. In case there are no questions, should we conclude? Hello, am I audible?
Yes, ma'am.
In case there are no questions, should we conclude?
Greetings to everyone present here, including our distinguished chief guest, Dr. Lipika Patnaik, and all participants. I extend my sincere thanks to our honored chief guest, Dr. Lipika Patnaik, for taking time from their busy schedule to grace the occasion and enlighten all of us with innovative ideas on patent drafting.
Thank you very much.
Your words of inspiration and encouragement on this special day are greatly appreciated, ma'am. My gratitude also goes to Dr. Manjunatha BK.
Thank you very much for this, for giving me this opportunity. In case there are any questions which are not being asked here, and it could be mailed to me, I'll be very glad to answer. Thank you so much.
Thanks, Trinan. Just to repeat what you heard from the person who introduced, what I do for living, what I do for my passion is to invest in startups. Our focus is to invest in startups on campuses for different reasons. We, our experience suggests that some of the best of the minds that India has is concentrated around undergrads, and we want to help these bright students become entrepreneurs when they are still in colleges. So that's why we created a fund specifically focuses on startups by the students, and we have invested more than 30 startups. Other than that, we also have a not-for-profit to make this happen. In the sense, while we wanted to fund, we realized that not many students or faculties are able to innovate right. They're not able to spot the right problem, and there is lack of understanding and awareness in terms of what kind of startups that they should invest into. Considering this challenge, we started a not-for-profit, which is organizing credited courses for the students and faculty development programs to help students and faculties become better innovators and entrepreneurs. Right? That's a quick reason why I am here. Right? So let's get to the topic. Just before I start, wanted to share one more thing. Normally, these kind of sessions are best delivered offline. In the sense, these needs to be interactive, otherwise they tend to lose the importance that these sessions should have. Anyway, considering the challenge we have, let me start with. First thing that I wanted to tell you guys, right? So, of course, if you have, I have written even earlier, any questions that you have, please feel free to post it either on this chat box, or you can even Instagram it or Twitter it, when I will definitely respond to each and every questions of yours. But feel free to ask any questions in the chat box as we speak. Right. Um, so to start with, let me start with a point, right? So it is very, very important to understand how the investors work and why do they exist. Why is that investors wants to come and invest in startups, right? Is the question that we need to address before even we plan to go and think of approaching an investor, right? Of course, approaching an investors are 3-4 steps ahead, which we'll cover, but it's essential to know how do the investors work. First thing, there are a lot of misconceptions. What investors take is a part of your business, whether it's 10% or 15% or 20% of your business is what they take. That they don't want your profits, they don't want share of your revenues, they don't want to control or they don't want to come and operate your businesses. That's the last thing that investors want. All that they want is 15 to 20% of shares in your company and a way to make sure that whatever uh, was proposed to them or whatever the initial plan, the entrepreneur is in line with that plan. I mean, are putting the efforts in the plan. All of us know that the results may not be same as what we put it out in the plan, but at least the efforts needs to be in the right direction. That's what investors want. So I repeat, investors don't want control on your business. Investors don't take your profits. Investors don't take share of your revenues, right? All that they want is they want to be part of cap table or they want to own shares in companies that they believe will do extremely well, right? Because there is no profit that needs to be shared, there are no revenues that needs to be shared. For the entrepreneurs or for the innovators, there is no liabilities. There is no liability for you to return the capital, right? That's not a liability. All that you need to do is go and build your business as best as you can, and then the returns will come, right? If the startup fails, there is no liability on the innovator or the startup entrepreneur to return the capital to the investor, which is this is very, very important, because there are a lot of people feel that if I take money, then how can I give it back? You need to think like that if you go and raise a loan from the bank, because banks give loans so that you can repay them with interest. But investors don't expect you to return it like a loan. They expect you to return through equity, right? The second thing. And third one, they investors, how do they invest? How do investors make money? They make money when they can sell their shares, right? They make money. If I have 10% of shares in your company, I will make that money when I can sell that share. How can I sell the shares? All of us know there are IPOs, publicly listed stocks, right? If you build a great business and go and list it in the stock exchange, then I can go and sell my shares in the IPO. Or there are some other company which wants to come and acquire your business, right? So then I will sell my shares to them, right? Or some other investors who wants to replace me and put in more capital into the company, then I will sell my shares to them. In fact, least preferred option is founders buying my share or company buying back my shares. That's the least preferred option. So most important thing is, if I invest money, I will get the shares. How can I sell my shares, right? Whom I can sell it to, which is what is called exit in the startup term, right? So these are very, very fundamental and important thing for you, right? Let me tell you what we have done. We have invested in around 30 startups. Most of them are run by students. The chances of all these 30 startups becoming very big is low, right? So around 20% of them will fail. 40-50% of them will be moderately successful, right? Another 20% will be slightly more successful, but another 20% will be super duper successful, right? They are the Flipkarts of this world, or probably if you are technology centric, these are the Facebooks of this world. So as an investor, right, we recover the money that we have invested from a few of the startups, right? Not all startups will always be successful, right? All that we want is at least few of the startups that where we invest into will become successful. Do we know which startup will become hugely successful when we invest the money? No, because all the startups that we are investing into, we hope all of them are super duper successful. Each and every investment that I make, I hope that's my next Flipkart or that's my next Facebook. That's the intention with which we invest. But unfortunately, I mean, law of averages are the reality is not all the startups that I invest into will be successful. Some of them will fail, right? Which I am okay as an investor because, as I said, right, what I am looking at is as a portfolio across my 30 companies, can I get much better returns than what I would have got if I had gone ahead and invested in the bank or stock market. Any questions here? Please feel free to post that question in the comment box or the chat box. We'll be happy to answer. So, in summary, we invest for high returns at a high risk, which means I may not get my capital back at all, but if I get, I may make a lot of money. And we are okay to lose money at the points that you need to address, right? It's not that we want to lose money. We invest in startups where we lose money, but we'll invest in startups that have the potential to give us very great returns. But unfortunately, for some reasons, I may not be able to get back my money. Market would have changed. Entrepreneur will not be as good as I wanted it to be. Or the product didn't work. Or there was a competitor who came up with a better product. So all these are the risks that we understand and the reality of life. Okay. Now the next question is, now that I have said I have told you why I exist, what is that I am investing in? How do I decide which company to invest my money into, right? Because I get hundreds of applications each month and I can only select 2 or 3 to invest into, right? And of course, the advantage we have is we can invest in as many as we want, but still not many, all companies that we look into, or most of the companies that we look into will not get investment from our side. What are the 3 aspects that we look into? Core 3 aspects. There are many more, but fundamentally 3. The most important thing for an investor is the team, right? Who is the entrepreneur? Who is the person who is working on the idea? What is the team looks like, right? Are they committed? Are they capable? And are they in control, right? For example, let's say you are working on a deep technology product. Then I definitely expect you to have the capability to build or develop the product, and I want you to have a decent understanding of the market. You may not have necessary sales skills, you may not have necessary finance skills, you may not have necessary marketing skills. That's okay, we'll help you with that. But when you come to me as an innovator of the new technology, I expect you to understand at least 2 things. Why you are building this, what is the market situation because of which you are building this product, and B, you should know that you can build this product, right? That is the capability that we are talking about. It need not, ideally it should not. We want this to be. Ravana, can you please? Okay. Ideally, we don't expect it from one person. Just to de-risk ourselves, there should be at least 2 or 3 founders in a team. But having said that, it is not necessary. What is important is each and every person in the team are equally capable or are capable of delivering part of the core functionality that we expect in a startup. Right. What we normally see is just because you want to complete the teams, you will get 4 people. One of them will be called CMO, one of them will be called CHRO. We don't need, right? Unless you are a real expert in marketing, unless you are a real expert in HR, I don't want you to be called yourself as CHRO, right? That's not what we need. We need the team to be capable of delivering the core functions that are required for the business. So, and they should be committed, right? You can't say that I will continue to work as a professor, or I will go and take a job and my startup is my hobby or part time. That's not acceptable. You need to be 100% on your startup. In fact, we want to see 200% commitment on your startup. If you are not ready to slog a lot more than the typical employment, then you are not an entrepreneur. So we expect you to be committed. We expect you to be capable. And third one, we expect you to be in control, right? For example, we invest in idea stages, right? When you just have an idea, right? Or when you are not even sure what product to build, that's the level at which we come and invest. And we help you go all the way to getting the initial revenues. That's what we support, right? So, and we even let the entrepreneurs take the salary, etc., all those things. But we only take 15% of the equity in the company, right? Many of them come and ask us, okay, why you are taking only 15%, right? Because you are a partner, you are helping them. In fact, entrepreneur is not even investing any money. Why are you taking only 15%? The reason is any investor who will come in the future wants to make sure that the team that is working on the company full time owns most of the company, right? So other than you are an investor, right? Any other equity is considered as equity. So what investors need is a team that is in control in terms of how much equity they own, what is the kind of decisions they can take, team that is committed, and C, more importantly, team that is capable are the three most important things that investors look from the team perspective. The second thing, which is perhaps normally more important than even the team for the startup investment, is the market. Right? So if you pick up a market, how many customers are there? How large the market is that? What is the scale of that market? Are you building something which can only be used by, let's say, Karnataka government? I'm just taking an example, right? How scalable this is, how many customers will be willing to pay for this? Right? I mean, can you go and, is it a market where you can go and build a business, right? Normally, it's not very easy to build businesses around, let's say, places where there is a lot of control, let's say government. Not very easy to go and build a business, large businesses with government, unless you know how to deal with the governments, right? So we look for the market, right? Is the stuff that you are building, does it have the large market? Right? In fact, the market size is one thing that will determine what is the valuation or how big your company can be. Some of you must be questioning how come Ola, Flipkart got so much of money even when they are losing money. The answer was the market size, right? They thought everyone knows that India spends so much of money on. India has so many people who wants to travel. India has so many people who wants to buy stuff, right? That's where Ola and Flipkart were valued so high. And then comes the product offering that you have, right? Do you have the right solution, right? You have approached market will tell you what kind of problem that you have identified, right? The product or solution, do you have the right solution, right? I mean, does it really solve the problem of the people, right? And is it 10x better than the solutions that exist, right? Is it how better it is? For example, normally investors come to me and say that, oh, the competition is not comprehensive. They will not do end to end. I will do end to end, right? Or you will come and say that they don't have this feature. I have this feature. Or they're very expensive. I want to offer it at a lower cost. These are not the right answers normally for an investor. If you want to offer something at a lower cost, why you are able to offer at a lower cost? Do you have fundamentally different technology, right? For example, before YouTube, video was very, very expensive. YouTube could come and offer you video for free because they reduce the cost of delivering videos, right? So otherwise, YouTube could have come and said that I will deliver video at 2 rupees. I'm just giving an example, right? So what is the fundamental model or technology because of which you are lower cost, right? I mean, is it so differentiated that others can't follow that? Because if you are just Selling it cheap, your cost is same, but selling it cheap is not going to be sustainable, right? So these are the attributes of the product. So three things that the investors invest money into: team, market, and product, right? So there are more things, but generally these are the three most important critical things, right? In fact, I'm talking about product because I'm talking to innovators, I'm talking to campus. Otherwise, the team and product market should have been good enough for most of them to look into. But because we are talking about deep tech technology products in the university, product and solution becomes very, very important. The next point that you need to understand is that, right? So, uh, okay, I will get to that end of investors bit later. I want to touch upon the fact that your entrepreneurial journey. The first thing that you need to answer, right? Forget about investors for the time being. You need to answer these things yourself. What kind of innovator are you? What is the problem that you are solving and why you are solving that, right? I normally say, right? There are three kinds of entrepreneurs. Those who have a purpose in life, right? I want to remove cancer. I want to make people richer. I want to make sure that every kid studies. These are the people with purpose. Then there are people who find problems and want to solve this because they think this problem exists for many people. The Red Bus, the startup that we know, started because Funny faced the problem of riding on a bus. So to address this, he decided to launch Red Bus, and it's a history, right? Similarly, there is one of my student. I'm just taking one of my student. One of my student found that it's very, very difficult to take her dog to veterinary doctors always. So she created a variable for the pets, right? She had a problem, so she created a solution to address that problem. And of course, that has a huge market, etc. That's a different issue, right? So are you a purpose-driven entrepreneur, right? So I'll give you one more example of the purpose-driven entrepreneur. I have a, sorry. I have very, very interesting student from a very, very low spectrum of the society. They wanted to solve the problem of the debts for the students, right? They thought they want to solve the problem of credit for the future. So they ended up building a whole Web3 and crypto based under collateralized lending system, right? So many ideas start with the purpose. Sometimes it will start with the problems. And third one, which is very, very interesting for professors and students, right? Technology or professors, is the possibilities out of technology. I call it possibilities out of technology because these are the opportunities. I mean, people may not be, the problem may not be very, very evident, or the purpose may not be very clear, but some very, very interesting technical possibility as technology trend. You want to work on this, and then you will start figuring out what are the utilities of solving this, like superconductivity. And Steve Jobs famously say, if you had gone ahead to market and asked them what do you need, no one would have suggested him they need iPod. No one knew that something like iPod required that, but he figured out because of whatever the insights that we have, right? So normally these are the three ways to become entrepreneur, right? As I said, we do both FDP and innovation program where we do it at length to help people identify what kind of entrepreneurs that they are. But in summary, these are the three things. The next very important thing is idea and entrepreneur match. The idea that you have, why should you build it, right? Do you want to work on this idea because you are most capable of doing this, or you want to work on this idea because you are really feel for it, right? Both the answers are important, right? Idea entrepreneur match is extremely important. So when you pick up a problem to become an innovator, pick up an idea with which you will be able to connect, and pick up an idea that you are confident that you will be the right person to build the solutions upon, right? This is how you become a right investor, a right innovator. And once you identify the problem, right, or once you identify the solution or idea, then as I said earlier, you need to pick up a team. And again, I will tell you, normally it's okay not to have the complete team, but you need to have a team which is capable of delivering the core functions. What are the core functions in a startup? You should be able to go and build the technology, and B, you should be able to understand the domain in which this technology can be sold, right? So these are the very, very core functions. Next important thing could be person who has relationships in the industry to help you go and sell, or person who understands how to go and take it to the market, right? Or the next important one. Your finance, your HR, all these things come later. They are not I mean, it's not immediately required for sure. Second thing that you are, once you have identified the solution or problem, you need to figure out what is the product or problem, which you, as an idea, as an innovator, you would have figured out. And what is the market, right? Within the, I mean, for example, pet wearable that I mentioned. Pet wearable can be sold to cattle, it can be sold to dogs, it can be sold to cat owners. Whom do you want to sell it to, right? Where does your solution make sense? Or let's say they have another company called Sustify. What they do is they provide generative AI based recommendation for the packaging to go sustainable and go sustainable, right? That's one of the startup by the students. So packaging is required in all the industry, right? You require in electronics, you require in pharma, you require in FMCG. What is the industry that you go to, right? That becomes very, very important for the market or the approach size, estimating the size of the market, or deciding how your solution should take shape, right? So once you have these clarity, then you will go and build the business plan, you will build a financial plan, what would be the price, etc. But after, when you are doing all these things, you need to start thinking about one important thing. Is this fundable, right? Because let's go back to investors. As I said, you remember, investors want a high risk, high return. So they need very large market, right? They are not interested in profitability, but they are interested in growth of your product, right? How large it can get to. And when it becomes very large, how much money it makes is what they care about, right? It doesn't matter. You make 1 crore rupees and generate 50 lakhs is not going to be of interest to any investors. But if you tell me that over next 1 year or next 3 years, I will make it 100 crore business, and let's say out of 100 crore, I will generate, let's say 1 crore. But then there is an opportunity to make it 1,000 crore and generate profits of 100 crore. Then it starts sounding interesting, right? So what investors want is the scale, right? What is the scale? So is your product, right? Is it scalable? If it is not scalable, probably this is not fundable. Then what are the options that you have, right? Can you build your business only through investment? Obviously not. If you know, for example, the business that I mentioned, you will build a product that gets sold at 1 crore and you will generate profits of 50 lakhs. If I were you, I'll just go and take the loan from someone, right? Because I will just return, if I have taken 50 lakhs and I will return 60 lakhs, and 40 lakhs is the net profit which I'll enjoy with, right? No hassles, right? So many times just finding a VC or angel may not be worth it, right? Or it's not possible. Then you need to go for other alternatives. Alternatives include raising the debt, raising money from the customers, right? Or raising money from the customer, or just going and using your own savings, etc. Other options, you should explore other options. Or you can just make that, okay, I have the offering, instead of trying to invest money, let me just make it a consulting. Let me approach companies and say that I figured out a great solution, I'll work with you, I'll consult you, and I will help you if you pay me a consulting fee. So, which could be very interesting for the faculties, that's where I mentioned. So, it need not be always fundable, right? There are many other ways in which you can fund your idea. Any questions at this point of time? Okay, let me move on, right? Then once you think you have an idea which is fundable, which you can take it to investors, next thing that you need to understand is not all investors are one and the same, right? There are very few investors who will come and support you at the idea stage. Co-create, my company is one of them, right? Or you need to there are maybe Elevate or some of the government grants or your DST grants, etc. Right? There are very few people who will support you at the idea stage, right? So what we need is probably just the team, great team, and the great technology and possibilities, right? So we take very high risk because we understand what the great technology can do. That's where we come at the idea stage. We normally don't need product, we don't need market, we don't need customers, none of them we need, right? We just need a great idea and a team to execute it, right? Deep enough idea. And of course, we'll go through the same kind of, and we try to understand the business the way everyone understands, but we'll come in at the idea stage. Then you have seed or angel investor. Normally, what seed or angel investors need is you must have built a product, prove the fact that there are some customers who are happy with this, few customers who are happy with it, and this has the big potential, right? When they know that, they will come and invest, right? Normally in seed or angel investors will put in anywhere between 1 to 6 crore of money they will put in, and they will also take 15 to 20% of the 20% equity in company, and very rarely people will take up to 30% in that case, right? So that's the second one, seed or angels. But once you have the product, once you have initial customers, let's say you have around 15-20 lakhs a month kind of revenues, then there is a whole lot of investors who will say early stage pre-series A investors who will come and invest anywhere between 10 to let's say 100 crore in your business, right? So 40 crore, 10 to 40 crore in your business, and same thing, right? So the reason why they invest money is you have got the product, you have got the initial customers. Now you need to get slightly more customers to prove your model, and then get your cost point, get your team right, etc. Right? That's where the pre-series A investors come in. And once you have predictable revenue, once you have the model perfected, once you know what is the kind of scale that you can get, when you want to grow nationally or when you want to expand your business, then the regular growth investors will will invest upwards of 100 crore, will come on board, right? So what I wanted to say is not all investors are the same. Depending on the stage in which you are in, you need to go and approach the right set of investors, right? So when you are in concept, no point in going and talking to growth investors or pre-series A investors, right? So each investors will work on a given domain. Okay, one is they are specific to the stage of the company. Then there are also investors who have theses. For example, not all investors, there are investors who will only invest in SaaS businesses. We only invest where there is the technology is the differentiator. There are investors who will not invest in hardware at all. There are investors who will only invest in D2C, direct to consumer kind of brands. So each investors will have their own thesis or their own plan based on which they will go ahead and invest capital. So depending on the product that you have and depending on the stage at which you are in, you need to go and approach the right VCs, and the way you approach is by, of course, having the summary of the business plan and then sending it across to them or connecting with them through a reference contact and then closing the business, right? So these are the ways, these are some of the very, very important aspects of reaching out to VCs. I don't want to make it too heavy unless you have some questions, right? I don't want to load a lot more information, right? So please feel free to ask me any questions. Or even moderators can source it. Please feel free to ask me any questions. Otherwise, I think we should conclude. Any questions? Okay, Trinayan, how risky is investing? Investment is always risky. In fact, this is the riskiest investment, next only to gambling, right? So gambling, it's next only to gambling, right? Because when we invest money, for example, when I invest money, there are entrepreneurial risk, there are technology related risk, there are market related risk. For example, some of the best startups, when they did everything right, even then they can't be successful because of various factors. So generally investment is very risky. So normally what we do is we only invest part of our earnings into investment, right? Only part of our assets that someone has, that it will be invested into VC investment, right? So that's how even the large VC funds operate, right? So for example, there are pension funds who are sitting on trillions of dollars. They will invest 1% of their capital into venture investing, which is quite large, as you can expect, $10 billion, right? That's how most of the VC funds are funded. So investment is always risky, but when they are successful, even the returns are higher.
So, good afternoon. There is one question. How to identify my innovation is scalable in the market?
Okay, sir, that's a function of few things. One is how large is the market itself, right? How many potential customers that you have in the market, right? How relevant you are, what percentage of the customers in the market that you are focusing on can actually use your solution, right? So one is that. Second one is how large is that market itself. For example, I have a company, I own Just Books, right? So I'm sure some of you might have known Just Books, right, in Bangalore. Just Books, what it does is we lend books, right? People can request for books that they want to read. We'll deliver those books home and then bring it back whenever they're ready, right? This service is it, will all the investors think that it is fundable? May not be, because they believe only 1% of the people will actually read books, right? But when I make it, okay, I mean, this Just Books is powering libraries of all the colleges, because all the colleges are struggling because the library utilization is lower, then it becomes fundable, right? So the thing is, you need to understand the market, how large the market is. You need to understand your solution, how, for what percentage of the market your solution makes sense, and see how much money the customers are willing to pay for you. It's a combination of these three things to say whether your product is scalable or not.
Sir, I have my own question for you. See, we have a couple of innovations which rooted out of our research. But as I said, as a full-time professor in an institute, difficult to concentrate on our, in case if we take up startup as a
right,
as you said. But under such conditions, how you will help us?
Brilliant question, Dr. Manjunath, right? So we are aware of this problem, not only even for students, between their academic pressure, they need a lot more support to build this out. So we do have, I mean, normally this has been the problem. For example, in fact, I was just writing a paper. Government is investing so much of money to give you grants to do the research, and what happens after the research? Because professors don't have bandwidth, and many times they don't have capabilities, and many times they don't have even additional funds to take it to the market, right? What will happen to them? So this is the challenge that we see. We do have few models by which, if the technology or if the core research is so interesting, how can we take it over and build a business around it? We do have some models around it, which we are doing, which we are experimenting with some of the partner universities and colleges, Manjunath. But the few tips that I can give you is, if you can't, one is try to see if you can convert your research into consulting, or try to see if you can convert your research into, I mean, hand over research into some of the students who will build it as a product, build it as a startup. But when you offload your IP to someone, you should know that you should not have more than 5 or 10% in the startup, because if you think that your equity, your IP is so valuable and you want to hand it over to other one and you want to own most of it without you running it, is not going to help it, right? So structuring those deals are extremely important. But to summarize, what you are saying is challenging, and in fact, that's one of the core areas where we are focusing on. We have experimented with few and got huge success out of this. As we speak, we are doing something with SVIASA, something with PES, where there was some interesting IP which we have taken up and then converted them into successful startups or products. Okay, Pallavi is asking me, sir, can investing be easy on some devices or products? Actually, investing is very tough on devices. Okay, I mean, just to tell you, the moment there is hardware involved, the investment becomes trickier or complex. But I think it's not. I mean, it's slightly more tougher if it has the hardware, right? But it's a lot more easier when it is pure software, right? So that's this one. Sir, can investing be on simplified machines be useful? Uh, Depends on, I mean, I don't know the exact idea. I would love to know more about it. And any simplified machines which will offer point solution are becoming very, very interesting. So on what sort of products the fund will be given? Sir, Lavanya, as I said, any product that has a very large market, clarity in terms of execution, right, with a great team is fundable, right? So devil is in details. We want to know what kind of products that we have. See, as an entrepreneur, you should never start with what is fundable, right? Leave it to experts. You do innovation or you have bunch of ideas that you're really passionate about. Trinayan is asking me how many phases should we go through in order to invest in a pharmaceutical startup, right? So, in fact, I'll be very keen if I mean, I'll get in touch with your college again, right? If there are a lot of ideas around pharma, we are very keen on this. I think uh, it's, I mean, the basically the science must be proven, right? Before even you start working on an idea, the science or the possibility of you achieving the result should be proven, right? That's very, very core to this before you start. Once you know that, once you have the science proven, rest of the things can be managed. How can you attract investors to invest in our startups? I think Naitik, get all the things that I mentioned right, and then don't worry, investors will chase you, right? You don't need to attract. In fact, investors will chase you if you have a great product, great team, and if you are getting the good customers and with bit of presence on the online, investors will chase you, right? It's our duty. Right. Any other questions?
Sir, one more is there. In the market, we have one product called Oil Zapper. Oil Zapper.
Ayu Zapper, okay.
Oil Zapper. It is a product of Terry.
Okay.
Which aims at remediating hydrocarbons.
Okay.
That is the only product in the Indian market.
Okay.
And we have developed a similar product in our lab.
Okay.
Then how to go about it? It is funded by BIRAC and it is patented, and patent is granted also. We are looking out for the investors.
So, Manjunath, I can't answer right now because, see, normally, I mean, as I said, I need to understand what is the market potential and what is the defensibility of this, because there is already a vendor who is already there, right? What is the, we need to understand a bit more, right? So, as I said, most of the BIRAC projects, that's where we are stuck, right? So, I mean, probably if I get more details about the product, I'll be able to respond.
Probably if you can say some few time, your free time, either we visit or you can visit our department or campus, so that such kind of innovations are there across the department.
Sure, Manjunath, we'll be happy to do that. I'll be very, very
so
happy.
that you can have a look at it and you can help our students as faculty.
Sure. Sir, you are VTU affiliated or you are an independent?
Yeah, VTU affiliated.
Okay. You are not autonomous yet.
No, not autonomous. Okay. We are planning to next year, but as of now, we are affiliated.
Samit, investments into mutual funds is safe or taking policies in LIC? Depends on your, I'm not an financial consultant, Samit. I only understand startups. Depends on your requirement, right? Policies in LIC is not just for investment, right? It also uses security, etc. Whereas mutual funds may give you much better returns, right? So that's highly subjective, and you should talk to financial consultants to get answer on that, right? Okay. Can we, okay, there is one more question from Veda. How to build trust when starting a new startup or investment, right? So I think, as I said, right, it's simpler. You can't build the trust, right? You should have a great team, you should have a great market, and you should have a good product, right? The trust will come automatically, right? So if you figure out, if you think right and if you execute it right, people will trust you, right? The problem is not about the trust, problem is about how well you are thought through, right? Do you have the right offerings, right? It's nothing personal around there. This one, right? So thinking, I mean, in fact, most of them, what we have observed is most of them make mistake when they pick up the problem, right? If you pick up the right problem, right, or they have the idea, unless if you work with some professionals to fine tune your idea and make sure that that idea becomes scalable and fundable at the idea stage, instead of, I mean, normally what I've seen, especially in the campuses, both from the teachers and students perspective, is they will just, they are too shy to go and talk about their innovation. In the earlier days, they say, let me build the plan, let me get my product ready and then go and talk to people, right? That it doesn't work like this. Talk to experts to know whether what you are building is reasonably good enough for you to raise capital, how large it can get to, right? Talk to the right investors. Unfortunately, in India, the problem is there are not many good early stage, very early stage investors. There are not people who understand technology or who wants to sit and understand the technology. That's where we started this fund, right? Because we felt there is a need for a fund which works with the colleges. That's where I created this. But it's very, very important that you go and talk to potential investors at the earliest, right? So, and figure out, is your idea worth building upon, right? Sir, Manjunath sir was asking me a question. The challenge that we see is lot of ideas in the campuses, right? If I go to 10 colleges, at least 60% of the ideas are common across the colleges, right? Because uh, the source of problems will be one and the same, etc., right? So if there are 10 others who are working on the same product, there is no, I mean, at least from the fundability perspective, it becomes very, very challenging. So my suggestion is to build the trust, go and talk to people, go and spend, uh, go and talk to investors, right? Normally, I recommend at this stage, talking to investors is better than talking to anyone else, because investors understand the market very, very differently compared to customers or mentors or the business guys. Right. So I want to, I mean, I hope there are no more questions, right? I'll be happy to take it up on my Insta, etc. If, okay, last one, Naitik. If startup fails, when what is the action? We don't take any action, sir. We can't take any actions. As long as entrepreneurs have not committed any fraud, right? As long as we know that they have put in their best efforts, right? They are not done any fraud, investors don't do anything. Investors can't do anything, right? We just need to write off our investment and move on. That's the only thing that we can do, and that's the only thing that we will do, and that's what we should do, right? So that's the answer. So I want to leave three tips here. I mean, I believe there are also students here, so I want to leave these three tips. First, just go and start reading, right? I mean, don't just read on your subject, just don't go and read on your let's say personality development or the business planning, self-help. Also go and read a lot of fiction, read a lot of classics, right? That's the first thing that I suggest you do for becoming better innovators. Second one, for becoming a good entrepreneur, learn local language, learn how to talk to people around you, right? Talk to a security guy out there, talk to your librarian, talk to person who is a chef in the canteen. The most of the great ideas or the new world order comes from these bottom of the pyramid idea. So it's very, very essential for you guys to talk in the local language and go and connect with people on the across the spectrum. Third most important thing, I mean, I'm sure your college will have a lot of clubs, or there are a lot of NGOs working around your college. So it's very, very essential for you to go join one of them and learn how to contribute without expecting too much of things in return, right? When these are the three traits that I normally would encourage you to get to if you want to become a slightly, Veda was talking about trust, right? Get to these three things, you will understand how to build the trust much better than any of the theories, right? So thanks a lot for your time. I'm not sure how much I was able to convey through the online mode. Uh, Best of luck to you guys. And then I personally feel Indian campuses are the best place to find the innovations, and that's where I went and set up the fund. I think lot better things can happen on Indian campuses when the right ecosystem is in place, and when you guys decide to do something when you are still on the campuses, right? With this, let me stop my session.
Thank you, sir. Thank you very much for your wonderful session. Hope we have a good number of innovations across the departments in the campus. And in biotechnology, we have three, four good marketable innovations. Probably down the line, I will talk to you and we'll make some arrangements so that you can visit us and we can sit and we can discuss with the students and the staff members so that we can contribute something to the society with our innovations. And on behalf of Oxford College of Engineering and the Innovation Club and from the Department of Biotechnology and Civil Engineering, I wholeheartedly thank you for sharing your knowledge and in spite of your busy schedule, sharing your time. Your time is more valuable than anybody's because you are nurturing the young minds. So we thank wholeheartedly for your encouraging words and informative talks. Thank you. We're looking forward for face-to-face interaction so that faculty and students will get maximum benefit out of it. Thank you, sir. Thank you very much.
Thanks, Ritan, sir.
And I also extend my thanks to Prabhavati madam because she is VTPC is with us in all our endeavors. Whenever we need some experts in a particular domain, she will select the right persons. I hope you are introduced into Oxford in the right time because we are also planning with so many reforming schemes. So probably this investment also will become one such commodity in the reframing schemes. So I thank VTPC also and KSCST for their kind technical support. Thank you, sir. Thank you very much.
Thank you, sir.
A very good morning to one and all present here. Welcome to Day 5, Session 9 of Know Your Intellectual Property, Series 2. On behalf of the President of Children's Education Society and Chairman of Oxford Educational Institutions, Management, Principal, staff and students of the Oxford College of Engineering, I extend a very warm and hearty welcome to our guest and resource person, Dr. T. Pawan Kumar, who will be taking us through a session on Essential of Patents. I would like to extend a very warm and hearty welcome to our principal, Dr. N. Kannan, in his absence. I would also like to welcome our HOD, Dr. B.K. Manjunath sir. I would now request Ms. Bhavishya to introduce our resource person for today.
Dr. T. Pawan Kumar, currently working as Senior Scientist in Department of R&D Planning and Business Development at CSIR, Institute of Minerals and Materials Technology, Bhubaneswar, India. He obtained his BSc Chemistry in 2002 with College First and MSc Organic Chemistry in 2004 from Osmania University, Hyderabad, and secured University First with 4 gold medals. He pursued his PhD work in chemistry at CSIR IICT as CSIR JRF SRF and received PhD degree from Osmania University, Hyderabad in 2011. He holds PhD PL Patents Law from NAL SAR Hyderabad and several certifications from WIPO. His research interests include organic chemistry, asymmetric synthesis, process chemistry, green chemistry, etc. He has vast experience in intellectual property and has about 18 patents to his credit. His present research work is focused on small molecule chemistry with biology interface, and his core functioning is in the areas of intellectual property and technology management in business development. I request you, sir, to take over the session now.
So thank you very much for the detailed introduction. And
I really appreciate the efforts taken by Oxford College of Engineering for organizing such a wonderful faculty development program or the training program on this IPR. I know it started on 24th of this month, and it is running very well. I could attend some of the sessions, and I hope all the participants are getting some new inputs through this program. So with this brief introduction, once again, I wish to convey my sincere appreciations to Dr. Manjunath and also Dr. Salma in being instrumental in the design as well as the smooth running of this workshop. So maybe I'll switch off my screen to avoid any sort of technical glitch. As I told, it is raining here today. Meanwhile, if by any reason, if I go out of this meeting, I'm sure that I'll join you back in a minute, not more than that. Okay. So please stay tuned. I'm just sharing my screen. Hope the screen is visible. Is the screen visible?
Yes, sir.
Okay. So I'll be talking to you on essentials of patents. I think by now you all would have got a decent understanding on what is called IP, what are patents, what are the different types of factors that help us in obtaining patents. And here I'll be talking to you on essentials, mainly the structure, the significance, and also the kind of claims that are allowed so that we can convert our research works into patentable outcomes. Just to start with, this month is declared as National IP Festival by Government of India. In addition to the sensitization activities through workshops, seminars, and programs, we have initiated a CSR IP Rath in line to Puri Rath Yatra. And for 15 days, this Rath is going around different parts of Odisha, mainly covering about 100 kilometers distance of Bhubaneswar. And this will go till 31st of this month. I just thought of introducing this program that we have initiated. And looking into the patents, by now we all would have realized that a patent is nothing but a contract between the government and the inventor. You develop a research work and you file a patent application to the patent office. If it gets granted, you'll get the rights. Those rights are called as patent rights. And these rights are generally also referred as negative rights, because the right given by the law to the inventor is to stop others. So therefore, the government gives the inventor the right to exclude or stop others from making, using, or selling the invention for 20 years. And in simple terms, we can also refer a patent as a techno-legal document. Technical part will be there as well as legal component will be there. It is through this legal component we get the rights for the works we develop. Believe me, patents or intellectual property practices or any other kinds of IPs, whatever we are discussing for last few days, these are not the very recent practices. There is a reference of practice of IP in ancient Greeks somewhere in 500 BC itself. They used to grant protection to the inventors. The first recorded evidence of patent law is from Venetian Republic in 1474. So these are one of the age-old practices. Here is the history of patents. Early 1200s, there is a reference of 10 years monopolies granted in Italy. And then first recorded patent of UK came in the year 1449. First American patent came in 1790. In 1883, there was a Paris Convention, which is referred as the first international treaty or international convention for the IPRs. And only in 1970, we could get a patent act. Whenever we talk about patents, always it is referred as Indian Patent Act 1970. Of course, since then there were many amendments. And the recent amendment was in September 2021, through which all the academic institutions were made 80% subsidy related to the fees for patents. So, yes. So here is how a patent structure look like. If you, I don't know how many of you have seen the patent. If you have already referred, you would understand it easily. Otherwise also, you please try to get a patent sometime today, tomorrow. Look into the entire document. Irrespective of the number of pages goes into a patent document, this is the structure. The first page is always called as bibliographic data, then comes the drawings, then comes the description, and the last part is claims. In bibliographic data, you will find title, some numbers, dates, names, class codes, abstract, citations, all other related information. In the description, again you have several fields like field of invention, background, summary, description of the drawings, and detailed description. So description part is almost all equivalent to a manuscript that we make for a publication. Then the claims, and it is through claims we get our rights. So these are the legal parts or legal components of a patent document. I have seen a patent document with about more than 890 pages. Even then, it consists of these 4 parts. And this is how we can divide. The first 3 parts are also referred as disclosure, which are useful for the public. But for you, as an inventor, it is the claim or claims which are more and more important, because you can enjoy the rights through the claims. So therefore, we need to be careful. Here is the structure of the first page, which is referred as bibliographic data. You can find name, numbers, titles, dates, abstract, all those. This is PCT and this is American patent application. From here, I'll be showing you the different pages of a patent document. It is the front page, as I mentioned, bibliographic data, title, name of a company, class codes, drawings, abstract, patent numbers, dates, all are there. Then field of the invention, prior art, summary, description of the drawings, detailed description of the invention. When we talk about detailed description of the invention, it will also include all the experimentation, methods, materials, supporting information like spectral information, analytical information, all those kind of informations has to be given under detailed description. In the drawings, this is how one has to make the drawing in a patent. There should be a line drawing only. Different parts need to be referred by numbers. No text should go in the drawing. And another example, patent number, title, inventor names, company name, application number, filing date, publication number, abstract, class codes, and field of the invention, then drawings, prior art, detailed description, description of the drawings, and finally the claims. So always remember one thing, that it is the claim which appears at the end of the patent document, and it is through these claims we get our rights. Now let us quickly talk about 3 codes. One is patent kind code, second one is country code, and the other one is classification code. These 3 codes will help us in knowing the status or stage of the patent application, the country from which it belongs, and the technological area or the subject or the domain which the patent talks about. So here is the kind code. You might have seen in earlier examples also. In those, in one of the patent, the code was B1 or B2. The other one was A1 or A2. So whenever you find code with A1, A2, A3, whatever may be, along with the patent number, then that is only an application. Application is not a patent. Application is just an application that you have submitted to the patent office. When you find B along with the number, when I say B, it can be B, B1, B2, B3. then it is called as patent. So whenever we refer patents, that means they are the granted applications. Only granted applications are called as patents. If they are not granted, you will not find B. Then they are not called as patents. If you find E, especially in case of American patents, they are reissued patents. If you find D, they are design patents. The concept of design patent is only there in America, not in India. In India, we call them as industrial designs. And here is about the patent classification codes. These are the 4 major classification codes. American classification, you can find only in American patents. Japanese classification, you can find only in Japanese patents. But apart from these two, there is European classification system and international patent classification system. European classification system also appears only in the patents arising from Europe, but WIPO, or the International Patent Classification System, which is also in short called as IPC. IPC. This kind of coding system will be present on the patents of any country, whichever is practicing patent system. Indian patents you can find IPC, American patents you can find every country patents. They will definitely include international patent classification codes. And then comes patent country code. We all need to remember that there are several fields in the patent database which use WIPO standard 2-letter codes to represent the country names. To make the retrieval process easy, these 2-letter codes will help us a lot. Here are the examples. US is for US, GB is for Britain, F for France, C in China. If you want to more about this, look at the country. Tunisia, Ukraine, Uzbekistan, Vietnam, South Africa, Grenada, Egypt, Algeria, Cuba, Colombia, China, Sri Lanka, Morocco, Madagascar, Mexico, Mongolia, India, Israel, Indonesia, Hungary, Croatia. So all they generally use 2-letter country codes. And then now let us look into a bit more about what is called this international patent classification. Please read the description present here. Largest set of symbols, very efficient tool for conducting the patent search, retrieving the different patent information. Why it is so important is, it is language independent, terminology independent, and is applied as a standardized field to all the documents. So therefore, even if you don't know Chinese, if you don't know Japanese, if you don't know other languages, you can retrieve the patents of your subject of interest by using this international patent classification code. And as I mentioned, to determine the status of your invention, to know whether something is already known or not, to what extent you can make an impact, all these would be ascertained only by conducting patent search and analysis. And to do it efficiently, IPC helps us a lot. Here is the structure. All the fields that are available are divided into 8 sections. You can refer the different names for each section. And each section again subdivided into several groups or subgroups. Even each section is divided into class, again subclass, then groups, within that subgroups. There are about 12 levels of hierarchy. Section is the highest. Section to the 12th level of hierarchy it is there. The benefit of different levels of hierarchy of this international patent classification while conducting the search is mentioned on the left hand side. If you use this code with the main group, so you may get around 34,000 patents. Analyzing 34,000 patents is not an easy task. A very laborious, time consuming, lengthy activity. But If you can go down, if you can narrow down your search elements, and if you use this, see this one, you can end up with 607 relevant results. If you further narrow down, if there is a scope for you to narrow down further, to do this, which is more specific, more matching to your area, then you may get only 98 documents. So now you must understand, you must have understood that with the relevancy of the IPC code, you can restrict the number of documents that you retrieve while you conduct the search. Analyzing 38 documents is quite easy. Then analyzing 600 documents. 600 is more and more easy than 34,000. So therefore, this is the significance of having intellectual property international patent classification course on the practices of patents. From here, very quickly, I will show you the front pages of some patents from different countries. Try to identify the class code and the country code, as well as the international classification codes. Kind code, country code, and class code. These three one need to identify. See here, this is JP, Japan, B2, granted patent, and these are the international classification codes. Okay, and this one, Australian patent, B2 is a kind code, and here are the international IPC, international patent classification codes. Slovakian Republic, SK is there. A3, again it is an application, and these are the classification codes. This is from Taiwan, A, application, and here are the classification codes. Portuguese, then E, it's a reissued patent, and classification codes. Russia, application, A is application, and here is the classification code, international classification code. And another example from Korea, KR, Korea, A means application, and then these are the international classification codes. Here, Norway, but it has got a special kind of coding system. They refer it as L. I don't know what exactly L about. Maybe this is one of the oldest patent. Just to make sure that you also find some kind of exceptions in the practices. And NO is Norway, country code. And here is GB from Great Britain. A is application. And these are the international classification codes. And this is our own patent. You can find my name here. This is our own patent. This is again Poland. B1 granted patent. And this is international classification system. So therefore, we all know that whenever we take up any literature search activity, always we confine our search only to scientific publications, and there is a huge amount of patenting activity which is already present with us but being untouched. So we are not doing this, or slightly doing this, but majorly we do this. But believe me, while you conduct the patent search, you should also do a patent search. While you conduct the publication search, you should also do a patent search. Why? The reason is like this. Prior art is global. Prior art is global. Patent rights are territorial. If you are planning some new work, who knows? A similar kind of work would have been already practiced somewhere else. May not be in your country, but some other country. So believe me, If some work is already known in any part of the globe, you will not get a patent. And if you have patent rights in India, you can enjoy the rights only in India, but not in other countries. Science is global, technology is local. To make the technologies for our benefit, for our convenience, then we need to look into the patents. And again, patent search has got several types depending upon the kind of requirement, kind of necessity, kind of practice that you are looking for. You might conduct an invalidation search, patentability or novelty search, freedom to operate search, ideation search, and landscape search. These are some examples of the free databases. All country-specific databases are free, and these are the examples of free databases which do got global coverage. Google Patents, WIPO Patent Scope, eSpaceNet, Lens.org likewise. And these are some examples of the paid databases through which you can retrieve the patent information. But the difference between paid and free databases are, paid databases are like supermarkets where they are very exhaustive, information available is ready-made, very handy. In the free databases also, you can get all these kind of information, but however, they are like local markets. You need to identify, you need to put efforts to collect, to compile, to see them in proper order. From here, I will be quickly showing you the websites of different countries' patent or IPR offices. This is the Indian Patent Office website. Of course, it deals with patents, designs, trademarks, and geographical indications. And there are several fields that are available. You can try to explore the database to get more inputs. And this is about Canadian Patent Office or IP Office database. You can again further explore the IP information related to Canada. This is about Korean Patent Office database. They also mention about different activities, their guidelines, some reference materials, some tools, some kits. Yes, every country has some or other means of educating or popularizing IP for their citizens as well as for others. Chinese patent database, you can refer for IPs on China, IPs from China. Japanese Patent Office database, JPO, and you can refer the country specific information related to the Japanese practices. This is European Patent Office database. European Patent Office is a regional office. When we say European patent, it is applicable to the entire European Union. But however, in every country, again, you need to pursue. This is one of the exhaustive database which is freely available. It has got a coverage of about 80 or 90 countries. So you can, from this single web page, you can retrieve patent information related to more than 70-80 countries. This is American Patent Office database. They do have several information available in their database at free of cost. We can refer them, we can download them, we can read them for our benefit. And this is World Intellectual Property Office database, WIPO. Even WIPO has got a patent search database in the form of WIPO Patent Scope. It has got again a decent coverage of about 70 to 80 countries. Both eSpaceNet and WIPO Patent Scope are equally efficient. You can use any of these two while conducting the patent search. Both are available for free. You can also use Google Patents, you can also use Lens.org, or you can also conduct search by individual country-specific databases. From here, let us look into the structure of the claims, which are very, very important as we plan for filing patents. Filing is a formality which needs to be fulfilled with all the documents, the forms, and the fees. But however, it is drafting of the application or drafting of the document which is more important, and more specifically, drafting of the claims, because it is through claims you will get the rights. Without claim, a patent is not called as a patent. Otherwise, it is anything like another report or an article. It is because of the claims the document is called as a patent. It is through claims you get the rights. These are the different kinds of claims that are possible. Product claims if you develop a product. Process claims if you develop a process. Marquis claims mainly useful for the people of chemistry, mainly the organic chemistry people or medicinal chemistry people. Jepson claims whenever you develop an improved version of existing invention, then you may have to refer the existing invention. So therefore, where there is an acknowledgement for the existing invention, those kind of claims are called as Jepson claims. And then comes Swiss claims. Swiss claims are also called as second or further medical use claims. And generally, these are the major types of claims that are available. One need to understand. But however, in India or Indian Patent Act do not allow all these kind of claims to be practiced or to be granted. Every country has got their own guidelines, right? Their own acts. So therefore, according to the Indian Patent Act 1970, these are the claims which are allowed in India. Product claims are allowed. Process claims are also allowed. Composition or formulation claims are also allowed. But method of treatment not allowed. Living organisms not allowed. And new physical forms provided if they show enhanced therapeutic efficacy, they can be allowed. If they do not show enhanced therapeutic efficacy, they are not allowed. If you ask me why not allowed, the answer is quite simple. Our patent law do not allow these things. But American systems might allow. Some other countries' systems might allow. But our systems, our law do not allow. These are the different kinds of patent applications one can file with the patent office. Provisional is something which is used to retain the priority. Whenever you feel that your work is not fully done, but however, you might have a threat, you might have a competition from others. In that case, you can go for filing provisional. It is referred as advance reservation with no confirmation. If you file provisional, within 12 months, you need to file a complete or a full or a traditional or a regular application. When I say complete, full, traditional, regular, they are one and the same. And there are also applications called as divisional applications, patents of additions. If you include more than one invention in a single patent, then patent office will ask you to divide and file them separately. The reason being, one patent for one invention. This is the rule. One patent for one invention. Not that one patent for more than one invention. No. Each patent application should have only one invention to be mentioned about. If you mention more than one, they will ask you to divide and file. Such kind of division is called as divisional patent application. And patent of addition, the title itself reflects the significance. If you have a granted patent, if you develop a new work which can be added to the existing patent, you can do it by way of patent of addition. You can do it by patent of addition. You can do by patent of addition. And then comes international application. If you wish to file patents in more than one country apart from India, you can file an international application. It is through this you can get the priority of filing in other countries. So such kind of route is called as international application or international route or even PCT route. It is also referred as PCT route, Patent Cooperation Treaty route. It is not that whatever invention you develop, you will get a patent. Your invention must satisfy the patentability criteria, and the criteria is referred as Nunn's test. Novelty, utility, non-obviousness, and statutes of the nation. Novelty is it must be new. Non-obviousness means it must have got some or other inventiveness. And utility means we all know it must have got some use. So novelty, utility are very easy to satisfy, but satisfying non-obviousness is not that easy in comparison to novelty and utility. So therefore one need to be little careful enough while addressing the non-obviousness criteria. Then comes the fourth one, which is statutes of the nation. Every country has got their own patent law, and there are certain limitations. In India, any invention or any example falling under Section 3 and Section 4 of Indian Patent Act 1970, in spite of having novelty, utility, and inventiveness, it is not patentable, because our patent law do not allow these kind of inventions to be patentable. And you all must also remember that whenever you are planning to file a patent for the work which you are planning, it should not be disclosed anywhere before the filing of patent application with patent office. Before filing the application, if you disclose, that is no more a new thing. Novelty criteria is not satisfied. When novelty criteria is not satisfied, you need not worry about other criteria. So therefore, one need to be careful enough. Please don't publish or document your works which you are planning to file patents in any of these journals, proceedings, theses, reports, encyclopedias, posters, books, abstracts, presentations. You should not do. If you do, it is not a new thing then. From here, I'll be talking to you on some of the research works from my own area, our own contributions, wherein we could convert them into patentable as well as, to some extent, profitable outcomes. Okay? Look at the kind of diversity of our research through which we could obtain some patents. I think the slides are very self-explanatory. Being an organic chemist, we always try to design and develop new molecules for various applications. When we started realizing the value of IP, for us, it has become very easy or quite easy to develop or to design and develop molecules for biological applications. That is where we could collaborate with biology teams. In many of the cases, we will develop molecules, they will conduct biology. If everything is good, if there is some potential, we always try to file patents. With this approach, as on today, we have filed about 43 patent applications, out of which 27 are already granted in different countries. About 16, 17 are in pipeline. These are some of those works. And the structures I am representing here, maybe ring A, ring B, ring A, ring B of this structure, the entire structure, they are referred as marker structures. Marker structure is a generic structure which can represent a large number of specific structures. And marker structure is allowed in the patents in the form of a Marquess claim. These are the front pages of PCT applications for the works that I just referred. You can find my name there. You can also find other details as we discussed in bibliographic information. These are few more works. Nimbolite is a natural product. We designed several analogs around this natural product. Biology was very good towards anti-cancer properties. We could file patents. Another work on process development for the nicotine. And this is the work for which we initially thought of filing patents. Otherwise, before this work, we were not having the practice of filing patents. When we thought of filing, somehow we could not dare to make a PCT application, but however, we could file in India first in 2015, and then we filed in US as well as UK. We filed 2 patents in US, 1 in UK, 1 in India. And very luckily, we were very fortunate enough that these 4 patents, as filed or as granted, were licensed to Sun Pharma in 2019. So 2015 we filed. By 2019, we could license these 4 patents to Sun Pharma, wherein IICT, at the time I was at IICT Hyderabad, IICT could receive about 5 crores as first premium royalty. If everything goes well, you might have noticed by now, the projected score is about 240 crores for the institute. I don't know whether we can really attract 240 crores or not, but 5 crores have already been attracted. This itself is a direct attestation that the IP is more important. Doing patents are more important. Because this is a patented work, we could license and we could get some money. If it is not being a patented work, even if it is published in Nature, Science or very high impact journals, we could not have realized any monies, because through publication, anyone can see, anyone can practice, anyone can get profits. They need not necessarily involve you or even inform you, because publications are an open domain source. When you publish something, you do not have any rights there. So that is the difference of having a patent, not having a patent. These are the front pages of American granted patents from our works that I just described. Here is at another work, which is alpha lipoic acid, a very small molecule in structure, but it has got large number of applications. It is found as a nutrition supplement, as a cofactor in many enzymes, and it is also an approved drug molecule for treating some kind of diabetes. And luckily, when we conducted the patent search, we found that in India it is not being manufactured. We are importing 96% from China, 4% from US. Then we thought we should definitely pursue this. We started filing patents, and but we thought to file patents only in India, because there is a scope for market in India. In all other countries, they were already either practicing or they have some patents. So therefore, now patent is ready, and we have also parallelly developed a continuous method. Initially, being an organic chemist, we could only develop organic chemistry team. We could only develop a batch process, but we could also consult our engineering team and then develop a continuous flow method. We have 2 methods available. For this technology. We are in the process of commercialization. Hopefully, if everything goes well, some companies, maybe from Bengaluru or from Hyderabad or from Mumbai, might take this patent. If it happens, this would be a second example which can be directly attested for the practice of integrating patents with our research. Here is the patent for lipoic acid that we filed in India. Why patents are important? Just to refresh again, 80% of the technical information will appear only in the form of patents. There are about 150 million patents worldwide. Every year, there are about 4 lakh new inventions being added to the existing library. 4 lakh new inventions. And luckily, all these patent documents are copyright free. You can practice them, you can protect them, you can copy them, you can Xerox them, you can use them, provided if you're not using for commercial benefit. For any kind of non-commercial activities, without taking permission from the owner, you can use the patents. This is the power of patents. Now, knowingly or unknowingly, we all are into this kind of transition. We have the practice of making publications, but nowadays everyone is talking about patents, IPs, even government. Yes or no? So therefore, whenever you feel that you are in such a state of transition, always try to take an IP first, followed by publication. By doing so, you can get both patents as well as publications for the same work. It is like 1+1 offer, provided if you take a patent first. And there would be a decent scope for its commercial exploitation. This is the advantage of having patents. Here we propose a very simple strategy. By now, maybe Oxford College of Engineering might already be practicing this. Anyway, maybe for the benefit of others or as a recollection of our own practice, I thought of showing this strategy. Whenever you develop a new work, before publishing, try to screen it for possible patenting. If you find scope, take a patent first, then go for publication. By adopting this simple practice, we can contribute more towards IP, and there would be higher chances of their exploitation. Now, from here, I will try to summarize the essence of having an IPR and also the purpose of conducting these kind of sessions. We all know that we are in a competitive world. Whether we admit or not, it is true. This would be the scenario if we do not have IP assets. Big will eat small, small will eat further small, and being small is so dangerous. Being small is so dangerous. So therefore, you need to be very careful if you are small without IP. If you have IP assets, whatever small you may be, you can resist, you can stop, you can retain, you can rise, you can stand on your own. The advantages that big companies gets when there is no IP with a small company is not the way when small companies have IPs. So therefore, IP is very, very important. With this cartoon, I would like to convey the entire essence of intellectual property rights. If you try to recollect the definition given by WIPO, it says creations of the mind. So creations of the mind. IP rights are the rights given provided if you protect your creations. So once you protect your creations through IP, you get the IP rights. Why? To stop others. If someone tries to exploit, you can stop them. You have the right to stop them for those limited number of years. This is the entire purpose of intellectual property rights. Innovation is a key player for generating more and more IPs. That is how our new slogan is Jai Jawan, Jai Kisan, Jai Vigyan, and Jai Anusandhan. Anusandhan is all about innovation. Without innovation, we cannot make a decent progress. When I say we as a nation, maybe we as an individuals, we at large as a globe. So we need innovations across. But again to mention, whether we admit or not, this has been the main orientation of our research. Yes or no? It has been towards making impact factor publication first. Good. We need to do this. We need to encourage. We need to practice. But at the same time, if we only do this by not realizing the other practices, then maybe we may not be really competitive enough in this era. So therefore, we also need to be reoriented towards India first, innovation first, and IP first. Whatever activity we take up, it should add value to our country. Wherever, whatever research works or whatever works we carry out, we should include one or other innovativeness, some or other innovative concept. And wherever there is a scope, there is a possibility, we should take an IP first. By doing these three practices, along with the existing practice of making publications, certainly we can do great, we can do wonders. We need to take up this with great spirit. And the message is, knowing is not enough, we must apply. Willing is not enough, we must do. It is through doing we can achieve something different. Only by saying, only by feeling, we may not get anything. Just by doing, we can achieve anything, whatever we wish. So, therefore, we all need to be a doer than just only a thinker. There is a research inspiration, Professor Robert Langer, 1500 papers, more than 800 patents. His patents were licensed to more than 250 companies. He himself has started about 25-30 companies. Now you tell me, whether he is a man or machine. In India, generally, machines can only do. We cannot even imagine that a man can do this. Yes, of course, that is also true. As an individual, he may not have done all these things, but as a team, as a successful team, they could achieve it. So, therefore, working in teams is more and more important. And these lines by Swami Vivekananda appear to be very much correct for us to be reoriented to the practices. So, therefore, we need to look into converting our knowledge into useful applications for making revenues, for generating profits. If we can do this, certainly we can add more and more value to our contributions. So with this, I just stop here. Thank you all. This is our institute located at Bhubaneswar, Institute of Minerals and Materials Technology. I just stop here. If you have any queries, we can take them up.
Thank you, sir. Dear participants, the forum is open for any queries.
Yes, please. Yes, if there is a patent valid in every country. No, patent practices are there in every country, but if your patent is granted in other countries, yes, they are valid. But with one application in India, you cannot get validity in other countries. You need to file patents in individual countries separately. It is necessary to create a prototype before applying for a patent. Yes, generally yes, because you need to have a working model. Otherwise, how do you say that you have a solution to address a problem, or you have a invention or innovation which is performing good? Utility you need to show. Unless and otherwise you develop a prototype, you cannot show the utility. So therefore, prototype is a minimum requirement. Is there any additional requirements for filing of patent application in respect of microbiological invention? Yes, any kind of biological inventions, they need to also satisfy the guidelines stated by Biodiversity Act 2002. So you need to go through Biodiversity Act. What are the stages for an inventor to acquire a patent under FDI? No, I am not into those pharmaceutical aspects directly, because unless you deal with a industry where you are involved in their IP strategies, it may not be that easy for to comment on this query. So therefore, maybe I'll also think it. If I get an answer, I'll definitely convey it to you. How long is a patent valid in India? It is valid for 20 years, provided if it gets granted. And 20 years is a standard time period in any country, not only India. Okay. Do I need a patent to sell the product? No, not necessarily. Without a patent also you can start selling the product, provided if you have freedom to operate. But if you have a patent, you can stop parallel practicing. Okay. By your product in the market which you sold, people may copy it, people may fine tune it, people may replicate it and bring the same product on their brand. Certainly you might face more complexities. So therefore, if you have a patent, you will have the monopoly, you will have the rights to stop others. So that is how it is always better to make the patent. How to carry out importing of living modified organisms from foreign country? Again, there are several guidelines on import and export rules by Ministry of External Affairs. You need to follow those guidelines. If they allow, you can import. If they do not allow, you cannot do anything. This is, as of now, this is my answer. Can I obtain a patent for a software related inventions? Very good query. Softwares as such are not patentable in India. But however, if you integrate a software with the hardware, certainly you can get a patent. But not just for the software as such. Hope I have answered. I'm very happy to see a good number of queries coming in the chat box. Further, if you have any queries, you can put them in the chat box, or if you can unmute yourself, you can also raise that query. Maybe we can spend some more time if there are any further queries. How to stop copiers while patent pending? How does it matter? Even if someone copies while your patent is pending, you should send a communication to them that my patent is already been filed, it has been published, or it is being in pending. So your work is a proper match to my work. There are a lot of similarities which match both the works. So therefore, be careful. If something happens to a level of commercial exploitation, then I might go for legal challenges. That you can tell. Or is at a softer note, you can tell them that We have patents for this similar kind of inventions. They are about to be granted. So please don't work on them. Otherwise, come to a compromise where we make a dealing and both can be benefited. So there are several options. Any other query, please? Any other queries? Can I obtain a patent and keep my invention secret? No. Both are different IPs. Once you obtain a patent, it is not a secret at all. It is disclosed in the patent. Your patent can be seen by all throughout the world. People can see it, people can read it, people can analyze it. So then how can you keep it as a secret? Not possible. Even if you wish, it is not possible. And there is another query. Does patent of addition require separate renewal fees? It only requires some fees while adding, but renewal fees is not required. Once it gets added to the existing patent, it goes with the fees of the existing patent. To my knowledge, renewal fees is not required for renewing the patent of addition. Hope I have answered both of your queries.
Sir, can you highlight something on second use of the known compound?
Yes, very good. Second use of the known compound. See, we all have faced COVID situation, right? There was no direct treatment available for the COVID, but then thanks to many of our researchers, mainly the researchers from chemistry and biology interface, they could find or they could repurpose the drugs like favipiravir, remdesivir, and others. Remdesivir and favipiravir were already known for some other applications. They were already patented products. But when the scientific community started reinventing of these drugs or repurposing of these drugs for COVID, many companies started getting voluntary license. Because they had patents in those respective countries, they got the license. Even in India, they filed patents. If you go through the first examination report of remdesivir, initially there were many objections, but later on they could able to defend, they could able to prove that yes, they have added some new component in it so as to make it more feasible. Maybe in the form of a composition they would have brought. Likewise, the patent has been granted. If you take the example of favipiravir, there is no patent because favipiravir is already known for some other disease, some other treatment. Now we are using favipiravir for COVID treatment. COVID treatment is a second application for favipiravir, second or maybe more than second. Such kind of patents are not allowed in India. A similar kind of patent practice is allowed in the countries like US. They allow second and further medical use patents, but India do not allow second or further medical use patents. Otherwise, during the times of COVID, we would have seen some thousands of patents coming from pharma industry or chemical industry. It did not happen. The reason being, India do not allow second and further medical use. Hope I have answered. There is another query. If I obtain a patent for my invention, does this mean I am free to use the invention commercially? Yes, you are free to use it, but before you bring it to the market, you also need to have freedom of operation. So you need to conduct a freedom to operation search. If you have the freedom, you can definitely bring it to the market. If you do not have the freedom, even in spite of having patents, you cannot bring your product into the market. Having patent is one aspect, having freedom of practice is another aspect. Both need to be looked into. And to ascertain that, you can conduct a freedom to operate search. You can look about what are the different players which are already there in the market, whether they are practicing that in the market or not. If they stopped, when did they stop? Is their patent still valid? what are their claims. All these matters you need to look into carefully to establish your freedom of operation in the market. Getting patent do not guarantee you taking your product to the market. This is a summary. Hope you got the answer. So any others?
Manjunath sir, would you like to add something there, sir?
Thank you, sir. Thank you, Pawan sir, for your kind cooperation and for sharing your knowledge with us. When we approached you, you are kind enough to accept to collaborate with us for this 1 week FDPM workshop on intellectual property right. We are thankful for you and your organization for supporting us. On behalf of the Oxford College of Engineering and Department of Biotechnology, KSCST, VTPC, and from myself and from all the participants, we thank you for helping us and collaborating us with the technical things. And thank you to Lipika madam and for you also for collaborating and making this event a grand success. Thank you, sir. Thank you very much.
Thank you, Manjunath. Thank you very much. Thank you, Dr. Salma, and I wish you all the very best. We hope to see some more programs coming in joint manner in the days or years to come at least. And to all the participants, I once again wish you the very best and hope to see some productive patentable outcomes in near future. Thank you.
Definitely, sir. We can technically collaborate also. We are also working on some natural compounds.
Oh.
I'll be in touch with you.
Sure, then I think our fields are very much matching.
Yes.
So definitely we look forward for working together.
Definitely, sir.
So because working together will bring more contributions than working in isolation.
Yes, sir. Yes.
So definitely we'll be happy to collaborate.
Definitely, sir.
We can also have an MOU between both organizations if you wish. So because MOU goes through my office only at IMMT.
Fine.
So we can have a MOU and we can take it forward, not any.
Yeah, immediately we'll make that, sir. Because we, as I discussed, we have some 3 compounds for which second use of thing are in.
Yes.
So we can discuss and we can finalize that.
Yes. Yeah, that can be with some possible means that can be converted into a composition. Then through that route we can pursue it.
Definitely, sir. Definitely. Thank you very much, sir. Once again.
Thank you. Thank you very much.
Right, sir. Right, sir.
Thank you so much, sir. Now I would like to call Ms. Kavya to propose the vote of thanks.
Greetings to everyone present here, including our distinguished guest, Dr. T. Pawan Kumar, and all the participants. I extend my sincere thanks to our honored guest, Dr. T. Pawan Kumar, for taking time from his busy schedule to grace the occasion and for sharing his expertise on essential of patents, their structure and significance. Your words of inspiration and encouragement are greatly appreciated, sir. My gratitude also goes to Dr. Manjunath PK, Head of Biotechnology Department, for his efforts in organizing this event. I must also acknowledge the organizing team and volunteers for their hard work in the lead up to this workshop. I extend my deep sense of appreciation to all the faculties, students, and workshop participants for their active involvement. Thank you once again to everyone for making this event a great success. Thank you.